Good morning, everyone.
The Starburst, and it ended up in about 4 big bags. One of them got aggressive.
Welcome everybody who's here in person and also on Zoom to Section 2 Small, exploring the new constitutional limits on trademark law. Elster oral argument happened just this week, as you all know, on the rejected Trump 2 Small trademark application, and this is going to be the fourth time in the last few years that the Supreme Court has looked at a direct or an indirect constitutional challenge to the Lanham Act. Hi, Ashley. We had Tam and Brunetti and VIP Products and Elster, and it looks like the first panel is going to start out the day with some Jack Daniels, which sounds like a very interesting way to begin our conference. I started working on this topic a little over 12 years ago when John Cross at Louisville took Doris Long, John Marshall and I out to try some Kentucky bourbon. And he said, I'm going to organize a symposium for the 65th anniversary of the Lanham Act. And I'd like some scholars to think about what portions might be retired or, might be revised, expanded, and will you do it? And it was that evening really that started me on this path to considering the role of morality and scandalousness and disparagement in the context of trademark law, and to ask myself, if trademark law is about consumer protection, what kind of protection are we talking about? As my own work in this space has evolved, often through presentations that I give with John Sommer, attorney for Eric Brunetti, we've explored more of the social justice ramifications of Supreme Court decisions and thinking about things like Eskimo pie and Junipero Serra. But most recently, I dove back into this topic for a handbook on fashion law that Irene Calboli and Eleonora Rosati are putting together, which was really fun. Marks that are viewed as kind of edgy or profane are not just part of streetwear and skatewear culture, as it was in Brunetti, but social movements in the United States throughout history have used branding and fashion as signs and symbols to identify their movement or make a statement. From the suffragettes, which had sort of two camps that identified themselves differently as signs and symbols through clothing, to Black Panthers or the second wave feminist women's movement, miniskirts of women's liberation. Elements of fashion have used branding tools for identification, promotion, and subversion of the status quo and messaging. And the use of profanity in branding, which proliferated on the red carpets and stretched certainly to mainstream fashion. I think there's sort of a launching year in 2016. Before these cases, has been seen as a way by brands to kind of cut through the noise and connect and develop goodwill in a way that behavioral research will show is perceived as authentic and raw. And if I may say it, not bullshit. We're not just going to say, let's fight cancer anymore, but we will say, fuck cancer or COVID or diabetes or any one of a number of diseases that we want to tackle. So after Tam and Brunetti, what has happened? Justice Sotomayor, it seemed like in the Brunetti opinion, there weren't just there were so many opinions. Everybody didn't agree on everything, but it seemed like everyone agreed that that the statute was unappealing as it stood. Justice Sotomayor predicted that we would see this rush to register and the government's powerlessness to say no. And indeed, we have seen a proliferation of applications to register marks with George Carlin's 7 famous dirty words. But for the most part, those marks are not being registered. Trademark applications for those words had increased dramatically in both absolute and year-over-year numbers since the year 2000. And then the year that Brunetti was decided, those applications went up over 62%. So yes, she was correct. But where she was incorrect, though, was in her prediction that the government would be powerless to stop the registration of this flood of offensive marks. And in reality, registration of scandalous or immoral marks or marks that disparage remains low. They're still rejected, but they're rejected just for different reasons. And the registration numbers for those types of marks are much lower than the general registration numbers. And when you think about kind of clothing and fashion, that's been the industry that's most affected by that trend. When it comes to applications for trademark registration, more offensive trademarks appear in the fashion industry than in any other space by, I think, an X of 5. And the marks are now being refused, most commonly on the basis that they are commonplace words or merely ornamental. And there's a lot certainly to unpack here that I won't go into now. But with the arguments in Elster that took place this week, it's an ideal time to consider the two main questions that we're going to look at today. One, which parts of the Lanham Act are going to survive this era of constitutional challenge to trademark law? And two, what will this flurry of constitutional activity in the space mean for trademark practice and trademark enforcement as we move forward? So today we have 3 extended panels that are going to be discussing, respectively, trademark enforcement, registration, and then more broadly, what's next. We'll be covering a wide and exciting range of subjects that will include an overview of these recent cases and SCOTUS opinions, empirical research into filings of disparaging marks in the wake of Tam and Brunetti, whether tarnishment really occurs in a manner that we can measure, public health concerns, especially in connection with cannabis products and parodies, the Rogers test, which we all love, and its continued viability, the relevance of commercial versus expressive brand usage for constitutional adjudication, proposed alternative frameworks for reconciling First Amendment with trademark law, the interplay of 2A and 2C with failure to function, and what impacts we might see on rights of publicity and privacy and defamation practice. I want to give a huge dollop of thanks to Peter Carol, who is our new faculty director of our IP Center. He organized this conference, he put it together, he brought all of you here today and online, and I have admired his work for a long time as a colleague, and I am so happy to have him as a colleague at UNH Franklin Pierce now. Thank you, Peter, for all you're doing. I also want to thank Chiara Maria, Courtney Thornton, Rachel LaFerge, and Paul Leclerc and CJ Quinn for all of their efforts organizing logistics and including marketing and technology. I was pleased. One of the things Peter and I were talking about yesterday, I was asking him, is there anything that's been keeping you up at night that you're worried about? And he said, you kind of woke up thinking, what if the technology isn't working? And so I was so pleased to walk in and see both our experts, Paul Leclerc and CJ Quinn, kind of coming in from opposite doors, ready to solve any problems that we had. Grateful to our student volunteer, Andres Rodriguez Gomez, for moderating the chat. Our moderators, Sandra Aistar and Ed Timberlake. Our former full-time faculty members, former IP Center Director, Alex Roberts, and now affiliate faculty member. And surprise to me, our former clinic director, Ashlyn Lembry, are both here. And thank you for rejoining us. And I told Alex last night, we might lock the doors and never let you leave. And I want to thank all of our panelists for coming back to Concord and joining us by Zoom. And each of you will be introduced more fully by your moderators as we go forward. Those on Zoom, just a couple of housekeeping, those on Zoom should use the Q&A feature in the webinar to ask questions of the panelists, and then they'll be passed along, time permitting, to the moderator at the conclusion of each panel. And I also want to let you know, as a reminder, that the event is being recorded. Back in 2019, I was interviewed on this topic by Elsa Chang at NPR, which was a really exciting moment for me. I was excited, went to the studio. It's this 45-minute interview. I had all my research and papers, and she kept telling me to stop shuffling my papers. But But at the end, she asked me to read one of, you might remember in the Brunetti case, there was an appendix of, sort of scandalous bad word trademarks, at the end. And she asked me to kind of read a few of those. And so I happily, whatever she asked, I was ready to do. So then my parents, later we sat around the radio waiting for the interview to play like you would, like the 1950s or something. And I thought, my parents, like they're going to read my law review articles, and they're finally thinking like I'm doing something meaningful that is, that isn't so technical and just goes into the ether. And so we're all sitting there, and the only part of the interview that was played on the air was me saying bad words. And I learned that no matter how old I get, I will continue to embarrass my parents over and over in whatever setting. So this will be recorded. Use language at your own discretion. Right now, I'd like to turn it over to our first panel on enforcement, moderated by Sandra Aistar, who is a clinical professor at George Mason, Antonin Scalia School of Law, and leads the law school's arts and entertainment program. Sandra, to you.
So good morning, everybody. I am really glad to be here. Thank you, Peter, for inviting me, and thank you for the kind introduction. As a copyright and entertainment law person, I'm really glad to be here among trademark scholars to discuss issues of trademark fair use and how the law balances the important function of consumer protection against First Amendment rights. And until Wednesday, I thought maybe I'm a fish out of water, but then the first question out of the mouth of Justice Thomas was, what does this all mean for copyright law? So I am here to get that answer as part of what I'm doing here, but hopefully we will get many, many more answers that satisfy all of you more than they satisfy the narrow copyright community interests that somehow came to the fore in that argument, to me, at least unexpectedly. Anyway, we have a really thoughtful and knowledgeable panel to share their insights with us today. And I'm just going to introduce all the panelists first, and then Willajeanne will give us a introduction to some of the cases that are framing our discussion. And then we'll go to each of the panelists for their presentations. And then the folks who are providing questions from online, we'll filter those through Andres, who is here and will direct questions to me. So if you hear one person asking lots of questions, he is indeed brilliant, but also has some other folks who he's channeling. So, in no particular order, Christine H. Farley is a professor of law at American University Washington College of Law and an expert on intellectual property. Her scholarship has been published in books and journals, and she's taught courses and conducted research on information law, contract law, advertising law, and art law. She serves as the co-faculty director of the program on information justice and intellectual property, and she previously served as associate dean for faculty and academic affairs. I could list many more accolades and achievements, but I will let you get to know Christine personally. If anybody, for some reason, doesn't know her. Jake Linford is the Lula Feller and Dan Myers Professor and Associate Dean for Research at Florida State University College of Law. And he focuses his scholarship on trademarks, copyright, and contract law. He teaches trademarks and unfair competition, contracts, copyright, information, privacy, and various IP and tech-related seminars. And his scholarship empirically tests and theoretically reassesses key trademark and copyright doctrines, and has been published in leading law reviews, including the Georgetown Law Journal, Notre Dame Law Review, and Minnesota Law Review. And then Hannah Weiser is an assistant professor of law with Bentley University. And she most recently served as a visiting assistant professor of practice law with Babson College, previously working with Montgomery College for many years. Hannah served as the coordinator and professor of business and management, where she taught a variety of courses, including Introduction to Business and Business Law, while also managing the scheduling, hiring, and training for part-time faculty and leading and developing the business advising program and co-directing the Raptor Tank Business Pitch Competition. She's also the faculty advisor for the Macklin Business Institute Experimental Honors Program. And with her over 10 years of teaching experience and multiple teaching awards, she's also previously taught professional ethics online for the Eisenberg School of Management at the University of Massachusetts, as well as leadership and teamwork courses for the University of Maryland. And then Daniel Cahoy is the Robert G. and Caroline Schwartz Professor and Professor of Business Law and Head of the Risk Management Department at the Pennsylvania State University's Smeal College of Business. Professor Cahoy's research focuses on intellectual property rights and the intersection of business and human rights. He's served as the president of the Academy of Legal Studies in Business and editor-in-chief of the American Business Law Journal. And he was a Fulbright Scholar in International Humanitarian Law at the University of Ottawa School of Law. Professor Cahoy is a registered patent attorney and specialized in complex intellectual property litigation before entering academia. To start us off, we will have Professor Willajeanne McLean, who is Distinguished Professor of Law at UConn Law School. And she has taught trademark law, torts law, and institutions of the European Union, and a seminar in intellectual property law in the EU. She was a Fulbright Fellow at Adam Mickiewicz University in Poznan, Poland, where she taught comparative EU and US intellectual property law and lectured at the Intellectual Property Law Institute at the Jagiellonian University in Krakow. And her recent scholarship focuses on trademark law and the stories trademarks tell about society and who we are. So Professor McLean has been kind enough to offer to frame the discussion for us this morning by offering a description of the salient points to keep in mind about two Supreme Court cases that will likely come up throughout the course of our conversation today. So in Vidal v. Elster, argued just Wednesday, the issue is whether the refusal to register a trademark under Section 1052C violates the free speech clause of the First Amendment when the mark contains criticism of a government official or public figure. And then in Jack Daniels Properties v. VIP Products, the Bad Spaniels case, which we're well representing with our props here, the Supreme Court in June ruled squarely for Jack Daniels, and I'll let Willajeanne tell us all the details of that ruling. So thank you, Professor McLean.
Thank you.
Discussion over to you.
Good morning. And let me also add my thanks to Dean Carpenter and Professor Carol and to the staff for the invitation to come to this conference. I'm here to discuss what I am calling a tale of two cases. I thought about making it be TAIL in homage to Bad Spaniels, but I thought maybe it might be a little too early in the morning for bad puns. Both these cases, Jack Daniels and Vidal versus Elster, concern the scope afforded to free expression when it intersects with or conflicts with trademark principles. In the Jack Daniels case, the Supreme Court restricted the breadth of protection applied by the Ninth Circuit to so-called expressive works. And in Elster, which concerns enforcement of the Lanham Act's prohibition against the registration of marks identifying a particular living individual sans the consent of that individual, the Supreme Court has an opportunity to make Section 2 smaller, having already excised 2 of its clauses in the 2017 Tam and 2019 Brunetti decisions. Before discussing Jack Daniels or Elster, I want to put these in a little bit of context. Now, the question that I pose here is, what do these images have in common? If you start at the bottom left, what you have is a bored ape, Yuga Labs versus Rips, in which Yuga Labs sued for trademark infringement and appropriation of their Bored Ape Yacht Club collection. Squarely above it, you have Rothschild's reimagined Birkin bag. His collection was called Meta Birkins, which was the subject of a trademark infringement suit brought by Hermes. Next to it, you have the iconic Barbie in a blender. Mattel sued Walking Mountain Productions, alleging infringement because the photographer, Tom Forsyth, used Barbie in all sorts of situations for a series called Food Chain Barbie. And down in the bottom right quadrant there, you have Mattel versus MCA Records, where Mattel alleged infringement of its Barbie mark because of a song, Barbie Girl, that was made famous by a Danish-Norwegian Europop group. And in an ironic turn of events, Mattel licensed Barbie Girl, and it was reimagined as Barbie World in the mega hit Barbie movie this summer. So if you said, except for one, all were heard by the Ninth Circuit, yes, you would be right. However, what they all have in common is Ginger Rogers, shown on the left with her dancing partner, Fred Astaire. Ginger Rogers was not happy when Fellini decided to make a film, Ginger and Fred. She alleged that it created a false impression that she was somehow involved in the Italian movie. The Second Circuit basically took a look at the problem and said, in general, the Lanham Act should be construed to apply to artistic works only where the public interest in avoiding consumer confusion outweighs the public interest in free expression. And from that, we got the Rogers test, which basically says an artistic work is protected as free speech from the Lanham Act when the title has some artistic relevance to the underlying work and when the title is not explicitly misleading as to the source of the work. This now brings us to the Jack Daniels Bad Spaniels case. Jack Daniels claimed trademark infringement and dilution. It wasn't happy with being told that being compared to the old number 2 on your Tennessee carpet. VIP claimed it was an expressive work and therefore Rogers test should apply. The district court said consumers were going to be confused as to the likely source. Ninth Circuit reversed, said you need to apply Rogers. District court granted summary judgment. Ninth Circuit said, finally, you got it right. And then the US Supreme Court granted cert. The court had a narrow holding. It basically said not appropriate when the accused infringer has used a trademark to designate the source of its own goods. So the trademark is used as a trademark, and they said Bed Spaniels was, not that far away from Jack Daniels. They were using it as a trademark despite the presence of a tag. This is silly squeakers as a source identifier. And so when a mark is used without permission, the court said, the standard likelihood of confusion inquiry covers free expression interests. They did say, except potentially in rare situations. Did not say what those rare situations might be. And part of the concern was that almost all cases involving expressive use would be decided under Rogers and not likelihood of confusion. So with that in mind, we have the court considering, and we'll move to the case du jour, Vidal versus Elster. Lanham Act, Section 2C is there, forbids registration if the proposed mark consists of or comprises a name identifying a particular living individual, except by his written consent. So Elster wanted to trademark the phrase Trump too small for T-shirts. The examiner said, sorry, Trump is a living individual. You don't have his consent. Section 2C. Elster did all of the appropriate things, appeal to the TTAB. And then right as the TTAB was getting ready to examine the case, the examiner says, oh, wait, there's another possible ground for refusal, false suggestion of a connection under Section 2A. The examiner got the case back and said, we're going to reject it based on both 2A, false suggestion of a connection, and 2C, use of a name without the individual's consent. TTAB, Trademark Trial and Appeal Board, upheld the refusal of registration on the grounds of 2C only. It did not take up the question of false suggestion and false association. Elster appealed, went to the Federal Circuit. The Federal Circuit said, yeah, we think it's unconstitutional as applied to Elster, and reversed the board's decision. The government filed a petition, and as you've heard and know, oral argument was heard on Wednesday. And I have to say, as an aside, I wonder how much money Professor Carol gave to the court to do this 2 days before the conference. So the arguments were based on 3 prongs. For the petitioner, the government said 2C imposes a condition on a federal benefit. It is not a restriction of speech. We're only saying that when this occurs, you may not register the mark. The argument was also that it's viewpoint neutral in the sense that all it says is that you need consent. We're not talking about the consent being conditional or registration being conditional on the mark being favorable as opposed to critical of the named individual. And oddly enough, registration of the mark would reduce speech because, of course, one has all of the imprimatur of a trademark. So anyone who uses a mark that is the same or similar on products which would confuse the consumer would have the right to squash the use. The respondent basically says, well, 2C is going to forbid and prohibit use of the mark, and it's based on applicant's speech, and it's going to be a substantial burden. The respondent also argued, Elster's lawyer also argued that, this is a purpose, using 2C achieves a purpose wholly unrelated to trademark law, and it involves speaker-based discrimination that lends itself to viewpoint discrimination. You heard, probably most of you, the arguments. One would have been left with the question, what will the Supreme Court decide? Justice Sonia Sotomayor said the question is this an infringement on speech? And immediately answered her own question, and the answer is no. And so I'm joining most who have heard the argument that it's not going to be expunged from the Lanham Act. The big question is, how will the Supreme Court decide the basis on which to keep 2C viable? But that's a conversation for a later period, probably today. And so I leave it to you to introduce the next person. Thank you very much.
So Professor Farley, if we can start with you, as I sort of alluded to in the opening, as a copyright person, sometimes find it challenging to find the coherent thread in the Supreme Court's jurisprudence on the question of what's the proper relationship between trademark law and First Amendment law. And so it seems like there's some guideposts around the edges, but there's this vast swath of issues, particularly surrounding Section 2 of the Lanham Act, that have been left kind of unanswered. And so I know you've written in this space, and in particular, after the Jack Daniels case, you wrote an article proposing a different and more holistic fair use test be adopted nationwide. So if you can maybe introduce yourself also by introducing your scholarship on that point, and telling us how it would help courts resolve some of the enforcement questions that they are likely to face.
Great, thank you. And I know we're not really making presentations, but this is more conversational, but I couldn't see that half the room
Yeah,
sitting,
sorry.
so I'm getting up. And I don't know whether my co-author Lisa Ransey is on, because, oh, she is. Good for you, Lisa, because it's very early in California. So I'm going to talk a little bit about the article Lisa and I recently published. But before I do, I just want to, I want to take what has been said by the other speakers so far and kind of make that the setting for why Lisa and I embarked on this project. So what's going on here? 4 cases on trademark and the First Amendment in 6 years. And I suspect even after we have a decision in Elster, we can look at all 4 of them together and not learn very much about what the framework is for thinking about the First Amendment and trademark law, because each of the decisions so far has taken the narrowest path to resolving the issue. In Tam, it was because the justices couldn't agree on anything, so they agreed on the bare minimum. It's viewpoint discrimination. In Brunetti, that was all. That's such a Kagan move. Like, viewpoint discrimination, we don't need to say anymore. Let me write a really short decision. But there were in both of those cases multiple opinions. So the court is thinking different things. They just haven't coalesced to say something that's super helpful. And I suspect, even though I was witness as I was sitting in the Supreme Court listening to the Elster argument of a metamorphosis of the Supreme Court into one that was even more sensitive to the larger role of trademarks and the First Amendment. I suspect that because of the change and because it didn't seem like there was a lot of agreement on how, the question you left us with, Willajeanne, how they do this, that we'll have another narrow opinion that will deliberately not try to answer other questions. So in all of this non-telling us things, I do think we can put them together and get a larger message, and that is that the Supreme Court is interested in this area, and that the Supreme Court is, even without saying it explicitly, conscious of the fact that the First Amendment does play a role in trademark law. And I want to just quote my new friend, Justice Alito, who's become my friend in the past 3 cases. He said in oral argument in Jack Daniels, he said, there is a text that says that Congress shall make no law infringing the freedom of speech. That text, that's a text that takes precedence over the Lanham Act. I totally believe that. And the question is, how does it do it? And we're here talking about enforcement, and that's what Lisa and I were concerned with. So we recognized that the Rogers test that was described to you has problems. We recognized in our article that it was never meant to be the end-all be-all for navigating this intersection. And it has a lot of issues, and we could do better. But we need trademark law to be consistent with the First Amendment, and taking the model of copyright law that has a broad fair use provision that the court has pointed to say, here's how this doesn't run afoul of the First Amendment. I think trademark law could use the same, and we would hope that Congress would add such a fair use defense to the act. But we wanted to help them along. So we came up with a test that we thought, because we also wrote in the article about how there's lots of places in trademark law, in common law doctrine, in the act itself, where we're kind of taking account of speech, but not in a holistic way. So we wanted a broad fair use defense. We wanted it to be simple, predictable. We definitely wanted to provide an early out to litigation where that was appropriate. And we definitely recognized the problem that Justice Sotomayor and Justice Alito recognized in their separate opinion in Jack Daniels about survey evidence and how survey evidence can be abused. So we came up with a 3-prong test, because that seems like the right number of prongs for a test. If a defendant makes an informational or expressive use of a trademark that is not a false statement about its products and is not likely to mislead a reasonable person as to source, then that should be a fair use. So I've gone over that quickly, but I want to tell you what our thinking was with all of that. So first, we talk about an expressive use, not an expressive work. So that leaves the focus on the message, not on the medium, which gets us out of the problem that Justice Kagan had about, can a can of peas be free speech? And it includes not only expressive uses, but also informational uses. And that's our attempt to kind of make a broader fair use defense to deal with speakers who have a message, but also speakers who are using words and marks in a descriptive way. And we note, as per Jack Daniels, that if Congress or a court wanted to use this test, they could always lump onto that and not used as a trademark. That works perfectly fine there. But this first prong is the threshold. So the burden is on the defendant to show that they're making such a use. And once they've met that threshold, then we pivot away from the likelihood of confusion test and apply the next two prongs of this test. Okay, the next prong is not a false statement about its products, and we want to include there any kind of false sponsorship, false endorsement, or false approval, so that we're capturing all of 43A. So things like authorized NFL merchandise or official beer of the NFL would run afoul of that prong. So this is kind of tracking the explicit part of Rogers, but being a little broader in that explicitness. Prong 3 is not likely to mislead a reasonable person about source. Every time I've read that, I've really emphasized reasonable, and that's because I've underlined it in my notes. That is an objective standard. And I just want to note that a number of justices in oral arguments have talked about a reasonable person wouldn't be confused. Isn't trademark law about protecting reasonable people? So they've read in that different standard that actually isn't in the law. And Justice Jackson in particular keeps talking about, isn't trademark law about protecting reasonable people about confusion as to source? So she has a kind of narrower understanding. So because it's objective, there shouldn't be surveys. It can be decided as a matter of law. There can be a defendant can prevail on a motion to dismiss, a motion for summary judgment, a motion for judgment on the pleadings. And this is responding to Justice Kagan's footnote 2 in Jack Daniels about having early off-ramps. That is recognized as being really important here. A worthy speaker should not have to go through years of expensive litigation. And so I'll close with saying, although in Jack Daniels, the court said parity should be subject to the likelihood of confusion when used as when the defendant uses it as a trademark, as the court was certain happened in Jack Daniels, although I disagree. And there was the insinuation that the likelihood of confusion would work just perfectly fine for a worthy parodist. I don't think that's right. And I can point to examples where it didn't go well. And I think our test would do a much better job with parody and other speeches. So thank you.
Thank you. So next, I'd like to invite Professor Linford to speak. And Professor Linford, you've conducted some empirical research on the issue of tarnishment. So could you summarize some of your findings there?
You bet. So I'm glad to be with you. You need to set me up. While Peter's setting up, I'm glad to be back at New Hampshire. I broke out my winter coat for the first time in a couple of years. Like Dean Carpenter, I have wondered if my parents would ever enjoy my scholarship. And I think my dad did spend a month working through one of my articles, 3 pages and a long map at a time. And I was always very pleased that he made that effort. So I've done a couple of empirical projects, one which is completed, one which we've started. As you think about whether or not the First Amendment should limit the current scope of trademark protection, a place where folks often point to as a potential locus for narrowing or perhaps constitutional nullification entirely is in the space of, there we go, trademark tarnishment. So our anti-dilution statute extends to famous marks, protection against use that harms the reputation of the famous mark. And if you think back to Tam and Brunetti, and especially Tam and the court's concern about a law that allows only happy speech or only positive speech and not negative speech with regard to racial groups or with regard to offensive or scandalous terminology, you might wonder whether the same should be true for a provision of the Trademark Act that protects famous brands from uses that tarnish. And typically, courts have talked especially about uses that connect the mark to sex or to drugs. Some of the question for me has been whether or not these cases, Tam and Brunetti, a case called Alvarez, this was the stolen valor case, and also perhaps Elster, although having heard Elster, I'm not so sure, might indicate that there will be, at some point, some constitutional scrutiny applied to tarnishment. To the extent that happens, whether or not we're applying rational basis, did Congress have a good reason for what it did, or intermediate scrutiny, did Congress have a substantial interest, and does the Tarnishment Act directly advance that substantial interest, or whether we're talking about strict scrutiny, which is often but not always fatal, is there a compelling government interest and is the statute narrowly tailored? Some of that might depend on whether we think tarnishment actually happens, whether there is actually harm to the reputation of the mark. So we've got 2 studies in the can, and a co-author and I are working on a 3rd one designed to ask those questions. So the paper that's finished looks at sex, drugs, and sacrilege-related tarnishment. And we looked at sexual imagery, drug-related imagery, and what we call sacrilegious imagery, kind of building on the Satan shoes controversy. And looking both at kind of direct processing and indirect processing. I won't get into the weeds on that part. If you want to talk about that in Q&A, I'm happy to try to explain that. So the first study, we hypothesized we might see a tarnishment effect with regard to sex and drug-related imagery, and that it would be stronger among survey participants that identified themselves as political conservatives as opposed to political liberals or political progressives. So we selected 5 well-known consumer brands and tarnished versions. We had 2 with sex-related imagery, 3 with drug-related imagery. The following image is very tacky. So there's McDonald's in a sex-related image, and then Sour Patch Kids used as a cannabis sale, okay? And we thought we might see conservatives react more negatively, but that we would see a tarnishment effect overall, and we didn't. Instead, what we saw as between the control condition where respondents were not exposed to the potential tarnishing stimuli and the tarnishment condition where they were, is we actually saw a net increase. The question we asked is, which of these 2 brands would you pick? And there was a net increase, a statistically significant net increase, that they would pick the brand that they had previously seen the tarnishing stimulus. And if you compare the 5 brands, if you break out the 5 brands individually, there was a Coke and the Sour Patch and the McDonald's, and you'll notice those bars go over the 0 line, which suggests mess, right? Reese's and Titleist, there was a Reese drug use and then a Titleist, the breast joke, that were kind of clearly in the burnishment or halo effect. And if you pool them all, the bands were all clearly in the burnishing effect, which suggests, at least with regard to that part of the study, we didn't see a tarnishment effect. We split it out by sex and by drugs, and there was a burnishment effect statistically significant in both of those subgroups. We split it out by conservatives and liberals. We found a not statistically significant burnishment effect, and the conservatives are kind of all over the map, and a quite strong burnishment effect among political progressives. We then took a look at so the art collective Mischief that had done the Satan shoes with the Little Nas X also did a prank where they bought a bunch of Chick-fil-A sandwiches and resold them on Sunday for $6.66 with some with some satanic iconography, quote unquote. This is what the ads look like. And so we ran an indirect survey where we were asking them questions about news stories, and the ads were all in the periphery. And what we did find there, we used a couple of different metrics for how much you like Chick-fil-A. And we did find for respondents that had high religiosity, and there's a way social scientists measure your religiosity. For the group with high religiosity, there was a reduction in how tasty they said Chick-fil-A sandwiches were. So at least for the highly religious group, there seems to be a tarnishing effect with regard to Chick-fil-A sandwiches. Now, there are previous studies by different scholars, some of which who have seen a tarnishment effect, some of which who haven't. So we're starting to build a database that suggests a mixed case. And that mixed case might then depend if we have some sort of constitutional challenge. And we're talking rational basis, mixed case is probably good enough. And if we're talking strict scrutiny, maybe not. But our first study suggested to me a question: is there any sort of tarnishment that would actually work on political progressives? So we've done a pilot to try to answer that question. Here's what we did. We mocked up kind of 6 different potentially offensive ads. Somebody actually made a Starbucks guns and coffee logo. Lululemon, one of their workers had mocked up a sweater that made a a racially offensive statement about where COVID had started. The others we mocked up. So it's a bunch of Ford trucks in front of a church, a CVS vape pen, McDonald's on a smokestack designed to associate it with pollution, and then a Tiffany's box with the slogan, "This will keep her in the kitchen," which is designed to be kind of sexist, right? And what we did is we asked the respondents, we actually explained tarnishment law to them. Funny side note, a third of them could not successfully identify the tarnishment case from a number of cases. And so there's something about this concept of tarnishment that we tried to teach them basically the difference between tarnishment and confusion, and a third of them failed out. I don't know what to make of that yet, but you can roll that around in your own mind. Yeah, I'm not going to try blurring. There's no way in the world I'm going to try blurring. I don't understand blurring. But what we did see is when we asked them, which of these uses do you think is likely to harm the reputation of the mark for you among conservatives, among progressives? What we found is for almost all of them, Ford being the exception, they all predicted that progressives would be, would hold the mark in lower esteem, would find the mark harmed by these uses. They were all statistically significant except the CVS one. The CVS vape pens, I'm not sure anybody knew what to do with. Even conservatives seemed troubled by the Lululemon racist joke, or sorry, our respondents predicted that conservatives as well as progressives would be troubled by the racist use of Lululemon. And they predicted that progressives only would be troubled by the sexist use of Tiffany or a gun-related use of Starbucks. Now, this is a pilot study where we asked them what they thought, and we kind of ran these 6 samples by them. The next step, of course, is to run studies like we ran in our trademark tarnishments paper and to see if this bears out. If that bears out, there's 2 potential consequences. One is then we have a little bit more evidence of tarnishment in favor of tarnishment, and potentially a stronger case that whatever level of scrutiny we apply, tarnishment might survive it, or there's enough evidence to say Congress had a basis, and we move on from there. But it may suggest, and I'm not sure what to do with this yet, and I'd love to talk with you about it over lunch or whenever, feel free to shoot me an email. Are we seeing in trademark law the same sort of political bifurcation that we seem to see in markets and that we seem to see in social media? And what do we do with that? And does the political bifurcation then change the way the First Amendment analysis ought to work in these contexts? And I don't have an answer for that yet. I just have some data that suggests maybe there's something to it. So anyway, I'll be excited to hear your thoughts and conversations, and we'll talk more about Elster, I'm sure. I kind of join everybody else in thinking that this court is not likely to get rid of 2C at this point in time on this case, or to find that it was unconstitutional as applied. We'll talk more about that. Thank you so much.
Thank you. And so turning also to Professor Weiser and Professor Cahoy, you've looked at consumer confusion and copycat products involving cannabis and edibles in particular. So I'm curious how that squares with what we've just heard and where those issues might link up.
Thanks, Sandra. Yeah, so that's I think this kind of puts maybe our discussion in context for making sort of the opposite sort of statement. So, I think we look at a lot of these examples at the outset as thinking that they're kind of art projects and social commentary. But there is a context where unauthorized use of another's mark could create some significant dangers, and actually confusion could create not only consumer harm but potentially harm for the goodwill of the company. And so, we did want to focus specifically on edibles because there's been some really interesting cases in the news about this, but I think it also teaches us some lessons with regard to the need for trademark owners to be enforcers and the tools that they have available now and the concerns I think we might have with changing those tests with a substitute. Either Rogers test or I think Christine Farley's. I think that's a really interesting idea for a substitute fair use test. But again, I think you'd have to have some concern about that. So Hannah's going to show you some examples and tell you a little bit about what this real world, real life problem is. Actually, this Halloween example is this Halloween. So,
Yeah.
so maybe you can enlighten us, Hannah.
Thank you. So as Dan mentioned, we have some real concerns about in a business environment, especially in the cannabis environment, which is a large emerging market. It's a multi-billion-dollar market. And specifically, our research looks into cannabis edibles as a part of that market, where there can be very confusing products, not just to the person who is purchasing the product, but actually to the people accessing it wholesale. So we look a lot at youth, but also adults who maybe don't realize that they just ate something they thought was a cookie and turned out to be a drug. Someone who might be pregnant, someone who's applying to a job. There's real concerns and real harm happening in the marketplace as we see this expanded legalization. And when I say expanded legalization, I know we're in New Hampshire, but we have medical use here for cannabis. It's the only state in New England, though, where it actually is, cannabis is not legalized for adult use. You'll see about 23 states now, DC and a few outlying territories have legalized cannabis. And as a result of this, we have a big business industry. And as a part of that industry, you'll see many dispensaries, many of them, especially with cannabis edibles, sort of taking advantage of longstanding trademark brands and using them in a fun way. There's sort of a culture around it. It's meant to be fun. It's meant to be humorous, these products, but they're having some serious harms. And that data has been more recent at a nationwide level that is specifically for use. We have youth, we have kids who are accidentally ingesting these products and ending up in hospitals. So a really clear example of that, many of us were celebrating Halloween just this week, going door to door and getting some candy. You go home, you spill the candy out and you go, ooh, I'm gonna eat some M&Ms. Unfortunately, as you'll see on the screen, sometimes the M&Ms actually look like this, and I'll switch forward here so you can see what I'm holding in front of me online as well. Sometimes they're not really M&Ms. Now, if I walk into a dispensary and I purchase the product you see on this side of the screen, I know that there's drugs in that. But will your kid know when they grab it out of a purse, when they see it at home, not stored properly as we might store that bottle of Jack Daniels you see over there? So the example we're sharing with you came up very recently this week on Halloween. There was actually a school, a PTA sponsored trunk or treat. Kids were grabbing their candy, and some of those kids, 4 of them, went home with drugs. They had cannabis in their bags. One of the children got very sick, and the police said, oh no, when they started sending out warnings and trying to let the parents know. That's real harm. When we talk about confusion, the kids were obviously confused. The parents may have been confused. And we don't expect to have that type of confusion. What you see on the screen was the original sort of Starburst looking candy and what they actually got in their bags, which was THC cannabis infused drugs. So you might look at this, and I think Dan and I have looked at this a lot in terms of some of these examples like you see here. This is pretty obvious infringement. Okay, maybe it's a joke, but okay, we see M&Ms. It says M&Ms on there. There's lots of color. It says party size, maybe not fun size. And we can see really, really small, but in the corner, it does say THC. It does give some level of warning, but looks very similar to that M&M product. Okay, so now we see some others. It may not immediately stand out to you whether or not, these products are not the longstanding brands that a lot of us grew up eating. Because cannabis is illegal, it's a Schedule I controlled substance under the Controlled Substances Act. We have a lot of sort of decentralized and strange regulation that happens more at a state level, and there's not always a lot of it. So we don't always have to have all these things you see here on the screen. Not all states require some of the warnings. Some states restrict whether or not there can be all these colors. Maybe like in Massachusetts, it should be plain packaging. We also have varying restrictions on how much of the drug is actually in the package. I think what alarmed us when we talk about harm is that some of these small products we would eat all of, we're excited to eat that whole treat, had 60 times what an adult should use, better yet, a child who should have none. They're getting very sick. Adults and children then are overdosing. And so as we move forward to some of the other examples here, now we remove the branding, right? We just see the gummy bear, but that clearly could have cannabis on it. And now we wonder, well, what about the shape? Are they using Haribo's shape when they make these gummy bear products? This is a picture from an actual dispensary. That looks like a 7-Eleven, right? You walk in and we see a lot of drugs on the screen, but they look like the food we commonly eat. Here we see a lot of these drugs actually showing up in schools. This was a Facebook announcement from the Charlotte County Sheriff's Office warning parents about a number of products they had found in local school districts. You'll see on the next slide here, we start to wonder, well, is this parody? Again, there's this culture of fun in this environment, but is it so fun when we start to see some of the kind of confusion that has now been documented? We saw just a handful of cases of youth in emergency rooms over the past few years has gone up to over 3,000 plus reported cases across the country. And that's just the ones reported. Now, very rarely does someone want to drag their children into the doctor and say, I messed up, they got my drugs out of my bag. No, and so these are just the reported cases that we have so far. Now we get into, okay, it's a little different, right? And this is where we start seeing, Starbucks, that's clearly coffee, but now we have a different market, right? And so we start to wonder, is this maybe a little different? Is this still that confusing? Here we have a sticker. Okay, I know it's a sticker. It's a sticker, so maybe this isn't as confusing here. And finally, we get into some of the upcycling parody and, okay, maybe this is an okay use. This could be fair use, or maybe it's not. And so I think what Dan and I wonder about and kind of worry about is this enforcement issue. We think that businesses can take a big role in trying to help protect against some of these harms that can hurt their brand. And what I mean by that is if my child goes home and eats this, they eat the drug instead of the candy, well, I might say, I don't want these kids eating M&Ms at all. Right? I'm worried about the harm that it might cause. So I'm going to let Dan talk a little bit more to you about some of the trademark issues we see there when we start saying, okay, let's allow free speech, and there's certainly some room for that, but we need to be careful about some of the harms it can create, especially in this environment.
Yeah, just a few additional comments here. Great. Thank you.
Yeah, so I mean, I think as you see, as Hannah went down the list of different examples here, if I can figure out how to go back here, that it gets a little easier to see, or it gets a little easier to make a First Amendment argument for some of these, and in some cases to say I don't see any confusion, and that's because that's the way the likelihood of confusion test works, right? That's what you're supposed to do, and so I guess one of the arguments we want to put out there is that we actually do have a way of analyzing this that gives you the opportunity to say, well, this is a different product segment. It reaches different consumers. It conveys a different message. It's going to be less likely to be confusing. This is a sticker that's not sold on a product and is likely not to affect anybody but those who see it post-sale in a post-sale confusion context. And we can talk about whether or not that's a relevant trademark context. But the point is that this is built into the system. And that's probably arguably enough. And one of the concerns I think that we need to be cognizant of is the possibility that trademark owners might be disincentivized from enforcement. And one of the points that we make in our paper, which is on SSR and not child's play, you can just Google that, or go to SSR and type their search, which I think would be appropriate trademark use there. We think trademark owners are actually an important part of this system. And so when you get away from sort of just the trendy art projects and you actually think about real potential harm context, a trademark owner is an important part of the system. So, regulators are trying to catch up with, as Hannah said, reducing the sales of cannabis products with colors and in candy forms and things like that. Maybe they'll do it in some states, maybe not in others. Police, when they find truly dangerous examples, can take enforcement action, but we don't have trademark owners incentivized to do something and make the strategic decision to enforce. I think we'd have a little bit of concern about whether or not we're going to have a more dangerous environment than we would prefer. And so what creates that incentive to enforce? Well, having at least some understanding that there is going to be at least a threat context and that a defendant is going to have to make a case for themselves. And I think, for example, I thought Christine's fair use argument is a really good one. And I agree that fair use, as it exists in copyright, you always sort of mentally transport that over to trademarks, even though it certainly doesn't exist there. But I guess one of the concerns I wonder, so 2 points about that. One, fair use and copyright is not actually all that clear, right? So I mean, I think we'd all agree it's not as if that's the crystal clear test and that whatever we're doing in trademark is necessarily less. But I think one of the concerns about trying to do Rogers, trying to do a separate fair use test is that all you're essentially doing is boiling down some of the elements of the multi-factored, I called it the Polaroid test where I practice in New York, but the multi-factored test into some summary elements, but you're doing essentially the same thing superficially and maybe without the surveys in some cases. So I'm not sure that it would, in many cases, is going to provide the appropriate incentives because, of course, trademark owners have to make a strategic decision about whether or not they want to enforce in any particular case. And also, an enforcement decision, keep in mind, also brings with it the potential for backlash if there's over enforcement. So that is also embedded in the system that a trademark owner going after, for example, this company. So this company was accused of selling canisters of some kind of cannabis product. I guess I'm not sure if it was straight marijuana or some other kind of cannabis edible, but they looked like Old Bay cans. And so the company that makes Old Bay said, no, you can't do that. So they said, great, fine, we don't need to. We'll just sell the cans and then we'll sell the stickers to consumers separately that then they can go apply them. It's okay, that's clever. That's good. And that should be assessed perhaps a little bit differently, understanding that in that case, that's going to be a pure, at most, post-sale confusion kind of context, or maybe a tarnishment context. But that should be something that is assessed a little bit differently. And a trademark owner, Old Bay, is legitimately and appropriately going to have to decide: is this a case I go after based on my concern about the free speech backlash, versus these super clear examples where M&M Mars has to take action there. That would be insane for them not to go after this a company like this. And it's amazing if you actually see the real example of this. Hannah was showing me how professional and truly legitimate the infringing copy looks. So I think the overall analysis that we have is that things generally seem to be working now well post Jack Daniels. And I'm not even sure where a Rogers test, where it would be inserted in a place that's necessarily more helpful, at least in these kinds of contexts. I'd still be waiting to see it. I think Jake's discussion about tarnishment is really interesting. And I think the second part of your analysis is where it's going to get really interesting, because where you see a connection here is where the tarnishment is connected to that some kind of perception of the product as opposed to something totally different. So you did McDonald's and some kind of sexual connotation where those are not really kind of connected contexts as far as I know. But when you're actually making a comment on the taste of something or the fun of something, or where actually the tarnishment actually relates to the product in some way, it's probably going to be a closer connection. So it'll be very interesting to see the results of that. So that's essentially the way we have been looking at that. And so making a proposal that the system generally seems to be working, at least in the context of dangerous products like this, that we need trademark owners to be enforcers. And I think finally that trademark owners not only should just see this as a typical case, but almost more like a counterfeiting case, and think about the powers that exist under the Trademark Modernization Act, the presumptions when it comes to injunctions, of course, are much more powerful in the trademark context than they are in the patent context. So that's the way we look at it. And so that's all we want to say, at least at this initial point, but we'll be happy to engage in some additional discussion. Let me just say as a final point, we're also very happy to be up here, and we thank Peter and Megan for inviting us. This is my law school. This is where I attended law school. So I'm actually glad to come back here and see the old place. So which now looks like a new place. But so anyway, thank you.
Thank you.
So before we go to questions from the audience, I encourage folks who are online to enter questions so that we can hear from you as well and incorporate you into our discussion. I have a few questions for the panel to discuss a little bit about amongst themselves. And one thing, the panel today is about enforcement. And so that's, who's suing who, why, what about what are the courts doing, I should say, to incentivize some claims over other claims? And so I've got, I guess, 3 linked questions for the panel. First would be your predictions. Where in the trademark context do you think we'll see, and trademark First Amendment speech context, do you think we'll see courts engage in a robust review of these First Amendment issues? Are there other compelling cases you see in the pipeline, or other compelling cases that should be in the pipeline? Then, as distinguished from my first question here, your scholarly opinions, not what we think will happen, but what we think should happen from an enforcement perspective at this intersection. This is really the, going to the how do courts incentivize the quote unquote right kinds of claims question. And just so we all understand what we mean by right kinds of claims, I'd also love it if you could state your kind of personal metrics for what constitutes the right kind of enforcement claim to either bring or for a court to uphold. So I know it's, a lot, but there are 3 interlinked questions. And if there's anyone who particularly wants to begin, I don't have a great, lineup in terms of ideas of who needs to start, but
I'm happy.
Jake, do you want to start?
Yeah, I don't mind. And I'll talk, excuse my reach here. Wow.
Hey, you knocked me.
See if I can knock the whole table over while I'm at it. So I'll talk mostly about tarnishment, because that's what I've been thinking about. And that, I think, some of my colleagues, including, I know, Lisa Ransey, Rebecca Tushnet, have posited. I can't remember if you've written directly on this, Christine, but I wouldn't be surprised if you had that tarnishment might be, the next place in light of Tam and in light of Brunetti for this sort of move. Predictively, I thought there were, I am skeptical if there is enough evidence, and I'll get to that in a second, that tarnishment actually exists. And that's part of what I'm trying to do, is figure out, do we think there's evidence there, right? I don't think I can do it all by myself. So to the extent you're interested in these empirical projects, let me encourage you to pick one up and do it, and let's see what we get. But I was interested to see many members of the court in the oral argument in Elster bite on the following concept for, I think, really the first time, which is the idea that the trademark harm, if there is any, would be in Elster's ability to enforce the Trump too small mark against potential competitors. In other words, that if there is a First Amendment problem with regard to these political slogans, it's not turning Elster away at the door, but it's letting Elster have the political slogan. Now, that is something that perhaps the government's attorney could have done a little better job grounding in something like a failure to function doctrine. I thought there was an attempt to do so. I thought it could have been done more concretely. And the idea to tell the court is these are by and large marks that shouldn't be registered at all, separate from 2C, because they're political slogans. Or if you look at the context of Elster's use on the front of a shirt, maybe that's just an ornamental mark. And perhaps we've allowed, the trademark office has allowed too many ornamental marks. And that may be, shore up the practice of the trademark office rejecting on one or both of those grounds, and we take care of most of that First Amendment problem. But I bring that up because I think if you are looking for a space where the trademark enforcement starts to look like this happy talk clause, you can say nice things about a brand, but not unnice things about a brand in a non-confusing context, that's going to be tarnishment. Now, do I think the court's actually going to go there? I do not. And I don't for a couple of reasons. One is, I think, as I read Tam and Brunetti, and I am skeptical about what's going on with, and this is all speculative and I have no evidence. So I'm gonna put on my tinfoil hat, ride with me for a minute, and then make of it what you will. I'm quite skeptical that the court is particularly serious about using the First Amendment as a tool to reset trademark law in any sort of speech promoting way. I am much more persuaded that the court is interested in using the First Amendment as a tool of deregulation. And telling the trademark office that you can't deny registrations based on woke concepts like racial sensitivity or not using the N-word in a registration fits with the deregulatory agenda. But telling people they can't protect their property right, which would include protecting a property right against tarnishment, would not fit the court's deregulatory agenda. And if you look at the way the court, many members of the court seemed willing to embrace the idea. Justice Gorsuch, I'll be curious what his concurrence looks like and what sort of concurrence or dissent and what sort of long history of protection of names in trademark law he has found, because I'm not sure what he's talking about. But there's this idea that, you know, we have this long history of protecting names under the common law. This idea that the identity of an individual can be protected from some sort of quasi right of publicity, quasi trademark infringement, and that 2C is a proper mechanism for that. I don't see this court as finding a lot of air between that and protecting a brand against a tarnishing use if the brand is famous, given all the very concrete First Amendment parody style off-ramps that are currently in Section 43C of the Lanham. Okay, that's my prediction. Scholarly response. I joined a brief prior to TAM that thought really the best way to think about the trademark office registry or trademark registration of the function is really that limited public forum, right? That was not persuasive to Justice Alito. He is still staking out ground. He was begging the petitioner to give him any reason to reverse other than one grounded in limited public forum. The government was not ready to go there with him. I don't know why. But if we're not going to go limited public forum and our choices are between the Scylla of strict scrutiny and the Charybdis of rational basis, I think in the trademark context, my presumption is rational basis is probably the right move. I think strict scrutiny as applied would, if we're going to apply it like the court has historically applied it, and what that means with a court that is not unlikely to try to overturn New York Times versus Sullivan in the next 5 years. That sort of mischief, I think, would upend many, many apple carts, and I think in a way that wouldn't be particularly productive. So I think a rational basis move would be the better move. I'm not particularly excited about giving the court one more opportunity to get rid of what's left of the commercial speech doctrine, and I know you've got a vote from Justice Thomas for that. So I think trademark law will continue to function better if it's left in that rational basis, reasonableness, commercial speech at the very far end, and that perhaps Tam and Brunetti are properly conceived as outliers. Now, that kind of gives away, I think, my game on what I think the right sorts of claims are. I was of the opinion that Rogers had expanded well beyond its reasonable bounds. And despite my great respect for Christine and for Lisa, I don't see a reason for any more hypermuscular replacement for Rogers, which I think is what their proposal offers. So I would be pleased to see fewer of these sorts of First Amendment arguments over time. I think trademark law can probably manage well enough without them. Could be that I'm wrong on that. I've got enough epistemic humility, given that my hypotheses in our trademark tarnishment case research, almost all of them turned out to be wrong. So it could be that the evidence ends up cutting against me in lots of other ways as well. So those are my initial thoughts.
Okay, well, I agreed with what some of Jake said.
I'll take 20%.
Some very strongly. So my prediction is that parity is going to do a lot of work in future. There's going to be a lot of cases. I think courts may take Justice Gorsuch's admonition to heart, which is stay clear of Rogers. You know, there's a problem with Rogers, and may trust the majority, which is to say courts will take due consideration of a parity in the likelihood of confusion factors. So that's a path. And just to respond to you a little bit about fair use being unclear, so is likelihood of confusion wickedly unclear. So so that's the alternative. So I think parity is going to have to do a lot of work. And I think the court, the court is a general court. They don't really have they're not watching what we're watching. They have a couple of examples in mind. Justice Sotomayor and Jack Daniels had this, like, here's a really political parody on a t-shirt that's, giving a message which is abundantly clear. I'm concerned about that. There's no need to be concerned about that. That example wins under any way you go to it. But parodies are not always so clear. And I always point to, well, there are a lot of things I could point to, but I always like to point to the Al-Qaeda Holocaust case, because I know from talking to Paul Levy that first of all, he does litigation for free and he does it very well. And that doesn't happen very often. And he put 500 hours into that case, somehow found 2 pro bono experts, which, basically doesn't exist, and then was able to win. And that seems like the next Al-Qaeda Holocaust case might not go that way. And that's why I think we need a more robust fair use provision. And so I think there are all kinds of right claims out there. I'm going to watch very carefully Mischief's current litigation, and I'm sure future litigation, because I think those are really subtle artistic moves that some courts will consider free riding, and I don't think free riding claims are legitimate claims. And then, your predictions about Elster and the rational basis. So I'm very interested in what Elster may say that may bear on my hope that someone would challenge tarnishment based on the First Amendment, and what they say could really bear on that future challenge. And I agree with you that the court was thinking about enforcement in a way that we just haven't seen before in any of these cases. And there was a lot of talk of a reasonableness standard, and that reasonableness standard needs to be tied to what the court thinks Congress is doing in trademark law, and whether they have a really narrow conception as to, protecting against deception and confusion, making sure marks function as marks, or whether there's any broader public policy there. And so maybe Justice Gorsuch's idea of a history that I also am not familiar with about this, property rights in names means that property rights are within what Congress should be doing in trademark law, and that saves tarnishment. But those are the things I'm going to be watching there.
I was just sitting here listening to the debate between Christine and Jay, and I'm curious as to, as I said during my talk, how the Supreme Court is going to reach its decision not to gut 2C. And I agree with you, Christine, that there was a whole lot of talk about reasonableness and is this rational? And I think that's where they're probably going to go. I too, when I heard talk about the long historical significance, was like, where, what case, what are you thinking about? I always get a little concerned when the Supreme Court gets its hand on a trademark case, because I'm never sure what they're going to do and how they're going to upend how we think about trademarks, because they don't, now it seems like they're doing trademarks every other year practically, but it's been a long time coming that they've been interested in trademark, and I really wish they'd sort of keep their paws off of it. My a thought is that you're right, parody is going to have to do a lot of work. There is I'm not sure what the basis is for Rogers that I think should give everybody pause. Every trademark practitioner should think about whether or not we're going to say, let's use Rogers, because if it gets to the Supreme Court, I can't imagine that they're not going to gut it even more than they have. What are the right kinds of claims? I'll know it when I say it.
Oh, great. Yeah. So I think those are, I think, really astute observations of the complexities in assessing this First Amendment context. And so I think rather than getting into those details, I think the next big debate is going to be about how to take an off ramp away, not with a separate kind of assessment test, but just getting away from trademarks. So I think what you saw in Elster, at least as much as the oral arguments I heard, is that there was a thought about, well, look at all the different ways we can avoid the First Amendment issue. So go ahead and print the Trump too small on a T-shirt. Just don't use that as your brand. Non-trademark use. So I think trademark use is probably going to be the next place that we're going to have to get into it a little bit more. And the courts have kind of avoided that about trying to assess, like, when is a trademark use, when is not. Functionality is going to be another area where we're going to see a lot more, I think, scrutiny and functionality as it relates to speech. So consider the Vintage Brands case. This is one where my university, Penn State, has been involved in some trademark litigation related to the branding of, well, apparently we have some relatively prominent sports teams that depend in part on revenue that is generated from our merchandising. And Vintage Brands has claimed that when you wear a Penn State jersey, you're really making a speech statement about your affinity for the Pennsylvania State University, not necessarily any connection to who made that T-shirt or that sweatshirt or hat or whatever. And that's kind of compelling. And so delineating when somebody is actually using something in a trademark context versus using a trademark as some other non-functional or some sort of, functional as opposed to trademark use, I think is going to be the area that courts are probably going to have to really start to separate more. That might be, again, the more convenient off-ramp getting into the morass of is this protected? What kind of test is a rational basis? Is it strict scrutiny? When is it content neutral? All that kind of stuff. So I think that's sort of where I would say. Anna,
It's interesting for me as I think about this in the cannabis context. In reality, most of these cases aren't making it to court. Most of them are settling outside of it when we have a trademark owner saying, hey, you're making something that looks really similar to my product. It's pretty clear and it's settling. But when they do make it to court, it also is pretty strong for the brand owner. They get to hold their trademark rights and the court supports that. And so maybe it's, are there other ways to sort of find a quicker resolution for businesses to settle these issues when they are so strong and when it's not just about something artistic we're wearing. Instead, it's a product that can be harmful. So I guess I sort of look at, are there different contexts? The fashion industry is a large industry. Well, now we have cannabis as a large industry, and you'll see as more states are starting to legalize cannabis, we're starting to see a movement for psychedelics as well, with Oregon being the first state to allow for some psychedelic use that ultimately will also show up in the form of edible products. So maybe the businesses should take a larger role as well.
So I'm going to press a little bit further on some of these distinctions that you're making, and also return to the question that I started with, which is, what does this all have to do with copyright, which is what the court was asking. And I say that only partially jokingly, because I think one of the ways, and saying this as an outsider looking at the cases, one distinction that comes to mind for me is that there are instances where somebody is using a mark in a parodic sense in a true expressive art work, right? And so I think the Rogers test is an example of that. It's a film, it's an expressive work, it's copyrighted, copyrightable, right? And the other instances that I'm thinking of where it would be useful to have some better information as to how to operate. And Christine, I'd be curious on your views on this in particular, is the visual arts world context, where it's not likely that the mark is going to be confusing to a consumer in certain instances, right? So you go to a gallery exhibit and somebody is using a mark parodically, but it kind of goes to your test, right? But then we've seen recent cases that are sort of in, I would say, a gray zone where, like the NFT cases dealing with the Hermes bags. So that's an area where you don't have strong copyright protection for the work as a like fashion law protection issue, right? But you do have strong trademark protection for the consumer good. But what is being offered as an NFT is, supposed to be an artwork, right? But yet it's offered in a context where maybe it is confusing to a consumer. You see something that looks exactly like an Hermes bag, but it's fuzzy. And you're like, oh, well, maybe Hermes is actually getting into the NFT world and is offering these things, in the metaverse. Like everybody can be a fuzzy, right? So you might want a fuzzy bag, right? Whatever the tale might be there. So I wonder if there's any logic to what I'm saying in terms of making those sorts of fine distinctions, and if that may have been what the Supreme Court was trying to ask a little bit in the arguments on Wednesday, as well, like trying to parse, okay, not so much if we create a robust fair use doctrine and trademark, what will it do for copyright, but where are those bleed over cases where it's a copyrighted work that deserves its own First Amendment protection, right of expression should apply, but yet there's a trademark that can come in and stop that, where copyright's fair use doctrine wouldn't. Sorry, that was an incredibly long question, but
I love it. It's so interesting. I think yes, if you have a defendant whose work would likely prevail in a copyright infringement case under fair use, then that should give you some guidance as to how trademark law should operate. If you do, though, I think you're in good standing in any event in trademark law, although there isn't maybe the easiest off-ramp. So I think of the University of Alabama case where the defendant was an artist. He was making oil paintings. It wasn't a parody. He was honoring the University of Alabama football team, and the university sued him, and it went to the Court of Appeals, right? It was a lot of litigation for him to finally prevail. Should have been an easy case, wasn't as easy a case as it should have been. You compare that and some other cases where visual artists have used trademarks in their art to Meta Birkin and maybe Mischief. And I think the difficulty is maybe not in trademark law, but one that I've thought about for a long time, which is how do judges think about art? And is it really art? Is the Meta Birkin guy really making art? I think is what the judge's suspicion is. And if the judge were convinced that Mischief is an arts collective really pushing boundaries and making great messages, and not in fact a shoe company disguising as a bunch of artists, then I think those cases would go a lot easier. And just on that, there should be a through line in free speech through copyright and trademark and infringement and in dilution. So in Jack Daniels, if on remand it goes, the court says, okay, we're going to do what the Supreme Court said, Ninth Circuit in particular, right? We're going to say this is a parody, and now saying it's a parody, we're going to walk through these multiple factors and say Jack Daniels loses. There are two claims there. So Jack Daniels could lose on infringement, but win on dilution because trademark use as an exception to dilution, and that just shouldn't be, right? This should all, and that's why I think we do need a more robust framework to think about these things.
Yeah, well, can I actually use this question for some of the other panelists too, is, thinking about, or how this might fit in. So I agree that, having the copyright fair use and trademark fair use work together makes a lot of sense. What about the context where it's probably going to come up is, as we now increasingly have more copyrights falling into the public domain, right? Now the 20-year stay is gone, and now we have a lot more images that are going to be formally protected by copyright and trademark, and now are only trademark. So there's going to be a question of whether there is a statutory limitation on copyright fair use. Should we be going back and saying, okay, let's do an imaginary copyright fair use and use that to also, since we have such a robust area of law there, and use that to inform, a sort of a trademark fair use framework? I'm curious, what you think about that.
I have an idea, but I don't want to be the only one who's speaking. I'll just say really quickly, if copyright ends, it should end.
So
I would hate to see some mutant copyright claim, and that's, under the guise of a Lanham Act claim.
So the one thing that I think becomes confusing in the scenario that you set up, though, is that it's not as clear as like copyright is ended and it's ended, right? Because even stuff that falls into the public domain, it's perhaps like whatever, Steamboat Willie, right? Falls into public domain, but it's not Mickey Mouse, right? And so that can become, that can become confusing if you're talking about a trademark parody. And if somebody doesn't like parse those distinctions, should they have to parse those distinctions is one question. And second, like, the dilution and the confusion issues, I think, become even more confusing, right? If you layer over it these elements of public domain or not really public domain, right?
So a couple thoughts on the death of copyright, and then a couple thoughts on this meta question, right? So we've got the Daystar opinion from 2003, which is another one of those opinions that kind of swept beyond its reasonable bounds. But I think the point the court was absolutely right on is we shouldn't be trying to create an extension of copyright protection using some sort of moral rights-ish 43A false endorsement claim. You're producing my work and it's my work, and therefore. And I think at the bright line there, that's an easy case, right? Now, it does get messy in a derivative work sort of context, which is to say, how much of Mickey Mouse was embedded in Steamboat Willie, and how much did Mickey Mouse change over time? And there's a couple of copyright cases that you might look at that I think might be useful for thinking about this in the trademark context. One is the litigation out of the Ninth Circuit on the end of the Superman copyright and whether or not Siegel and Schuster, the original creators, or their heirs actually, could terminate transfer. And we got back and forth, and the district court was the one that I think did the most careful job in thinking through, okay, so which parts of Superman were embedded in the original story and which parts did DC Comics add later? You get the same sort of question. I forget the name of the case now, but it's Judge Posner in the Seventh Circuit trying to sort these things out with regard to Sherlock Holmes. And, which is the original Sherlock Holmes story, which is the stuff that's later. And Judge Posner, very Judge Posnerian opinion, right? He's just cutting the line. He's saying, what I'm not going to let you do is try to use claims for copyright in the later stories to police somebody writing a new Sherlock Holmes story. And so these are some tools I think we might see courts begin to try to use. Thinking about fair use in the copyright context and what it might look like in the trademark context, I'm not sure it's as different as we think it is. And here's why. Barton Beebe's empirical research suggests that copyright fair use is really a two-pronged question. One, is the use transformative? Two, what are the market harms? And when we say transformative, we could think recontextualization or art purposes. And when we say market harms, we could think, are these parties competing in the market? And in a way, at a very meta level, those really are the questions we are asking in most trademark infringement cases. If we think, I know Christine disagrees that we can do this, I think there are reasons to be skeptical. If we think we can handle parity with a likelihood of confusion analysis, that's really the meta question we're asking. How similar are these marks? How similar is the defendant's use of the mark? Is it clearly kind of communicating non-confusing parity? Or is it much more subtle? Are they in competing product lines? Am I selling 300,000 shoes that I am calling an art parody versus am I selling 50 shoes to 50 museums that I'm calling an art parody? Right, and these are the sorts of questions that I think trademark law is already fired up to answer in a way. And questions of commerciality, that has been a sticking point where the court in the recent no, the copyright one. Warhol, thank you. Senior moment here. In the copyright context where the court is reinvigorating at least somewhat concepts of commerciality or commercial competition as perhaps tapping the brakes a little bit on the way transformation had kind of run away with everything in the Second Circuit. So I think it would be interesting to see these more and more in conversation with each other, to the extent some brand owners, I think, have signaled an interest in trying to protect copyrighted expression by turning copyrighted characters at least into trademarks. And I guess that's a third place you could look, right? Some of Irene Calboli's work, Zarsaid, they occur to me right off the top of my head as far as, characters where we got that copyright trademark overlap.
I want to be
Willajeanne,
open to questions from the audience too, but Willajeanne, if you've got an answer, that would be fantastic to hear.
All I was going to go back to Christine's point about whether or not judges judging art, despite the caution that, judges shouldn't judge art. In the Board 8's case, the judge said Rogers doesn't apply because this isn't art. This is just a misappropriation of the initial Yuga Labs Board 8, right? You took it wholesale. I'm not sure the judge was convinced that Rothschild Birkin bag was art. And so I think that has become a question. When you're talking about something like Barbie, food chain Barbie exhibit that you would see in a museum, or an exhibition, I think, and there was a copyright infringement part to that case, it was fair use all the way, right? And that, I think, informed whether or not it was trademark using the Rogers test. So I think it's all about the judge's perception. Skillfully hidden sometimes.
Questions from the audience? I think Alex has one.
I have a question for Jake. So this could have been a slip, it could have been intentional. You said, on the question of tarnishment, you said it depends whether we think tarnishment is real, rather than saying it depends whether tarnishment is real, which is really fascinating to me, right? And then
you actually surveyed people
Yeah.
and you taught them tarnishment and you asked them whether they identified tarnishment. This tied in with me to the gestures during oral argument toward dignitary rights in one's own name. And in fact, the government gave as an example of the importance of 2C. He said one example where 2C is going to come into play is where somebody's name is used in a trademark and consumers aren't confused and there's no false association or false endorsement, but the person named is offended and dislikes it.
Right.
So I wanted to hear you talk a little bit more about that connection. And then I just kind of wanted to ask the question motivating that part of your research, which is why do we care whether lay people predict a tarnishing effect as opposed to whether tarnishing actually takes place for those people?
Yeah, so with regard to the lay people predicting a tarnishment effect, that one's easy. That was my pilot study to make sure I was asking the right question for the eventual study. But I thought it was interesting. The one thing I didn't say about that is the lay people themselves, when they self-identify as politically conservative or politically progressive, and you divide them along those lines, they report their own perception of tarnishment more or less mirrors what they predicted for the various political groups, right? So the conservatives perceived less tarnishment than the political progressives. So what I meant to say, and that was a slip, what I meant to say is, do we have empirical evidence that a brand or a trademark suffers some sort of reputational harm or harm to the mark based on tarnishment? And the way I read Alvarez, and I see Alvarez as the seedbed in a lot of ways for the questions in Tam and Brunetti and Elster, and not so much JDI, but certainly in the registration context here, and when we are denying rights or potentially criminalizing false statements of some sort. I think the strength of the evidence and what test we decide to apply matter. Right? If it's rational basis, okay, I don't think you've got to show much other than Congress thought there was something going on here and it's not implausible. And if it's strict scrutiny, I think we'd want some evidence that Congress probably didn't have at time one, but may or may not be able to be marshaled at time two to suggest marks really do kind of suffer some sort of cognizable harm. Now, the dignitary harm really is different, right? So the last couple of projects I've been doing have not been trying to articulate a dignitary harm so much as they have been trying to measure, do we see a financial harm? Do we see consumers saying, I would be less likely to buy or consume, I would be less likely to pick, I'm going to give a lower number on a Likert scale. I think that matters I think it's a different sort of question and perhaps an easier question to meet constitutional scrutiny with, frankly, right? If we end up in a strict scrutiny world, I think the argument that a brand or an individual suffers a dignitary harm is going to run right up against what we have traditionally said about defamation law, for example, which is, okay, if you're famous, it's got to be not true, and you've also got to be reckless as to the untruth of it. If you're not famous, we'll make it negligence. But I don't think those dignitary harms get you anywhere. I don't think the dignitary harm question solves the strict scrutiny question or answers the strict scrutiny question. That said, I think the dignitary harms are, I think people will experience dignitary harms. And I think there's a conversation to be had long-term about whether we care about those dignitary harms. Now, historically, the way I see First Amendment law in the United States and speech protections for offensive speech in foreign countries, you look at the European approach, and you don't get to do Nazi stuff. You just don't. They just shut you down. And here we protect all sorts of speech that I think we find really problematic, and we just distrust the ability of the government to step in. Now, we have historically thought different about things that work in commerce. And the right of publicity is kind of a funny locus for commerce because there's the privacy tranche of it, and there's this misappropriation of my commercial opportunity tranche of it, and they bump up against each other in funny ways. So I have more questions than I have answers there, and I've talked too much, but thank you for the interesting questions.
Did we have another question from the folks online?
Yes, we have several questions from the audience. First, for Professor McNeil, do you see a contradiction between Tam Brunetti's holding that the registration brings important benefits and refusal to register burden speech and the suggestion in the Elster or argument that there's no problem with the free speech in a denial of registration?
Who's that for? Yeah.
Well,
Yeah, but what was the first part of the question again?
Is if you see a contradiction between Tam's Brunetti holding that the registration brings important benefits and refusal to register burdens speech and the suggestion in the elders or argument that there's no problem with free speech in a denial of registration.
Yeah, that there was a distinction there, and I was trying to decide if the court is moderating its viewpoint on restrictions on speech. I mean, that what they basically said that in Elster, the question sounded like that they were going to say that there is a benefit, government benefit, but that this was not a condition, this was a condition on a government benefit. It seems to me that there was a condition on government benefit in the Tam case and in the Brunetti case. So I'm not quite sure what the distinction is that they're making. But there seems to be one. And I think we have to wait to see how they write the opinion to figure it out.
Okay, thank you. This is from the public, from Diane Shop, for Professor Cahoy. From a former classmate, can we talk about failure to function and this new, quote, examiner-generated standard? They seem to use this as a catch-all. It's not that the phrase is commonly used. It might be common because of the trademark's owner's own use and efforts.
Yeah, the failure to function. Well, that's a good point. That's true. Yeah, because for example, in sports branding, I was thinking of it as another good offer. I was thinking of it in terms of functionality, that people are wearing the mark to communicate something about the university, but there's also the failure of the function, which is also that's true, a common rejection to say that it doesn't actually function as a mark in the first place. The reason why you wear, going back to my University of Penn State branded item has nothing to do with trademark at all, so it's not a trademark use. And so yeah, I think that is again another potential place for exploring non-trademark use as an easy off-ramp to the speech considerations that are so much more complex. I mean, I think it's legitimate, but the problem, I suppose, with failure to function is then that also gets into some depth about, well, why are people wearing it, right? That almost requires a consumer survey about whether or not people are using it as wearing it as a mark. So I think it's inherently more complex than the PTO suggested is when they throw it out as a rejection. So I think that's, but I think that is another good consideration, or another good possibility for crafting some kind of way around the First Amendment consideration. That's a really good point. Question.
Are there other questions in the room? No, if not, if there's one from the audience.
Yeah, we have several online until you provided. This is regarding cannabis edibles also, and from an anonymous user. I agree that post-sales confusion of cannabis edibles is a serious problem, but the Supreme Court held in Headtronic that use in commerce is only the initial sale of goods, and post-sale confusion no longer seems to be a viable claim. Are you concerned about this, or are courts going to look beyond Headtronic to stop harm?
Yeah, well, right. So yeah, post-sale confusion. Yeah, they have to look certainly beyond. For a trademark owner, they're going to be looking to enforce beyond the point of sale, right? Oh, sorry, beyond the point of sale, where there's clearly going to be probably a lack of confusion because everybody knows what's going on. Again, very similar to counterfeit cases. And so then the more complicated question of how we find post-sale confusion, whether there is post-sale confusion, and the whole basis of post-sale confusion. This is something that, I mean, Alex and I were talking about this a little bit last night, that it's a tough doctrine that is underexplored. Post-sale confusion is a problematic doctrine. So post-sale confusion, to be clear, is the idea that I knew what I was purchasing, but people who see me wear or use the item later are confused, and you always have to have this connecting point, and that has some negative consequence for the product. In the counterfeiting context, it's always been, oh, that fake Rolex watch doesn't work very well, so that says negative things about Rolex. Okay, maybe, but in this case, this is a lot harder argument to make in the context of edibles. That I'm really seeing somebody eat an M&M, and therefore that makes me less likely to buy M&Ms in the future because I see them get high from it. And that's a very attenuated argument, but it is the basis of liability in these cases. When all parties at the purchase point acknowledge they knew what was going on. So I think one of the places where I've suggested where we need a little more development is disclaimers. So one way to solidify that a little bit and maybe have some more standardization is to say, well, there's got to be some clear message to the potentially post-sale confused, walking zombies, the post-sale confused. You know, if we can have some clear statement or clear indication to them that could be that could be assessed, that might be a way of saying we don't need to do all the complicated analysis about whether or not post-sale confusion is likely to happen, what the effect is going to be, the breadth of the effect, that sort of thing. So, but that's a really good question. So I think the short way of saying it is very underdeveloped, yet it is an absolutely integral part of liability in these cases, and so it needs to be developed.
So we're almost at the end of the panel, but I have one question, which I know we don't have enough time to really get into, but I kind of want to close on it because it also sets us up for the next panel on registration. And that is to ask each of you in closing to anticipate how enforcement has an effect on the strategic choices that parodists and other expressive users of marks make about what trademarks to register. And so in particular, for me, in the Elster case, it sort of raised this issue because it's almost like we know Trump isn't a party in the case, right? But it's almost like, doesn't he actually come out better off if the mark is, if he gets the mark, right? There's only one person to criticize him, whereas if it's not registered, you've got the whole world using, potentially.
And if I could
using
just
it building
jump on that,
businesses.
if Simon Tam really wanted to reclaim slants, the same holds true for him, right? Much better that everybody is using slants than just him. If the real objective was to reclaim slants. I have an easy answer to your question, and that is that lawyers should counsel their clients not to register parodies, even though parodies have been successfully registered. So that is to say, that the TTAB has been able to sort out parodies and find them not to be confusing. And so in opposition proceedings, the trademark owners have failed. But for the purposes of the Jack Daniels decision, they should not do that, nor should they label their speech with a little tag with the parody on it, because then if they are in a jurisdiction that will apply Rogers, then they're barred from Rogers.
Yeah. I would agree with that. And that's potentially problematic because there's a copyright case where a theater had done a live version of Point Break, the famous Keanu Reeves joint. And they cast a member of the audience from Keanu Reeves to get the authentic, terrible delivery of dialogue. And somebody else decides to do the same show. And the first users claims, we have a fair use argument against the potential the copyright owners in the Point Break movie. And because it is a fair use, then our derivative is authorized and protectable. And at least at the first jump, a district court said, yes, that the first Point Break is a protectable derivative because it's a fair use. That does leave, I think, space where parodies perhaps spread widely. Perhaps mimetically, that's appropriate, that the parody should spread widely. I guess one difference I'd say about Simon Tam from both the Brunetti brand and Elster is I do think Tam really did need a registration, at least in this context, which is if you want to work with a record label expects the band name to be a registrable mark. Elster doesn't need that. Brunetti doesn't really need that. Tam probably did. And that's the one wrinkle I would add there, just because of the music industry.
That's an interesting wrinkle that on the Tam point that I had not thought about. I also want to point out that Elster is a lawyer. And so, maybe lawyers shouldn't have themselves as clients, but that being said, I think you're right. Don't register them. They should be free for all. There should be a free for all.
I think I would add to that too, though, that, keep in mind I think there's a distinction between branding versus registering a mark, right?
That's
So
true.
I think there's a utility in branding. So you kind of, don't forget that in the Warhol case, one of the things that wasn't, ultimately successful, one of the arguments that judges kept entertaining was, well, one of the reasons I think this is a fair use is it's a Warhol. It's clearly transformative because look, it's a Warhol, which we know because Warhol was such an amazing brander. I was actually just at the Warhol Museum last week, and they actually did have the Prince paintings there for a while, so they're still around. And I think you could say the same for the Tam case, right? I mean, the fact that that the band and Simon Tam himself probably gets more out of just branding the slants as opposed to registering it and using it exclusively. So I think there is a distinction, but it's important to keep in mind that they need to be disentangled.
All right, well, join me in thanking the panelists.
Hey, everybody, we're going to take a 15-minute break. We're going to pause the recording and we're going to come back at 11 o'clock for our next panel on registration. Thank you all.
Actually,
Yeah, I guess so.
Okay, everybody, we're gonna get started in just a minute. Thanks to everybody on that terrific first panel. It was really wonderful to get us started today. I'm going to be turning it all over to the cyber realm, where Ed Timberlake, who is going to be moderating our next panel, is going to be taking things on from here. So Ed, are you with us and ready to get going?
Yeah, can you hear me okay?
We can hear you just great. Thank you.
Dynamite. All right, we're at time, so I guess we'll go ahead and get started. Okay, so the next, we started with the focus on enforcement. The next piece here that we have has to do with registration. And since this is a case that's primarily focused directly on registration, this is going to be the most exciting panel and the best part of the topic. Just to sort of situate us a little bit, under the heading of, since this is called New Constitutional Limits on Trademark Law, it's worth just noting, I mean, we talk about this now as if it's all completely normal and we understand it and it's taken for granted, but not that long ago, talking about the First Amendment in a trademark law and a trademark registration context would basically have been crazy talk. So I think it's okay to acknowledge that this is a fairly dramatic change. And I believe one of the earlier moderator mentioned of what's going on through a number of these cases. I think we can also just frankly acknowledge that. Okay, another grounding principle is that trademarks are one thing, trademark registrations are a different thing. So this isn't a matter of, like a number of the other cases, is not a matter of somebody having trademark rights or using a trademark. This is specifically the entitlement to registration of a trademark. Now, obviously, registration comes with a lot of benefits. We love those benefits, but it's not the case. We shouldn't conflate that to say, well, a refusal of a registration is the same thing as not having a trademark. That's not the case here. Also worth noting, this is an application for registration of a trademark, and this application is still on a 1B basis. So there is no evidence of record that this mark is being used. We know, we can look out in the world and see it being used, but on the record, the use of this mark has not been addressed. So I think that can be a significant factor to keep in mind. Let me see. Okay, so we will make every effort to say trademark when we mean trademark and to say registration when we mean registration. All right, so we our four illustrious panelists. We have Professor Lisa Ramsey, we have Professor Samuel Ernst, Professor Michael Goodyear, and TTA blogger extraordinaire John Welch. And I think we'll go in just about that order of speakers. Professor Ramsey is joining us from the University of San Diego School of Law. And it's just worth pointing out that Professor Ramsey was writing and thinking and asking really interesting questions in this area before this was really even talk about this. When she was pre-TAM, she was already talking about these questions. So it's way ahead of all of the rest of us on these matters. She's a member of both AIPLA and INTA, and she's been both in private practice and had, I believe, enjoyed a clerkship as well before joining the Academy. And I would recommend highly that you all go check out her very lengthy list of publications and other material at her website, lisapramsey.com. So take it away, Professor Ramsey.
Thank you for the introduction. I will share my screen. All right, so the title of my presentation for you today is Trademark Registration Laws and the First Amendment. And I want to thank Peter and Ed and everybody at the University of New Hampshire for inviting me to speak with you today. So I watched the oral argument in Elster Live, like a lot of you, and was pleased to learn that the court was finally paying attention to the fact that a trademark registration can chill speech. and that it actually might chill speech more than the denial of a registration. So my prediction, which is the prediction of a lot of people, a lot of professors and attorneys that I've seen on social media, but also news reporters, is that the court will find that Section 2C is a viewpoint neutral law that does not restrict speech. The big question, as noted on the earlier panel, is what doctrine, if any, will the court use to determine whether Section 2C is constitutional? And I'll get to that point in a second. But first, I want to take us back to the earlier cases. We all know, right, back in 2017, that in the Tam case, the Supreme Court held for the first time that the First Amendment applies to trademark law. As Ed notes, I've been writing about this for 20 years. And so it was an exciting time for me that the court finally acknowledged this. However, I was conflicted about this case. I had actually written an article after the Federal Circuit decision called A Free Speech Right to Trademark Protection, where I noted that a registration actually can stifle speech more than the denial of a registration. But as noted by some folks earlier, Tam had said he could not get a record deal without a trademark registration. And what was interesting about the Tam case, right, is that you have an 8-0 decision where the court basically equates the denial of a registration with a speech restriction. If you read the opinion, there's a lot of language about the fact that the First Amendment prevents the government from restricting speech. And I was very frustrated that the court didn't acknowledge that a registration can also chill speech. And so what was interesting is after Tam, we see in Brunetti that the court follows the decision in Tam, right? In Tam, right, we have the court finding the ban on registration of disparaging matter to be an unconstitutional regulation of speech based on its viewpoint and striking it down for that reason. And then in Brunetti, the court follows this approach and finds this law banning registration of a moral or scandalous matter to be an unconstitutional viewpoint discriminatory law. But you see a couple of justices breaking away from this approach that a denial of a registration causes First Amendment problems, right? You have 3 justices, I believe it's Roberts, Sotomayor, Breyer, noting that Brunetti could still use this mark, right? And saying that it actually would be okay for the government to ban regulation of certain kinds of speech, right? Scandalous matter, highly profane matter, vulgar matter, obscene matter. So what I think is very interesting in Elster, now we have, I was not aware of any justice that seemed to equate the denial of a registration with a speech restriction. So again, it'll be interesting to see what the court does in the opinion. So after Tam and Brunetti, I wrote a paper in the Houston Law Review, which kind of talked about kind of what I call free speech elements or issues to consider in trademark disputes after Tam and Brunetti. I had raised some of these issues earlier in the Trademark Reporter article, A Free Speech Right to Trademark Protection. And I think these issues are going to be relevant in any kind of case where trademark rights might conflict with the First Amendment. So you're only going to see a potential violation of the right to free expression in a case involving a trademark registration law or enforcement law if 1 through 6 is satisfied. Now, first of all, this needs to be government action, right? Not private action in this trademark dispute. So if it's Facebook or some other social media site, Amazon, taking down your speech, right? That's not government action. Obviously, it harms your free speech, but at that point, it's not a First Amendment problem. Number 2, this trademark law has to ban, punish, chill, or otherwise harm expression. As I noted before, in Brunetti, some justices noted he could still use the mark. Before Tam, we weren't really sure if a denial of a registration would create First Amendment problems. After Tam, we know that it did. But again, in Elster, I think the fact that the law is not banning Elster's speech is really important. Next, we have number 3, the trademark law has to regulate expression protected by the right to freedom of expression. In the past, some courts said that trademark laws just regulated economic activity. They were kind of akin to non-expressive conduct. We know after TAM that trademarks can convey messages, right? They can identify the source of goods and services, but also convey political or social messages, describe the products, etc. And that's protected by the First Amendment. If it's not misleading or some other categorical exception doesn't apply, which we'll talk about in a second. Number 4, the expression has to be private speech, not government speech. Obviously, the government can decide it's not going to use trademarks that are disparaging or otherwise problematic, right, offensive. But if we're talking about just regular people, regular companies, and the government kind of restricts their speech, then there could be a First Amendment violation. Next, number 5, right, the expression has to not be categorically excluded from First Amendment protection. So the Supreme Court has said in previous decisions that obscene speech, fraudulent speech, misleading commercial speech can all be regulated by the government and has not subjected those kinds of laws to intermediate or strict scrutiny analysis. There are cases which say if the government's discriminating based on viewpoint, this would not be allowed. That could be problematic. But as long as it's a viewpoint neutral law, then this 5th element or issue, would be satisfied. And then finally, courts, right, the legislature needs to ask whether this regulation would fail the relevant constitutional balancing test. So in the past, in the court's First Amendment doctrine, right, you have strict scrutiny analysis or kind of the most rigorous type of scrutiny analysis for regulations that discriminate based on viewpoint or ideas, right? And Tam and Brunetti are examples of that. You also see strict scrutiny analysis for content-based regulations of non-commercial speech. If it's a content-neutral regulation of speech, it's more, it's different, right? It's a level of intermediate scrutiny that you see the time, place, and manner regulations in Ward versus Rock versus Races. There, you also see intermediate, and so because most trademark laws or substantive trademark laws regulate speech based on its content, the time, place, and manner type of test, intermediate scrutiny test, shouldn't apply in trademark law. But the intermediate scrutiny test that has been applied in trademark law by Justice Alito and 3 other justices in the Tam case is the Central Hudson intermediate scrutiny analysis that's used for regulations of non-misleading commercial speech that concerns lawful activity. Now, Justice Alito and the other justices in Tam didn't say that intermediate scrutiny analysis should be used. The court actually declined to decide which test should be used to evaluate the constitutionality of trademark laws. But what Justice Alito said in the plurality decision is that Section 2A's disparagement clause did not even satisfy intermediate scrutiny analysis. And then you see Justice Kennedy saying that this law was viewpoint discriminatory and was subject to heightened or rigorous scrutiny. And Justice Kennedy didn't actually say what test we should use, if any. And what I found interesting about the Elster oral arguments is it seemed like the court was kind of moving away from these different classifications of different tests. One test that has came up back in Tam, and you saw this on the government's brief in Elster, is this argument that reasonable basis analysis or rational basis analysis should be applied in this context. There's what the argument here is that when you deny someone a trademark registration, this is basically a denial of a certain government benefit as long as you satisfy the certain criteria. But the big debate is whether trademark registration laws are conditions on a government benefit, right? Is the trademark register a limited public forum? And we see a couple of justices do seem to be drawn to this argument that not that it is a limited public forum, but it's like a limited public forum, or that this is a condition on a government benefit. Other justices very much not in favor of this. Justice Alito during the Elster oral arguments made it very clear that he's going to continue to follow the approach on the plurality decision in Tam, that the register is not a limited public forum, that the government subsidy cases don't apply in this particular context. And again, there were 4 justices in Tam that rejected these arguments of the government. You see in Brunetti, again, a couple justices saying that, well, Sotomayor, Breyer, kind of suggesting that maybe this limited public forum analysis might apply. During Elster's oral arguments, too, some of the justices suggested that they might like this approach. But I don't know that I think that a majority of justices are going to adopt that approach. And so I agree with a lot of commentators, professors, right, who who have said, we're not really sure which approach they're going to use in Elster. To be honest, I think there's a good argument for them not picking any of these approaches. My understanding, my husband's a constitutional law professor, and he said in other areas of law, the court has been trying to move away from this categorical, this kind of constitutional scrutiny test, trying to figure out which test works. So finally, one other thing to think about is whether this regulation is void for vagueness. At the federal circuit level, there were arguments that the disparagement clause was vague because it was sometimes difficult for examiners to decide what was and was not disparaging. This argument could be made for so many laws in trademark law, right? Decisions about dilution, even likelihood of confusion. In TAM, the Supreme Court did not rule on the ground did not evaluate whether the law was void for vagueness under the doctrine, but it did note actually that the laws were vague. And so I think this is something that the courts might pay attention to in the future as to whether a particular trademark registration law or trademark enforcement law might be vague. So here's strict scrutiny analysis, here's intermediate scrutiny analysis. I don't think going forward that the Supreme Court's going to apply either of these tests necessarily in Elster. It might, but I think it's unlikely they're going to apply strict scrutiny analysis, even though trademark registration laws do regulate non-commercial speech, right? Where we have political, organizations, religious organizations that obtain trademark registrations. Obviously, Elster is engaging in an expression that incorporates a political message. But I don't think the court's going to require that very high level of scrutiny, which is usually fatal. So if they might say, like they did in TAM, that this law doesn't even survive intermediate scrutiny analysis. But again, I don't think that they're going to find that with regard to Section 2C after the oral arguments. They might if they actually subjected the trademark dilution law to analysis. And I've talked about this in some of my papers, as have others. So what laws, if any, might be unconstitutional after TAM and Brunetti? Well, I think all of those provisions in Section 2C that regulate fraudulent or misleading expression are probably constitutional, right? 2 ways ban on registration of deceptive matter, right? Rules about not registering matter which falsely suggests a connection with people, 2Ds likely to cause confusion, rule, etc. Those are going to be fine. Also, any of those provisions that promote fair competition are probably constitutional. The rules about merely descriptive matter, primarily geographically descriptive matter, matter that's primarily merely a surname, and matter that as a whole is functional. As you all know, some of these can be registered if the applicant can show secondary meaning, and that would further trademark law's source identifying function, but some of these cannot be registered, like matter that is functional. What's interesting is the Trademark Office has increasingly been using this failure to function doctrine to refuse registration of informational or expressive matter, political, social messages that fail to function as a source identifying trademark. Also, there's the ornamentality rejection. Sometimes failure to function can be overcome with proof of secondary meaning, but sometimes not. The examiner's TTAB will sometimes find that some evidence of secondary meaning may not matter. Just because you have an association between a phrase and a certain good or service doesn't necessarily mean that that phrase or maybe that color is serving as a trademark. And I actually think this is the right approach. I think that just being able to show acquired distinctiveness or secondary meaning shouldn't matter for reasons of public policy. Some marks should just not be registered. The provisions that could be, that would might be struck down as, but I think right now, probably not after oral argument, right? The provisions that regulate expression for other reasons, right? And so we need to think about, well, what is the goal of trademark law in this context, right? Section 2B bans registration of flags, coats of arms, other government insignia, symbols. A treaty, the Paris Convention, requires the United States to refuse registration to these types of marks. just because international requires us to do this, that doesn't mean it's going to trump the First Amendment. So there's some cases in other contexts where the court has said that. At the same time, right, we might not want to give one entity or individual exclusive rights to a certain country's flag, right, or other government symbols. So as I mentioned before, registration can itself suppress or chill speech, arguably more than the denial of a registration. So I think, again, after yesterday's oral argument, 2D is probably going to be found fine. As 2C, right, the law banning registration of a name, portrait, or signature of a particular living individual or deceased U.S. president during the life of his or her widow, if that person has not provided written consent. It is true that Elster's proposed mark, right, Trump too small, is critical of President Trump, but the Trademark Office has refused registration of marks that are not critical, including trumpets, and then also Obama pajama for pajamas. You'll hear later from Sam Ernst, you know, that obviously the practical effect is usually that 2A covers many of those uses, and that 2C really only matters if the use is critical. Would agree that that might be the case. But still, if you have, my approach would be is that you have to think about the fact that the registration would give the trademark owner a veto over others' use of the mark in the same way as the registrant. And then finally, Section 2F, as I've argued, others have argued, I do think this law should be found unconstitutional if you apply intermediate scrutiny analysis, but arguably you should apply strict scrutiny analysis here because dilution laws discriminate based on viewpoint. And I have an article which talks about that, the free speech challenges to trademark article. So in Elster, right after the Federal Circuit's decision, I wrote a blog post. So I don't want to go over my time. So just briefly, you know, what I'm very excited about is that the Supreme Court seemed to reject the Federal Circuit's approach here, that which to be arguably the Federal Circuit was just applying the approach in TAM, that a ban on registration was equivalent to a speech restriction. And so I think the Supreme Court's going to step back from that approach in the Elster case. What was interesting about Elster compared to Tam and Vernetti is you have INTA who had supported Tam and Vernetti in their argument that Section 2A's disparagement, scandalous, immoral marks provisions were unconstitutional. INTA had said they were. And then in Elster, you see INTA actually arguing that Section 2C is constitutional, right? It furthers important, government interests in protecting the right of privacy, right of publicity. It's true that Elster would be able to use this political slogan under right of publicity and right of privacy laws, right? But again, he's not trying to get the right to use this phrase. He's trying to register it and stop others from using it. So I think the fact that INTA supports the government, I think the fact that you also have Public Citizen had some great arguments in its amicus brief about the kind of chilling effect of a registration and kind of the implications of registering political messages. So again, I do think that the court's going to rule for the government. So the question is, how are they going to do this? How could they do this, right? So they can walk back the points they made, with regard to 2, right? That the fact this chilling effect of the denial of a registration, maybe just say that's just not as important. Again, the question with regard to my element 6 is which of these doctrines might they use to determine this law is constitutional? Again, I don't think they're going to use strict scrutiny analysis. Perhaps some of the justices will use intermediate scrutiny analysis. Some will use this reasonable basis or rational basis test and find the trademark register is a limited public forum. Here's what I think is I think the court should just kind of focus big picture on the goals of trademark law and whether this law furthers those goals and what the implications might be for freedom of expression if we enforce this trademark law. So here's my proposed constitutional test for trademark law. Number 1, identify the goals of this specific trademark law that are important government interests, right? Not the goals of trademark law generally, but this specific law, right? Does this law prevent fraudulent, deceptive, or misleading speech? Does it promote fair competition? Does it facilitate the communication of source identifying information? Does it promote the rights of publicity, the right of privacy? Once you identify the goal, then you confirm this trademark law directly and materially furthers those trademark goals. And then finally, identify how the trademark law endangers free speech and ensure the law does not suppress or chill protected expression more than necessary to further those goals. And I've made these kinds of arguments back starting in 2008, my Increasing First Amendment Scrutiny of Trademark Law article, the Houston Law Review article, Free Speech Challenges to Trademark Law. And then briefly, Christine Farley and I mentioned, these issues in our recent paper. But with regard to 3, that's where you would do the work of, for example, in Elster. Sure, you would consider the harm to free speech of denying Elster registration, but you also have to consider the harm to free speech of registering the mark and allowing Elster to veto use of the mark in the same way as him in other contexts. So that's my presentation. I think I don't know if I'm close to time or not, but I'm going to leave it to others to speak now. And I look forward to your questions later.
Thanks very much, Professor Ransey. Yeah, we're doing perfect on time, and we will get to the questions for everyone one time all the way at the end. So we'll move to Professor Samuel Ernst, who is joining us there from Golden Gate University School of Law, where he's Associate Dean and Professor of Law. He's published extensively on issues of innovation, policy, consumer protection, freedom of speech, the courts, and legal history. He's also, before joining the academy, he was in private practice and also enjoyed a clerkship. And if I'm not mistaken, wrote an amicus brief in this case. And I'm wondering, you can go in start wherever you want, but I'm wondering if you could say specifically, since Professor Ransey brought up some of the levels of scrutiny, I'd be particularly interested to hear your counter take on that.
Absolutely. Thank you, Professor Timberlake, and thank you to Professor Carol and to Dean Carpenter, and may it please the court. Yeah, when I boarded my plane in San Francisco, I was fully prepared to come here and argue why the Supreme Court would strike down this statute. And then I got on the plane and I saw, oh, they have Wi-Fi. That's nice. And let me download the transcript from the oral argument. And now I'm here to say that Professor Ransey is correct in her assessment of the case. And I'm just wondering if it will be 7-2, 9-0. What will it be? But I don't want to go down swinging. And also, I didn't want to rewrite my entire presentation. I wanted to watch the movie as well, but I rewrote it a bit. So I'm going to give you the argument as to why it should be unconstitutional and why that would not be such a bad thing for the world. All right, so the difference between, and I'll get to the level of scrutiny very shortly. Difference between 2C and the provisions at issue in Tam and Brunetti is, of course, that 2C is, as a technical matter on its face, viewpoint neutral. PTO denies registration whether or not your mark praises the famous person or ridicules, criticizes, parodies, or is neutral. It's a content-based restriction. However, meaning that the speech is burdened by the government based on the subject matter being discussed, here the famous person. And that will be the critical difference here. But there is a strong argument that the provision results in de facto viewpoint discrimination, because presumably a politician or famous person would only consent to marks that praise themselves or at least neutral about them, if they would indeed consent to those marks. And of course, they can themselves and do register marks that praise themselves. So I looked at the trademark database. Donald Trump has over 100 trademark registrations, most of which, all of which, not all of which, but most of which identify him in some fashion. And I didn't see any that criticize his policies or his characters or the size of his body parts. The Trump organization has over 60 trademark registrations, including many that identify Trump, some that are political slogans, Make America Great Again. And you guessed it, I didn't find hardly any that criticize him. So the presumption is very strong in this case, in particular, that he would not give his written consent to a mark that criticizes him. And for this reason, there's likely no consumer confusion when we encounter a mark like Trump too small that does criticize him. So 2C results in this regime that has the effect of allowing for a large body of marks, identifying or naming politicians that complement them, and very few or none which criticize those politicians. That's de facto viewpoint discrimination. That should be troubling. That's a heckler's veto. That's at the core of the First Amendment. Now, we heard questions from Justice Jackson twice asking about that and asking for the argument from Jonathan Taylor as what, let me hear your argument about this viewpoint disparate impact of the law. And she pushed counsel for Elster on this early and late in the argument. All right, so nonetheless, conceitedly as a technical matter, it's indeed viewpoint neutral, but it's a form of content discrimination defined simply by the topic of the covered speech. Some cases say that a court must apply strict scrutiny to a content-based speech restriction, even one that's viewpoint neutral. The question has never been answered. Are trademarks commercial speech? Are they speech that does nothing more than propose a commercial transaction under which they would fall under central Hudson? And there's a strong argument that whereas they once might have been mere symbols and words to distinguish goods and services, they've morphed, for good or for bad, into something far greater: intellectual property, brands that convey social and political meaning, for example, Nikes and Just Do It. Nonetheless, the court has shied away from answering that question. As Professor Ransey pointed out, the government, believing that it might lose under central Hudson, argued for reasonableness review, not rational basis, but something a little bit stricter than that. Reasonableness plus fit, meaning it's not just any rationale that anybody could dream of when they're writing an opinion, but did the government have a reasonable purpose, and is there some fit? And a lot of members of the court seemed open to that possibility. We know Justice Sotomayor is, Justice Kagan hinted at it. Justice Kavanaugh asked, what really is the difference? Why do we care? Central Hudson or reasonableness, right? And this harkens to Justice Breyer's dissents that say we shouldn't have these rigid categories because we just pick a category according to the outcome. If we want to invalidate it, we pick strict scrutiny. Otherwise, we pick something lower. All right. But I agree. I think they're going towards this reasonableness. Okay. The arguments as to why they can apply this lower standard of review, we thought had been either rejected in the previous cases or at least by 4 justices. So the first argument, the denial of trademark registration does not outright prohibit speech. Of course, the argument in favor of it burdening speech is a speech-related argument. It's that there are such substantial benefits to trademark registration that you all know about, that no rational business would choose a mark that they couldn't get a federal registration for. That's the speech-based argument. Nonetheless, we had Justice Sotomayor calling this into question, as several justices saying Elster can still say Trump too small, he can still put it on t-shirts, except for Justice Barrett, who said, well, but not if Trump registers the mark and wants to use it in commerce in some limited degree, and could prohibit him from saying it and prohibit others from saying it in commerce. But even Justice Thomas raised this issue. He can still use the phrase, he can still put it on t-shirts. And so they might adopt that reasoning and walk back Tam and Brunetti, even though that didn't seem to have too much to do with viewpoint discrimination per se. The argument that registrations are government subsidies or benefits. The government, sometimes you apply lower scrutiny if the government is withholding a benefit in a content neutral way for speech. We know that 4 members of the court in the Alito opinion and Tam rejected this. One of those was Justice Breyer, who's left the court. But in any event, the court said that those cases usually involve money. But again, here, Justice Sotomayor, Justice Kagan seemed attracted to this argument. Probably Justice Thomas and Alito are skeptical. Justice Alito announced that he was not going to buy this, I believe, and Gorsuch seems skeptical. The argument that it's a limited public forum for government speech. In some circumstances, the government can create a speech forum. So the Lanham Act is some sort of speech forum, and then they can regulate in a content neutral way. This is sort of mixed up with the government speech doctrine. We have a park where you can have monuments and they can be restricted to a particular topic. All 8 members concurred in TAM that trademarks are private citizen speech on a multitude of topics. It doesn't create this kind of forum. But here again, some justices seem to raise this again. Kagan strangely raised this again, and Kavanaugh hinted at this. Justice Alito then brought a wild card out of left field, which was a very bad moment for the Ulster team when he said, couldn't I uphold the law under San Francisco Arts and Athletics Committee versus the US Olympic Committee? He asked the government that question. And he also asked the government, he said, what should a judge or justice do in a case in which the issue is the constitutionality of a federal statute and the jurist thinks it might be constitutional under a theory other than the one advanced? And then he cited to this case, to which the government should have said, yes, you can do that. And that case is, I haven't read it, but it's on all 4. Yes, it supports our argument. I don't know why the government lawyer didn't do that, this being his 100th argument, but he didn't do that. And in that case, there was a statute that said the US Olympic Committee had the sole right to the word Olympic. And the statute required no likelihood of confusion or dilution, but the court reasoned that the Olympic Committee had invested substantial resources and time into developing the distinctiveness of this valuable word, such that it would have been reasonable for Congress to presume that the use of the word Olympic in these contexts by others would either cause confusion or dilute the distinctiveness of the mark. And presumably, if Justice Alito believes he has the power to write an opinion, I don't know why he wouldn't, right? Marbury versus Madison, you can come out of left field and write opinions, of course. You're a Supreme Court justice, right? Maybe we'll have an opinion under this case. All right, and then you had this but questions from Justice Gorsuch. And he said to Justice Kavanaugh, you and I are on the same page with this, that it protects the quasi-property right in one's own name. And isn't that, those are Justice Kavanaugh's words. And where do we find this? He said it's firmly rooted in history. A troubling phrase we've seen in notorious recent opinions, right? Firmly rooted in history, nowhere, not firmly rooted in the briefs or in the record, but somewhere, something he's pulling out of his hat, or it's firmly rooted in history that you can't trademark somebody else's name, all right? And Mr. Taylor for Ulster said, well, we have another provision that you can't trademark something that's primarily merely a surname. So maybe that's already covered, but this is somebody else's name. It sounds to me, I'm not sure, a little bit like the right of publicity, right? And so does the Olympic case, insofar as you've built up value in this name, you have some right or some sort of moral right in your own name. If it's the right of publicity, then my argument is that this statute is too broad. It's not a good fit to advance the purpose of the right of publicity. Whether it's reasonableness plus fit, it's not a good fit, or whether it's Central Hudson, it's not tailored. And that's because every state that has a right of publicity has some First Amendment defense, right? And balances it against the First Amendment interest. Is this parody? Is this political speech? right? And scholars have criticized these tests as providing insufficient protection for free speech, but the PTO's ban on registration of a famous person's name has no check, no First Amendment check. It takes no countervailing interests into account, whether the mark would cause consumer confusion, going to Jack Daniels, whether it would cause dilution, whether it suggests a false connection. It couldn't. There's other provisions that handle that, whether there's unjust enrichment, whether it constitutes news or political commentary, parody, entertainment speech, indeed without considering anything except for, does this mark communicate to consumers and identify a famous person? And is there a consent on the record? Surprise, no, Trump has not consented to the registration of a mark that calls him, his policies and his person too small. All right, and that's disturbing in the case of a government official, because Trump or Biden or Obama have this veto power, allowing some speech to be registered and other speech not to be registered, right? And moreover, famous politicians can register their own names. So the right of publicity is not a good fit, if that's what Gorsuch and Kavanaugh were getting at, or if that was the best justification given by the government below. All right, now, does this restriction serve to protect free speech? As many have argued, because you're giving a registration. And this came up in argument too from the Chief Justice. After all, the Supreme Court's granting a First Amendment right they're giving a First Amendment right in an intellectual property right of exclusion to prevent others from using the same political speech in commerce in a way that would likely cause confusion. And we had that concern in Tam and Brunetti as well. But to the extent protecting free speech is the purpose of this statute, and it's not at all equipped to achieve that purpose either, because the statute only prohibits people other than the politician or famous person from registering the mark. The politician herself can register their identity in a trademark, and they can give consent to other people registering their name as a trademark complimentary of the politician, a trademark criticizing the politician, right? And the Lanham Act allows the registration of a wide array of political and social commentary by anyone, so long as they do not identify a famous person without their consent. And so #MeToo for lipstick has been registered. Make America Great Again for various clothing and goods and services. Black Lives Matter has been registered, right? These are limited rights of exclusion. Section 2C does nothing to prohibit this. And in fact, it exacerbates the free speech concerns because it creates this de facto viewpoint discrimination, as I've pointed about, where you have all these marks registered that are complimentary of Trump, and you can't get one registered that criticizes him. So no, it does not protect free speech to retain this provision. This issue does implicate the broader critique of the Supreme Court's First Amendment jurisprudence. At least I think they might be getting away from this, as Professor Ransey pointed out, and as Justice Kavanaugh indicated. Well, why does it matter what category or what box we put it into? But in the past, they've often dealt in these rigid categories that don't consider such things as how giving private rights to the speaker affects the quantum of free speech in society, or how it affects the free speech of others, people other than the litigant. For example, in Citizens United, when the court said a corporation must have no government regulations burdening its right to engage in political speech or spending, it failed to view the broader context of how this unfettered right burdens the ability of less moneyed and powerful speakers to have their voices heard, hence resulting in less free speech from less viewpoints. Or in Boy Scouts of America versus Dale, the court decided the First Amendment rights of the Boy Scouts organization were violated by a New Jersey public accommodations law requiring it to, or that had required it to rehire a gay scoutmaster that it wanted to fire. So it had the First Amendment right to fire that scoutmaster, but that did not take into account or balance how that restricted the free speech rights of the scoutmaster to say publicly at work who he was. So the court has not considered the effects of its rulings previously on the quantum of free speech in society. So when they have said in Tam and Brunetti that the court must grant a trademark registration to protect the right of private speakers from having his speech burdened, they have failed to take into account that grants an exclusionary right. And often this favors moneyed property interests over the creation of a free speech community, people who have the know-how and the savvy to hire lawyers and register their marks. So all of this has been far too formalistic. Maybe we're starting to go away from that, as Justice Breyer often asked the court to do. For example, in his Brunetti partial dissent, he said, rather than deducing the answers to the First Amendment questions strictly from categories, as the court often does, I would appeal more often and more directly to the values the First Amendment seeks to protect. I would ask whether the regulation at issue works speech-related harm that is out of proportion to its justifications. So again, Professor Ransey, Lisa is correct, right? That would probably be a better test, but I would submit to you that Section 2C would survive that test because, as I said, it works First Amendment harm by creating this de facto regime. And as Public Citizen and others have pointed out, there are other avenues, legitimate trade-related, trademark-related avenues for the court to police marks that are primarily political. For example, the failure to function doctrine. And this came up in argument too by counsel for Elster as a reason why we need not be concerned with registration impinging on free speech. When consumers see a commonly used political slogan on a t-shirt, they do not think that it is indicating the source of the t-shirt, the quality of the materials, etc. We haven't seen Elster, or maybe we have seen Elster's specimens. Professor Roberts was saying she's seen some, right? But how does it appear on the shirt? Does it appear on the tag? Is it used in a trademark way? So the PTO can use that legitimate vehicle to decline to register marks that are being used to inhibit political or social commentary. But Section 2C does not serve that purpose. They don't ask about failure to function. It would deny registration to many marks that do function as trademarks, and it would allow registration of many marks that do not function as marks. And so this is a red herring with respect to that provision. And the Lanham Act already gives the PTO this power. So I'm going down with a fight and saying, we don't need Section 2C. We don't want Section 2C. Thank you very much.
Thank you very much, Professor Ernst. Now we'll hear from Michael Goodyear, who's acting assistant professor at NYU School of Law and a fellow at the Engelberg Center of Innovation, Law and Policy, also at NYU. Michael's research analyzes the potential of copyright and trademark law to spark and stymie technological and cultural change. And he also studies the impact of copyright and trademark law on underrepresented populations. So thanks for joining us, Professor Goodyear.
Thank you for having me. And thanks to Peter and Megan and UNH, Franklin Pierce, for hosting this great event. So the initial setup for this is a bit different in the wake of Wednesday. Thinking that, like Sam, 2C would not survive whenever the Elster decision comes down. Seems it's not going that way, but wanted to keep the same slides and the same analysis. What would happen to registration if 2C was struck down, and how much of an impact would it actually have? So we can't predict the future entirely, but we can look to what has happened in the past with the prior two decisions that struck down portions of Section 2C, or sorry, Section 2, namely the disparaging and scandalous and immoral bars. So those decisions, Tam Brunetti, Tam removed the disparaging bar, Brunetti the immoral and scandalous bars. But when they came down, there was quite a bit of concern about what would actually happen, and that the worst terms in the American lexicon would flood the trademark register. In particular, scholars and the public were concerned there was no consideration of motive. So you have individuals like Simon Tam and the Slants who are trying to reappropriate the mark that was historically used to disparage Asians and Asian Americans. At the same time, someone who's trying to use it in a hateful way could also register the Slants or any other mark. In particular, this is an issue due to, as Sam nicely had with the image, the political cartoon on his slide, large corporate spending or large spending from those with power could flood the marketplace. And those who already have power would largely stay in power. This is particularly an issue with what I've termed the marketplace of odious ideas, where the idea of the marketplace of ideas, where we have an open forum, the best ideas ultimately win out, is somewhat problematized both by the issue of the powerful flooding the marketplace with their own speech and trying to particularly encourage hateful speech, as well as online filtered bubbles. So in the age of social media and online, it's much easier for people with minority viewpoints that might be troubling to different minorities, whether racial, LGBTQ+, gender, et cetera, are able to find like-minded individuals and keep those more hateful viewpoints alive. So a variety of studies were undertaken involving the disparaging and scandalous immoral bars, several of them prior to, including one by Carpenter, as well as Barton Beebe and Jeannie Frommer at my institution, NYU. But there have only been 2 studies done post-Brunetti at the Supreme Court. The first of those is by Vicki Wang in the University of Illinois Law Review called Trademarks, Race, and Slur Appropriation, where she examined what the effect of Tam and Brunetti were on racially oriented trademarks, particularly race-based slurs. And then I have a forthcoming article also in the University of Illinois Law Review on queer trademarks, looking instead at how queer or LGBTQ+ related slurs have been used both prior to and post-Tam. So looking at Vicki's study first, her study looked at 6 different racial groups and slurs that have been used against them: African Americans, Native Americans, Native Hawaiians, Asians, Latinx, and Jewish individuals. In total, she found 312 trademarks that were implicating these various slurs across an entire 10-year period from January 1st, 2010 through January 1st, 2020. And just for reference, Tam was decided on June 19th, 2017. And she found that the actual impact on applications was relatively negligible. So if we see here, we go to 2017, Q2 and Q3, since Tam was decided right on the cusp. There is a little bit of a bump there, but we also see several spikes throughout the 10-year period. There's nothing to really suggest that Tam caused a huge difference in the number of applications, let alone registrations, which Vicki's study does not get to. She was also evaluating how many of these Reddit applications were from in-group members, so those who would identify as Asian or African American, et cetera, and those who were out-group members who do not identify as that. So through looking at the trademark applications, the specimens, their online presence, she was able to determine 92% of the races of the applicants, since the USPTO does not keep this data and publicly release it. And she found that overall, even though we were worried about these uses where individuals would be using them in hate-filled ways, trying to disparage, by and large, the number of in-group member uses or reappropriative uses increased post-Tam. But the actual effect on applications overall was relatively minor. At the same time, from 2010 through 2020, the number of applications in general increased almost twofold over, while the number of racially oriented trademarks kept or stayed pretty consistent. So in terms of absolute numbers, the number actually decreased. But she found some differences in the specific trends for individual racial groups. So especially for Native Americans, if you think of sports teams, to go back to Dan's point on sports earlier in the day, Native American marks across the entire period were still used in these disparaging ways by out-group members. But In other groups, particularly African-American and Latinx populations, the numbers were increasingly being used in a in-group way to reappropriate the slurs. And here we can see what happened just post-TAM. So the trends that we saw on the prior slide are somewhat exaggerated. We're seeing even more reappropriative uses by African Americans. We're seeing some reappropriative uses by Native Americans, but still a large number of outgroup uses. And Vicky found that these trends were likely this way for two reasons. One, failure to function that we've heard so much about. So you're not necessarily going to use a terrible term against a Native American individual or an African American individual as a source identifier. You're more using it as a sort of symbol or ornamental use, and also a lot of consumer pressure. So scholars such as Deborah Gerhardt and John Lee have written about this, where with racially oriented marks, especially since 2020, we've seen a lot of these more historically racially disparaging marks go by the wayside. So Land of Lakes, Native American woman, gone, Aunt Jemima has rebranded. And because of this, we're seeing large consumer pressure that would dissuade anyone from trying to register a trademark that is outright disparaging or hateful. My study, on the other hand, looks at LGBTQ plus related slurs. You can see the list of 11 here. I found that 144 trademarks were applied for across the 9-year period I looked at. So 4.5 years prior to TAM, 4.5 years post-TAM. And you see there was a pretty large jump in the number of applications post-TAM for LGBTQ plus oriented marks. The number of registrations also increased in absolute numbers, but in relative numbers, it actually is a little bit lower. Pretty large portion of these are still intent to use or still pending before the USPTO. So that number could increase, but we're not seeing a huge jump in registrations. And just to make it clear, we don't have a single spike like we were having in Vicky's racially oriented slur study. Instead here, the number of applications has continued to increase since TAM. The registration number dropping off in 2021 is just because those were recently filed. And the results from my study were that of the 114 trademarks that I was able to determine the intent for, they were bona fide reappropriation attempts. And out of the others, the intent was indeterminable. There just wasn't much intent, period. Many of these were filed as intent to use, so there wasn't much of an online presence, if anything. Occasionally, they would have a social media page, often defunct. So I was unable to determine for the 29, the 114 were bona fide reappropriation attempts. Not a single one, at least on its face, tried to disparage LGBTQ plus individuals. Instead, all the ones that identified were either by or for the queer community. And here are two examples of the Queer Agenda, playing card game, and the National Queer Theater. And in my paper, I posit there are 4 main reasons for this trend. So one, if we look at increasing rights, there's often a history of once civil rights improve for a marginalized community, there tends to be more activism and more pride in trying to reappropriate terms. That could easily be happening here, especially after the recent spate of Supreme Court cases improving LGBTQ plus rights from Lawrence v. Texas in 2003 through Bostock just a few years ago. If you look at the history of the use of queer trademarks, it's also quite different from racially oriented marks. We don't have an Aunt Jemima for queer individuals. Instead, queer topics were largely taboo for much of American history. No one would want to be associated with them in any light, let alone a positive light. And failure to function comes in yet again, where if you're just trying to have a particular message, that will likely not function as a trademark. So saying I hate queer people, that would not function. And finally, limited commercial appeal. Presumably, if you're using this as a trademark, you would actually like to sell the stuff you are making. And if you're just having a hate-filled message, that's going to be a lot harder to do, even if it might have some appeal for a minority or very small group. So what does this all have to say about Elster, the case that we're here for today? So at issue in Elster, as we've seen throughout today, Section 2C is the provision at issue. If the Elster actually overturned it, which seems unlikely, it could either be trying to get rid of it wholesale, or just trying to carve out and say that criticism of a government official or public official is okay for registration. So if we look at the tea leaves that come from the Tam Brunetti studies, I think there are three particular things that we should look at. The history of critical marks, the legal infirmities therewith, and finally the commercial appeal of them. So with the history, we don't really have a history of using critical marks at all from what I've determined. We don't have strong marks like Aunt Jemima or racially oriented marks. It's also not entirely a taboo subject like queer marks. So we should consider the history of, if we didn't need these historically, why we necessarily need them going forward. On the legal infirmity side, there's a big difference between using a critical message in an ornamental way, such as the "Let Us Turn Up the Beat" t-shirt, and actually using it as a source identifier. So Mark Lemley and Mark McKenna, the Marks, recently had a article that's coming out in the Stanford Law Review where they discuss certain placement of trademarks on products, such as hang tags, which came up in the Jack Daniels case, which of course we have an example of in the room. And there's a big difference between just generally having the message "Trump too small" on the t-shirt and trying to use it as a brand for a wide variety of products in a way that would be interpreted as such. There's also a big difference in how we're actually using these. So when we think of political slogans, Hillary for America or Joe 2020 are actually a source identifier. And that we think of Hillary for America is from the Hillary Clinton campaign, Joe 2020 is for the Joe Biden campaign. We're not, and they both are registered as well. We're not really seeing registrations for political criticism, however. So we don't think of these as Stop the Donald or Hillary for Prison. These aren't source identifiers in the same sort of way. They're critical messages, certainly of individuals, but we're not really thinking of them as originating from a source and would seem to fail to function as proper trademarks. And in fact, when I was trying to look through the trademark register, there were very few examples that seemed to have any real criticism of individuals. One of the few examples that I found that could potentially qualify is for Fuck Jerry. So F Jerry LLC owns the trademark to Fuck Jerry, which is a online media conglomerate. Looking at the backstory for the Fuck Jerry mark, supposedly the originator of it thought of the idea when he was watching an episode of Seinfeld, claims that it's an homage to Jerry Seinfeld rather than critical. I'll leave it to you to determine what the message here would possibly mean. But interestingly, the trademark application and registration say nothing about criticism or really Jerry Seinfeld at all. So potentially up to you whether this was an error in the decision or whether we just really don't have these types of critical marks. In addition, we have several other problems that could come up, including Section A and Section 2A and Section 2E. Has been discussed earlier today and was also brought up during the oral argument on Wednesday. Right of publicity laws could also potentially pose an issue, although typically criticism has been carved out from those. But overall, this presents even more potential legal infirmities and legal hurdles we have to go over than we're at issue with the disparaging or immoral or scandalous bars. And finally, for the how would these marks actually be used by the public and would they actually serve a certain population? So certainly people have an interest in using critical political criticism in expressing themselves, as the work of Barton Beebe and Sonia Akhtal and several others have shown. There is a semiotic function to trademarks. However, it's more that these individuals would be particularly trying to express this message and not really thinking about the source of the good. So having a Biden sucks or Trump too small shirt is just to express the message itself. It really has nothing to do with the trademark. So in conclusion, with all three of these, it seems that the overall impact of 2C being abrogated would be relatively minor on the registration amount. But considering that it seems like Elster will not come out that way, this is all somewhat academic, as I suppose this is in our conferences, but be interested to see what the decision holds, and I'll turn it over to Ed and to John. Thank you.
Thanks very much. Okay, and finally, I'll introduce John Welch. He's counsel to Wolf, Greenfield, and Sachs in Boston, where he specializes in trademark, copyright, and patent counseling and litigation matters. As many of you may know, he's the publisher of the TTA blog, which focuses on the procedure and jurisprudence of the TTAB. He's a frequent speaker at things like this and presents the yearly review of TTAB decisions at the annual meeting of the International Trademark Association. So thanks very much for joining us.
Thank you, Ed. I'm one of the few non-academics on this program today. I've been practicing law, however, for about 50 years. I did serve as at a law school for 1 year as an assistant professor, but that was about 40 years ago, and Simon Tam hadn't even been born at that time, so I wasn't really concerned with these kinds of issues. I take a view of these decisions, Tam, Brunetti, and Elster, from a practical point of view. For a practitioner, I'm not really concerned about why the decision was made by the Supreme Court. Just tell me what the decision is, and then I'll try to figure out how it changes my practice of law and how I comport my practice to that decision. I have to say, in 50 years of trademark practice, I've never had to file an application for a disparaging, scandalous, or immoral mark. So I think, although the academic exercise of figuring out why this is happening is interesting, to the practitioner, and as I think the statistics in the last presentation show, for a practitioner, these issues are not all that important, you know? But anyway, let's move along. In the Brunetti application, he is trying to register the mark Trump Too Small for the goods listed on this slide, basically all kinds of shirts. He filed an application based on intent to use, so there is no specimen of use in the record, although one can find the shirt online, and this is a picture of it. The trademark examiner refused registration on 2 grounds. Section 2C, lack of consent from Mr. Trump, and Section 2A, false association. Now, both refusals were appealed, and the Trademark Trial and Appeal Board dealt only with the Section 2C refusal. So that makes things kind of interesting. Now, from everyone's point of view, it seems, including mine, the Supreme Court is going to let Section 2C survive, in which case the application is dead. But if one assumes, or for the sake of argument, that the Supreme Court reverses and this case goes back down and the Section 2C refusal is thrown out, the case is going to go back to the board to consider the 2A refusal. Now, I have my doubts that the board will uphold a failure, a false association refusal, because I don't think people, for obvious reasons, will think Trump, this shirt is somehow associated with Trump and his organization. So let's assume then that the Trademark Trial and Appeal Board reverses the Section 2A refusal. So the case then gets approved for publication. Somebody may oppose it. If nobody opposes it and a notice of allowance issues, then Mr. Elster has to file his proof of use. Now, if he files this T-shirt, he's going to have a problem. He's going to have a failure to function problem, because in light of many cases in the last few years, the examining attorney corps is well attuned to the failure to function refusal. And an examiner will likely look at this and say either or both, this is merely an ornamental use, it's not a trademark use, or this is a common theme or a common meme that doesn't serve as a source indicator. I think the second one is a little harder to justify. When you think of these common memes, you usually have to find considerable use of the phrase. For instance, the phrase drive safely. I mean, you're not going to get that registered. That's simply too common a phrase. But anyway, as to if it's a ornamental refusal, it is possible to overcome such a refusal by showing secondary meaning. So it would be interesting to see what actually would happen if this case ever did go back to the examining attorney, but apparently it's not going to get there because the 2C refusal is going to be upheld. As an example of the powerfulness, I guess you could say, of the failure to function refusal, Mr. Brunetti, who was successful at the CAFC and the Supreme Court in getting the Section 2A scandalous provision thrown out of the statute, also tried to register the mark F-U-C-K. I pronounce it Fuke because, you know, there may be children listening. He tried to register Fuke for jewelry, and the board upheld a failure to function refusal on the ground that the word is in widespread use and therefore doesn't operate as a source indicator. So ultimately, I think the applicants who adopt political phrases, common memes, are going to have a hard time at the trademark office trying to get them registered because the examining attorneys will pull out the failure to function refusal. I do want to mention that nowhere in the statute does the phrase failure to function appear. When you talk about functionality, that's Section 2E5, you're talking about utilitarian functionality. Failure to function is a made-up doctrine that doesn't appear in the statute. It's based on Section 1, which says you can register a mark. Well, if it's not a mark, you can't register it. So if something doesn't function as a source indicator, it's not a mark. QED, it's not registrable. But there is, like I say, there is no express provision in the statute that says failure to function is a basis for refusal. There was a case a couple of years ago, not precedential, in which an applicant, actually he was a registrant, he was defending a cancellation proceeding. A man named Roman Atwood, whom I had never heard of, apparently has some following on, I don't know, Instagram. Anyway, he had a registration for the phrase smile more, and it was attacked on failure to function grounds. And he managed to fend off the attack by showing secondary meaning. He showed that people do recognize this as his as an indicator of his merchandise, as a source indicator. So failure to function refusals can be overcome. I think that it's going to be a lot harder to overcome them when they're a political slogan or a common obscenity, let's say. And I wanted to mention the Jack Daniels case because it does have an interesting impact on the Trademark Trial and Appeal Board. In Jack Daniels, the Supreme Court said, as we all know, having had it drilled into our heads for the last 5 hours, when a mark is used as a source indicator, the First Amendment does not demand a threshold inquiry. You just continue with the likelihood of confusion and analysis, and you don't get to the Rogers test. And the Supreme Court also said the district court had it right when it said dilution doesn't, non-commercial use exception for dilution doesn't apply because, again, once you find out the defendant is using the mark as a source indicator, you don't get to that exception. It seems to me, from a litigation point of view, I know this is outside the Trademark Trial Appeal Board or registration realm, but from a litigator's point of view, now that the Supreme Court says if the defendant is using whatever it is as a source indicator, you just go to the ordinary likelihood of confusion test and Rogers doesn't apply, there's going to be a lot of time spent on arguing and trying to prove that the defendant is using whatever it is as a source indicator. So a plaintiff is going to be trying to show in the first instance that the defendant doesn't deserve a Rogers analysis because there's a trademark use involved, which could lead to interesting situations where a plaintiff takes a survey trying to prove that the public recognizes defendants a thing as a source indicator. Of course, in Jack Daniels, VIP shot itself in the foot because it had applied to register the trade dress as a trademark, so it knocked itself out in the first round. But one of the consequences is there seemingly will be a lot fewer cases thrown out on a motion to dismiss or an early motion for summary judgment, because there is a factual question about whether a defendant is using whatever it is as a trademark. The other point I think is worth recognizing is that when the other side or the defendant adopts packaging bearing a parody of a trademark, packaging itself qualifies as a source identifier. So I think right off the bat, the likelihood that the Rogers test will apply is minimized, and you're going to be fighting over the likelihood of confusion test. At the TTAB, the contrary, I have to disagree with Professor Farley. The Trademark Trial and Appeal Board does not like parody, does not side with the parodist. In the sex rod case, the board specifically said parody is not a defense if the marks would otherwise be considered confusingly similar. So according to the board precedent, at least up to this point, you don't even get to parody. You do the likelihood of confusion analysis, and then maybe you look at parody, but usually the likelihood of confusion analysis slams the door shut. The board found sex rod and Red Sox to be confusingly similar, strangely enough. I guess that's what happens when you're wearing the black hat, so to speak, at the TTAB. So the question is, in the future at the TTAB, what are they going to do with the Jack Daniels decision? Jack Daniels says you have to take into account parity in the likelihood of confusion analysis. Is the board going to follow that teaching? Does it have to? It'll be interesting to see, but up to this point, at least up to Jack Daniels, the parity defense got you nowhere at the TTAB. That's all I have. Thank you very much.
Great, thanks very much. All right, we've got some time for questions, and I have one question. I think, let me see if I can do this. Yeah. So one question I had is just has to do with I believe our Dean Carpenter started us off with an observation that sometimes when there's a change in these provisions, things still end up being refused. They just will be refused on maybe different grounds. It sounds like there's a lot of feeling that this provision won't necessarily be struck down, but I think it's still an interesting question about if this, when this comes in to the U.S. Patent and Trademark Office, what the various grounds might be. I mean, the notion is that when something gets examined, that if there's a need for an office action, it should be a complete. The first office action should be a complete, examination and be a complete office action. So we've seen that initially here, I believe it was refused under 2C, and then later, upon continued review, I guess they added in 2A, which is all appropriate. There's nothing procedurally wrong about that. And until you don't have a registration until you have a registration. And so at any point up until registration, if the office finds that a filing is inconsistent with the statute, they don't have to put it on register. But I'm just a little bit curious myself, when I look at these two, if I see an application for registration coming in for Trump Too Small as a trademark for t-shirts, and there's a live, registration owned by Trump for Trump, this looks exactly like the kind of thing that would just typically be refused as under 2D for likelihood of confusion. I wonder if anybody has any thoughts on that aspect of this case, whether that would matter or seem significant.
I think, Ed, that's water over the dam. It didn't happen. I mean, maybe it should have happened, but it didn't happen. So it's kind of a moot point. I do want to make one mention about the Trump too small specimen of use. And in the initial examination, when the examiner looks at it, I think the examiner is hesitant to make a failure to function refusal until you see the specimen. So there's no specimen. So once the specimen comes in with the statement of use after the notice of allowance, then the examiner looks at the specimen and then he says, okay, this doesn't function as a trademark. I wanted to make that clear.
Yeah, and I think that if I can share one more piece, I believe, yeah, this looks like the website that is currently selling. So it seems like they have a range that certainly this placement, if this were the only evidence that were submitted. Now, no evidence of use has been submitted, but if this were the only evidence submitted, that looks like an ornamentality problem. But it does look like maybe there's an effort to show like, hey, look, we're doing this in a traditional trademark space. And certainly here on the website and in connection with the sale. I think it complicates the matter a little bit.
Yeah, well, there is a case where it's the I Love DC case or We Love DC case, in which that phrase was put on the hang tag and the board said, sorry, that's still not good enough. It's still just a common meme. So putting on the hang tag isn't going to help. I think that does raise an interesting question is what would be a trademark use of that phrase? If putting it on the front is not enough, if putting it on the hang tag is not enough, what is? Maybe it's putting it on the website as a heading or something, but it's hard to see how putting it somewhere on the t-shirt is going to be seen as a source indicating use.
Yeah, and I agree. And so, yeah, so here are my thoughts on this, Ed. So I think context matters. I think as you and I have talked about over the years, and there's two ways to think of context, right? One is this a trademark use or not? As everyone has noted, if it's on the front of a shirt, you have an ornamentality argument. If it's on a hang tag or label, it's more likely to be considered a trademark use. But I think in addition to the I Heart DC case, I think maybe even Black Lives Matter, when someone applied to register that for t-shirts, they had tried to also put it on the label and they said that's not okay. And so I think one of the important things to think about too, when you think about context, is not just is it a trademark use or not, but the goods and services. So if we're talking about t-shirts or other kinds of expressive merchandise, right? Keychains, posters, stickers, when you're trying to register a common phrase, a political slogan, a pun, in that situation, you're more likely to get that refusal under the merely informational or expressive use kind of part of failure to function doctrine. And in my paper, that was a response to Alex Roberts' excellent trademark failure to function paper. I know that I cited at least one or two, I don't know if it was a case or the TMEP, which said that there are some situations where you can actually refuse on failure to function grounds under that merely informational part of failure to function doctrine, even without a specimen. And I think you're going to see that though primarily in these expressive merchandise cases, right? So to me, it's very different if you have an organization called Black Lives Matter or Make America Great Again. I think in that context, those phrases can be source identifying. But once you have individuals apply to register trademarks for these slogans for t-shirts, it's problematic. Sometimes these people have no connection whatsoever to the organization. And so I think one way to think about failure to function doctrine is that it's not just focused on empirical information about is this serving a source identifying function. It really is serving a kind of speech protective, pro-competition function by making sure that these phrases remain available for everyone to use and that no single entity or individual gets exclusive rights to them. So I think that's the way I think we should be thinking about this, not are using it in a trademark way. We shouldn't worry about consumer surveys that show some people associate this phrase with Make America Great Again with Donald Trump. Okay, fine, but that doesn't mean he should get exclusive rights for this phrase for t-shirts, right? Reagan, Bush used this phrase long before he did. And I just think it's wrong that he was trying to stop others from putting this phrase on T-shirts back when he was campaigning. Again, clearly he has secondary meaning in that context, but that's my concern going forward is that folks will register positive and critical slogans and then try to prevent other people from using them on shirts.
Well, I think, Lisa, that for an examining attorney who tries to come up with a failure to function refusal based on the concept that you just articulated. I mean, there's nothing in the statute, nothing that says that where do you draw the line as to what you think should be available and shouldn't be available? Whereas the examining attorney looks for some use on the internet to show that it's a common meme or on its face that it's informational. I think the T-shirt cases are kind of low-hanging fruit because the ornamentality requirement. I mean, what if the Trump Too Small was the name of a restaurant on a sign over the restaurant? Clearly a trademark use. What do you do with that?
Right. And that's why maybe we treat shirts and expressive merchandise differently than everything else, right? Because of the kind of First Amendment implications. And I think you made an excellent point, John, is that failure to function is not in the trademark statute, right? This is in the Trademark Manual of Examining Procedure. I think this is a great doctrine. I think Congress should embrace it and add it to the statute. And I know some folks aren't happy with it because a lot of applications have been refused recently after Tam and Brunetti on failure to function grounds. But again, now that the court's paying more attention to the free speech implications of a registration, especially we see this in Elster, I think that the court would approve of use of failure to function doctrine. I know that in the Brunetti's, the cases involving applications to register hate speech and scandalous speech, they were arguing that failure to function law is unconstitutional, right? And I think that law could survive scrutiny, but again, it's not in the text. So it would be interesting to see if that would matter to the court. The definition of a trademark, as you note, is how the government hangs their hook on the fact that a mark has to identify the source of goods and services. But again, if you can refuse registration, even when there is a source identifying function going on there, I could see that potentially being problematic for those who like this provision.
With respect to the ornamental failure to function, if I were Elster, I might argue that it has obtained secondary meaning, and I think that could overcome that. How has it gained secondary meaning? Through this litigation, right? And what are the relevant channels of trade? Well, it's us law professors who now know that if it says Trump Too Small, it comes from Elster, and we're going to buy it to hang it on the wall here at the law center.
You mean we're helping Elster even as we speak? Is that what you're saying?
I think that's right.
Speak, yeah, with every word we say, right? We all know Elster now. And as far as it's not a commonly used phrase, Trump too small. It lacks the verb, right? It doesn't say Trump is too small. It's more of a source indicator, arguably. But of course, now he's hoisted himself on his own petard because it is commonly used, at least in this community, right? Trump too small.
Yeah.
So I mean,
Sam, that's an excellent point. Compared to a lot of these other cases where someone tries to register a meme, when after 9/11, people tried to register "Let's Roll" and other, and people try to register trending phrases, you have this evidence that can be presented to the trademark office through a letter of protest, or the examiner can find it themselves online. Before Elster, I don't know that anyone was using this phrase "Trump too small," and so I know I personally only associate it with him. To be honest, I think the phrase is kind of lame, but so it's very different than a lot of the political slogans that we've seen in the past. So I think it should be refused registration on failure to function grounds if Section 2C is struck down. But I think there's a good argument that this isn't a widely used phrase, and so that would be a response to my argument.
I'll just point out that the name of our symposium is Section Too Small, so we're entirely different branding.
I don't know, that might be cringing, Ed. I hope there's no T-shirt involved.
I wonder if the sort of lack of enthusiasm on some perceived lack of enthusiasm on the First Amendment front might, in this case, have anything to do with this. At least to me, this seemed like a really bad vehicle for a political speech. I mean, typically you would imagine the person on the other side of some sort of political speech is not usually somebody who also themselves has 100 federal trademark registrations that are, many of which are entirely in the commercial space. So this is at least a muddied analysis here. I think in that it's not a different, a non-celebrity turned politician would pose a different matter to my mind.
Well, I thought that was a benefit for Elster because it showed the de facto viewpoint discrimination, that Trump has a lot of marks and they're complementary and those are allowed to be registered. So I kind of saw it the other way, but I don't know what others think.
I agree. I think it's beneficial because if you think about the litigants in the prior cases, I mean, Simon Tam and the Slants were highly sympathetic, which undoubtedly helped the argument, where Elster is just someone who makes t-shirts, not necessarily that sympathetic on his face, where then if you have all this evidence on the other side of Trump getting to register all of the happy talk for himself, I would have thought would have seemed to be a better case. Obviously, the Supreme Court disagreed.
Well, and again, Ed, I think that if you think about this from a First Amendment perspective, right, and whose speech is chilled, right? If he's denied the registration, that's just one person whose speech is chilled. But if he gets the registration, the speech of anyone else who wants to use this phrase or an identical or similar phrase could be chilled. And so, again, my hope is that the court is starting to see the light, right, that registrations, trademark rights can chill speech. And I don't know if in part this is, we see this discussion during the oral argument in Jack Daniel about this concern about someone enforcing trademark rights and political messages on the front of a shirt, right? A parody, for example, of one of the Republican or Democratic Party logos. And so, again, maybe I'm just an optimist and I have been called an optimist, but I actually think that this is a very speech protective approach here if the court ultimately says that a registration itself can chill speech. And so therefore, there's no First Amendment problem here by denying this registration.
Okay, so I think we haven't taken any audience questions yet. If I get a little help moving the mic around, be happy to hear from. Assuming we have some, there we go.
So this question, I think primarily for Sam, but I'd love to hear others' thoughts on it. And it's about the what you saw with regard to the registrations that Trump signed off on, right? And you could imagine them being in two subsets. And I'm wondering if you have a sense for how many of them are some sort of partnership and how many of them is Trump kind of allowing some sort of third party use. Because I think if we care about the dignitary harms, and maybe we don't, and maybe the dignitary harms shouldn't trump the First Amendment considerations, the former is, I think, consistent with allowing an individual to kind of curate their trademark use in a way that I think the government is trying to defend 2C, is kind of that right of publicity defense of 2C. And the latter, I think, would be better evidence of the harm you are suggesting we get in practice, which is to say, people allow all sorts of positive uses and sign off on them readily, but refuse to sign off on the criticisms.
Right. Well, the trademark, I only reviewed his registrations and the Trump organization registrations, and they were, they were positive, Trump elite, Trump Esquire, things like that. And then political slogans like make America great. I found some applications that were for Trump that had not registered yet, and some of them were critical. I presume he had not consented to those. The dignitary harm is troubling, I think, because I think we've long said in this country and the framers, that you can't, free speech trumps any dignitary harm from criticizing or making fun or ridiculing a political figure, right? I mean, that's at the heart of the First Amendment, the right to mock and criticize politicians. So I think it would be troubling if they wrote an opinion here that said the basis and the justification for this law is to protect a famous person's dignitary harm, personally.
Add to that, I mean, one of the problems with allowing other people to register a person's name without their consent is that once that registrant owns right to that name for these goods, they can actually stop the person with the name from using the mark with those goods and services. And so I think that in addition to other people. And so again, I think just, it's important to step back, with right of publicity law, right of privacy law, and then trademark law, right? It does prevent false endorsement. We've seen this in a number of different situations, right? The Vanna White case, right? In all the situations, right, there are going to be defenses that hopefully will apply. And so what I would love to see the Supreme Court do would be to actually say that it's not infringement to display a phrase or a person's name or a design on the front of a t-shirt, right? So I mean, that's my hope, is that they will just clarify this fact and also maybe in the opinion talk about some defenses that would apply if Elster or anyone else wanted to use Trump's name in any way. And so I think that, again, it's just so critical to distinguish between a free speech right to register something versus a free speech right to use someone's name in a lot of different contexts. And I think no one's saying that Elster shouldn't be able to use this phrase on the front of a shirt, on a label, in any other way. But again, once you allow someone to register it, they can stop everyone, including the person with that name, from using it in the same way, as a in a trademark way, and possibly in a non-trademark way, right? I mean, this, up before Jack Daniels, a lot of folks, Stacey Dogan, Mark Lemley were arguing there should be a trademark use requirement for infringement. Graham Dinwiddie, Mark Jennis said there shouldn't be. And then you just see the Sixth Circuit finding that there is a trademark use requirement, but it's criticized by Professor McCarthy and many other people. Most circuits don't accept a trademark use requirement. And so what that means is that you might have situations where use on the front of a shirt is infringing or is considered problematic. And to me, there's a big difference between putting Nike on the front of a shirt and putting a political message or criticism of someone. So again, I would really hope the court would kind of clarify for all of us what is and is not allowed under trademark law, or Congress for that matter.
Yeah, Congress will get right on that.
Well, or they should just adopt the fair use test that Christine Farley and I have proposed, right? I'll write my congressperson.
So I have a question as a non-famous person, but a person with a very unique last name that, as far as I know, is not shared by anybody else in the country other than my relatives. So I was doing some research on chatbots and AI uses, and you see where this is going since my last name is Aistars. What came up as I was doing this was this website. It's astars.ai if anyone wants to go to it and share it. And it is a chatbot. At Astars, we provide IP protected AI personality services, and goes on to talk about how they're going. It's a chatbot that lets you chat to like Snoop Dogg and Martha Stewart and all sorts of other people, but also presents this image that this is like a high quality ethical use of AI for entertainment services. And it's kind of a weird feeling, right? But also as somebody who works in this space and who has, represented clients in this space my entire career, who runs a clinic, that works for artists and entertainers, and who has a very unusual last name. So I wonder what the thoughts on how some of these topics kind of cross over in this non-famous person's non-disparaging but maybe confusing situation might be.
And also descriptive.
And it is descriptive, right? I mean, it's AI stars, but the way that it's shown is just Astars. It's not in any way broken out. So,
well, I mean, I think regular trademark law would just apply in this context, right? If someone, I mean, no, you're not famous, but perhaps you would be well known in the AI. It sounds like you have been writing in the space, and so if someone suggested that you were affiliated with this, falsely stated you were affiliated with this website, that would be actionable to me under trademark law, possibly other laws as well. So, I think think AI, all these new technologies might, raise new issues, and we might need new doctrines to deal with them. But I think that just the traditional trademark doctrines might apply if someone's falsely suggesting there's some sort of connection to you. But if it's just your last name, and a lot of people have the same last name, same first name. My understanding is I think there was some case involving Scarlett Johansson being Lisa AI. So, I mean, it's happening to all of us, right? Our names are being used and to do bad things. But I think unless, someone is falsely stating that you're affiliated with them, hopefully people will figure out that you have no connection to.
I think I agree with that, and just say it's not a new problem as someone with the last name that is a famous trademark. And there's even since Mark Schultz at Akron is the Goodyear professor of law, so maybe there's confusion there over the actual use, but I don't think it's not a new problem.
Supreme Court trademark case.
Yes, and that as well.
So I don't want to sound Pollyanna or whiny, but I think I'm going to be both. I want to connect a couple of comments that have been made, the comment that Jake made with this panel. I very much agreed when Jake said, the Supreme Court is interested in restricting what the government does by way of regulation, the administrative state, and doesn't, may not apply the First Amendment when it comes to, private enforcement of property rights. And that's what I want to be whiny about. Because, I think back to the dignitary harms and Lisa's example of Obama pajamas. I mean, I think Obama pajamas is what this clause is for. And it's not that it insults, that there's a message that insults Obama. It's insulting to be registered as a trademark, right? It's insulting. And I think that is what was going on in the disparagement clause as well. Whether a Native American tribe's name was used in an insulting way, just to be used as a mark is insulting, right? And there's a long history of using Native American tribes' names and other language as marks, that it's kind of free to appropriate for others as marks. And I think this kind of broader public policy is what's going on in the prohibition against flags and emblems. And there is some kind of public policy that isn't dilution or confusion going on in our agreement to protect or to not register geographical indications for wines and spirits, right? Non-confusing wines and spirits. And so I think that's all a very long history in trademark law. And I actually can cite things, unlike Gorsuch, to say that there's a very long history in doing this kind of public policy. And it has always been done in international treaty law that we've been a part of. And in Section 45, Congress states, the intent, our intent in writing this chapter is, and one of them is to effectuate our treaty obligations. So that's my comment. And also to respond to something that you mentioned, Sam, about, I don't know why the government didn't budge from its position. That's because it's the government, right? They don't get to turn on a dime and be strategic in their litigation. They need to continuously, consistently argue for the government benefits and the public forum. And I do think this all kind of fits into that idea. And the court has said, the statute didn't make trademark law. The statute made registrations. And you want a registration, fall in line with our public policy, or, choose another mark.
That's a great point. Can I ask one question? If it's insulting to be registered as a mark, do you forfeit that dignitary harm to some extent when you become president of the United States? Should there be some exception for famous politicians?
So I think that the legislative history, at least, shows that they weren't thinking about public people. They were thinking about presidents in particular. And that's why there's the reference to presidents, so that, even though you were technically a public figure under defamation law, that there's some dignity to the office of president that could be preserved, and not having a coffee named after you.
Yeah, there
Yeah,
had been.
and I can add to that too. In a sense, right? If someone picks a celebrity's name or a politician's name to be their trademark, they're free riding off the value in that mark and benefiting from it, and then claiming exclusive rights to it and stopping other people from using it. So, again, there's such an important difference between registration and use here. And it's been a joy talking with you all about these issues. I know that we're at the end of our time.
Thank you, Lisa. I appreciate that. So this has been a wonderful conversation. Great two panels so far. Ed, any final thoughts before we turn it over to lunch?
Nope, that sounds good. Thank you.
Okay, wonderful. Well, thanks to everybody so much. We're gonna turn this over to the lunch hour, and I'll come back. I hope you all still join us at 1:45 for our final panel of the day. Thank you all. We'll see you in an hour. Okay, thank you all so much. We're gonna get started with our final panel of the afternoon. Hopefully it is as interesting and exciting as the last two, and I think it really will be, because our final panel today is going to be what we're calling What's Next? And really the idea here is to take these kind of concepts that have been previewed in our first two panels about all these other areas of law like defamation and right of publicity and failure to function, all these things we've been talking about, and pushing this further and seeing what this case Elster and what the other cases we've been talking about today really mean for all these other areas and doctrines, and just letting us think a little more broadly and further and push the conversation. So I'm going to start by introducing all of our panelists today. We have three with us in the room, as well as Professor Tushnet in cyberspace. And so I'll introduce everybody, and then we'll get going with each person's presentations as we have been before. So to start with, Professor Rebecca Tushnet, who is joining us on the internet, is the inaugural Frank Stanton Professor of First Amendment Law at Harvard Law School. She clerked for Associate Justice David Souter and previously taught at NYU in Georgetown. Her work focuses on copyright, trademark, and advertising law. With Eric Goldman, she publishes a casebook on advertising and marketing law, and joined Jane Ginsburg, Jessica Littman, and Mary Kovlin's book, Trademark Casebook. She helped found the Organization for Transformative Works, a nonprofit dedicated to supporting and promoting fan works. And her blog, tushnet.blogspot.com, is one of the top intellectual property blogs. Her writings may be found at tushnet.com. On my right here, we're going to also have with us Professor Jasmine Abdel-Kalik. She's a professor at the University of Missouri, Kansas City School of Law, where her research and teaching interests include trademark, business torts, copyright, and contracts. Most recently, she has examined how intellectual property doctrine may re-entrench existing stereotypes and biases, as well as the intersect of intellectual property laws and protection of speech. Professor Abdel-Kalik has been honored to receive several teaching awards at UMKC, as well as recognition twice for her research with the Daniel E. Brenner Faculty Publishing Award. Prior to joining the faculty, Professor Abdel-Kalik was a practicing attorney in Chicago, Illinois, initially with Baker McKenzie and then with Freeborn and Peters. Raised in Florida, Professor Abdel-Kalik earned her BA from Cornell in '97 and her JD from Michigan in 2000. On my left over here, we have Professor Alexandra Roberts. She holds a joint appointment with the School of Law and the Department of Music within the College of Arts, Media, and Design at Northeastern University. She is a leading authority on intellectual property and social media. Her research focuses on federal trademark and false advertising law, particularly in cyberspace. She has written on influencer marketing, trademark use on social media, hashtags as trademark law's failure to function doctrine. She also writes on law and literature. In early 2023, she was awarded the Inta Lattice Memorial Award for her article, Poetics of Trademark Law. She joined Northeastern in 2022 from, most importantly, the University of New Hampshire Franklin Pierce School of Law. Previously, she served as executive director of our IP center here and holds a JD from Yale and a AM from Stanford and an AB from Dartmouth. And finally, certainly not least, is Michael Keyes here on our panel to my right. He's a trademark lawyer and, as many of you know, a consumer survey expert at Dorsey & Whitney in Seattle. Mike has represented a number of well-known clients in high-stakes trademark and advertising disputes throughout the country, including the likes of TikTok, Kraft Foods, Abercrombie & Fitch, and Hall of Fame MLB player George Brett. In addition to his extensive trial practice, Mike is also a consumer survey expert and has a master's degree in survey research and data analytics analysis. He regularly conducts, analyzes, writes about, and lectures on consumer survey research. His LinkedIn newsletter, Lanham Act Surveys for Lawyers, provides a unique blend of insight and perspective where Mike harnesses his knowledge of the law involving admissibility of survey evidence with his consumer survey expertise. And with that introduction of our wonderful panel, we're going to start it off today with Professor Tushnet. Rebecca, are you there and ready to join? Okay.
Yep.
Let's see. Yeah.
All right.
Go ahead.
So,
Yeah.
Yeah. So I had to teach this morning, so I couldn't be with you in person. I apologize for that. So I also organized my remarks in response to the oral arguments in Elster. I think I hope they won't be too repetitive. I too recognize the strong job done by the government's lawyer, including responding to questions that asked how copyright could be distinguished from trademark. The government was attempting to resurrect the argument that trademark registration is a government benefit, that is, denying someone of government benefit for their speech is different from a ban on their speech and can legitimately be content-based, even if it can't be viewpoint-based. Tam did seem to reject that argument, but some of the court already seemed to have buyer's remorse about that in Brunetti, recognizing that almost all of trademark law is content-based. If we're going to have a registration system at all, we need to make some content-based distinctions. And then the questions are there any limits on that other than viewpoint discrimination? So the justices asked multiple questions about copyright law, and I saw some unhappiness about that on social media, related to the fact that even experienced lawyers who don't practice intellectual property may easily conflate copyright and trademark. But I didn't hear ignorance in those questions. I heard justices that were seeking to write an opinion reversing the Federal Circuit in a way that was limited to trademark law and asking for guidance on how to do so. So if the government can bar registration of a trademark, including a disparaging reference to a person, unless that person consents, can it also bar you from a copyright registration if your work disparages a living person? The government's response was fine as far as it went. Copyright is a different regime with different traditions, but the government didn't explain why copyright was different, presumably because that would have started to sound like an unconstitutional conditions analysis, which the government didn't want to risk. The fact of the matter is that copyright is interested in incentivizing creative expression. Whether that expression is about a living person without their permission is irrelevant to copyright's purpose. If you just simply say there's no tradition of requiring consent of the people you're talking about in copyright, by contrast, you can't explain why or when you might draw analogies or recognize limits on what the regime can do. So consider, for example, whether Congress could enact a law denying trademark registration to entities in the business of producing pornography, or denying registration to marks that refer to pornography. Those are content-based, one is speaker-based. Are they in any way related to the purposes of trademark? Can you reverse Elster and still say, Congress don't do that? Of course, such bans on a category of registrations would actually harm consumer protection and business investment, and they would have to be understood as punishing a business that Congress disagrees with. And if you think that's okay for pornography, consider the same question about abortion, right? That would seem to raise serious unconstitutional conditions questions that the government benefit is being exercised basically to achieve objectives outside the government program. But the government's initial approach that it's advocating Elster would make it unproblematic because if it's not viewpoint-based, it's just content-based and we can stop any analysis there. Unfortunately, as signaled by the government's unwillingness to get deep into the reasoning, the court's choose your own adventure approach to history was very much on display in some other exchanges. So we've already mentioned that Justice Gorsuch said that there's a long historical tradition of the living person name, just as there is with geography. And I agree, that's just completely untethered to actual history. Of course, there was no substantive federal trademark law until the Lanham Act. The first attempt was struck down as unconstitutional. A tradition that's younger than my parents is not usually the kind of tradition that the court's current majority pays attention to. There's also no tradition of requiring consent for registration or use of marks that demean rather than impersonate, whether at the state level or otherwise. There's no tradition of treating the name of a person as equivalent to the secondary meaning required to generate rights in a name with respect to certain goods or services. The common law would not have understood the idea that Trump could have blocking rights in fields he wasn't exploiting, or rights against non-confusing uses even in fields he was exploiting. History seems to be wielded extremely selectively, even in relatively unpoliticized cases, which is perhaps a cautionary note about appeals to tradition generally. It is just unfortunate that a justice would conflate, I don't know about this with, there must be a tradition about this. So meanwhile, Elster is essentially arguing for a type of unconstitutional conditions analysis. Is this restriction related reasonably to the purpose of the government program? The government is seeking something like rational basis review. Elster says, no, you should focus on the benefit that's being handed out, and is this sufficiently related to the benefit that's being handed out? which raises the question, is protecting a person's dignity beyond potential confusion a reasonable basis for the government to act? And, the fact that they couldn't prohibit this, or at least that's the government's claim, might seem to cast that into some doubt. But maybe it's good enough if you're not going to stop the person from making the reference. And this has potential implications for the survival of the remaining not fully confusion-based bars that are sort of confusion adjacent, maybe overbroad, but there's some relevance to confusion. And in particular, the geographic indications and flag and insignia provisions are at issue. And we might see some interpretation of the flag provision in the pending Penn State case, which I'm going to talk about in a minute. I think the strongest argument for Elster is simply that protecting dignity against overt criticism is not reasonably related to the acceptable purposes of trademark law. It enacts the same sort of viewpoint-based tilt as in TAM, where praising groups was okay, but criticizing them was not. If that's viewpoint-based, seems like this should be, given the reality that giving a person a veto over uses is going to predictably lead to only positive uses. Now, I actually argued for the opposite result in TAM. So if TAM is wrongly decided, maybe this is, maybe it's okay, but we have TAM. So now we have to enter into what else counts as viewpoint discriminatory if the prohibition on disparagement is viewpoint discriminatory. So I want to transition to talking about implications for infringement. If the court insists that Elster has the right to use Trump too small on the front of t-shirts even without a registration, and that he couldn't be prohibited from doing so, even though there is a legitimate government interest in prohibiting source indicating uses of an unconsenting person's name, that suggests a more formalist version of what counts as trademark use. So consider, for example, this argument by the government. As long as Elster can use the expression, and as long as he can obtain the benefits of trademark registration by choosing a different source identifier to distinguish his goods from others, he has all he needs for his free speech. So the concept of source identifiers is very important. It has to be somewhat normative if we are actually going to preserve his ability to use the phrase Trump too small. But compare the court's now a few years back past decision in Booking.com, where the court seems to think that trademark has no normative components. It's all empirical about what is functioning as a trademark. So the limit case for this empirical approach is when trademark owners convince, say, 15% of consumers that any reference to them at all requires permission. And so there's at least a 43A violation if there's any unauthorized reference. The court seemed unwilling to deal with that scenario, which fits the facts of a number of the Rogers cases it distinguished in JDI. So everything here turns on what the court understands the concept of trademark and source identification to mean. If any use that causes any confusion about anything is actionable, then the court will be allowing huge amounts of speech suppression. But if it adheres to the idea that trademark source identifying use can be objectively identified and doesn't exist merely because there's some kind of confusion, that could point the way to a workable regime, and one that I would say would have room to protect free speech. My main worry here is that the justices have no interest in the fact that lower courts have routinely considered the existence of confusion about something, including about whether the trademark owner gave permission for an accused use, to be proof of trademark use. And you see this a little bit in the oral argument in Elster too. So Justice Jackson says, trademark is not about expression. Trademark is not about the First Amendment and people's ability to speak. Trademark is about source identifying and preventing consumer confusion. So of course, that has to be a normative concept of confusion. And it is also quite incoherent if you say trademark is not about expression. In fact, if something is confusing, it's because it sends a message, it communicates about source or sponsorship. It has to mean that trademark infringement is not about protected expression. And the question is, okay, then do you have a robust enough definition of trademark infringement to protect against any kind of confusion by any number of people being actionable to suppress speech? Also, if that's your view, it doesn't really explain what trademark registration is about. And this Professor Farley's discussion of our treaty commitments is quite interesting here, in part because there's another area of undecided constitutional law. We think we probably can't agree with other countries to get rid of the First Amendment, but the court has tried very hard not to resolve that question. Justice Jackson's indifference to expressive elements of trademarks also conflicts with the court's previous claims in Tam, and even Jack Daniels, that trademarks themselves often have lots of non-source indicating expressive meaning. Courts can't seem to figure out how to handle that duality. And you know, the recent cases that have involved the court pretending that trademarks are pure information sharing devices, unless they're also badges of honor. And I think at the Supreme Court level in particular, this is also related to the rapid and stunning about face in the political valence of commercial speech doctrine, which contributes to the court's unwillingness to say anything about whether trademarks are commercial speech, are often commercial speech, are only commercial speech, or something else. The pending Penn State University case may give us some insight on how a lower court is going to think about these trademark issues post JDI and post Abitron. So this involves bunches of uses on the front of a t-shirt or on a mug or a mouse pad of public domain images that say PSU on them. So they're, you know, images from the 30s, from the 40s, and they're sold under a distinct brand name that isn't Penn State. So the question is, what do we do about the front of the t-shirt? Is that source indicating? And there's some really interesting evidence in that case. Hopefully the judge will decide, you know, sometime in the near future, and we'll see if the concept of used to identify source and to guarantee quality, which the court has been assuming is what trademark is for, if that actually has the prospect of also limiting some of the expansions of trademark that haven't been about that at all. Now, and I want to make a related and final comment about some arguments that the government made. And so the Elster's best argument is, because of 2A and 2D, 2C's only function is to suppress things that the referenced party doesn't like. So in rebuttal, the government offers a set of examples that it asserts 2A and 2D wouldn't cover. If the LA Lakers describe their product as Jack Nicholson's favorite team, or the Chicago Bulls describe their product as Barack Obama's favorite team, or a restaurant in which a senator has had dinner uses the slogan Senator X ate here, none of those would really be excludable under 2A or 2D based on false suggestion, because they would imply a connection between the living individual and the product, but it would be a connection that actually existed. So first of all, I strongly doubt that the PTO would, I mean, if the PTO is refusing Trump too small under 2A or 2D, and we've all seen similar ones, right? The pooping greyhound being refused as 2A confusion as well as, dilution. That's that's sort of out of touch with actual practice. Again, not too surprising to have a Supreme Court advocate not fully cognizant of what happens on the ground. But I do want to say, if the court agreed that those statements were truthful and therefore could not cause a false association, that would be fantastic. Right now, many lawyers would readily find false endorsement, because even if the statements are true, the people at issue didn't agree to have the company promote those things. And that margin the materiality of that difference is not considered relevant in trademark cases, even though it absolutely would matter in false advertising. So, one of the hopeful paths would be to say, yes, this is all correct. Trademarks are source indicating devices. And when they're not doing that, or when somebody is telling you the truth about their relationship, then that's not a trademark issue. I can't say that I'm confident we'll see that day, but I think it's certainly a possibility for what comes next. Thank you.
Okay, thank you, Professor Tushnet. Up next, we are going to hear from Professor Abdel-Kalik while I get her slides. Just a moment.
Didn't the person who talked about it, didn't type my name.
That was, all right. Hello.
Hello, I don't have a cool title for my talk today. So I just titled it Section Too Small, What's Next? Because I think that's what we're all here to talk about. In the short run or in the long run, in whichever panel, it's really what happened and what's next. What I would like to start off with is just a reminder of a conundrum. And I think it's been referenced a few times today, but I'd like to push it a little further. And it's the whole notion that trademark registrations are challenged as a restriction on expressive First Amendment speech, when really we could say trademarks, whether it's use or registration, is a restriction on speech. Because when someone registers or uses a trademark and gets trademark rights, that precludes other people from using that same trademark on similar goods or complementary goods that would create a likelihood of confusion. And God forbid that they become a famous mark and your name happens to be McDonald's and you want to put a trademark for something. The whole notion that the justices are having difficulty with, I think, in part stems from not really dealing with this conundrum that we have for a long time globally recognized restrictions on speech as being necessary for the functioning of our economic drivers, our economic businesses, our economic motivations. And if that's the case, then maybe they're not really addressing free speech appropriately or thinking through free speech appropriately. That's kind of led me in another paper I'm not going to talk about now that is also still pending, to think about some of what we've seen in the Tam decision a little differently. And for what I'm going to talk about today, there's two themes to consider. What provisions are implicated for future concerns, and what can we learn from them in how they've been treated in the past, and what about merchandising? So starting with registrations that are implicated, we've all talked about Mattel a little bit today. We've talked about the Asian American rock band. I have a slightly different approach to thinking through the First Amendment on these issues, because it always struck me that when we are talking about racial slurs, when we are talking about identity disparaging terms, we're not talking about them being used in a vacuum or being used only by the trademark owner. What makes trademark unique is that the intent of the trademark owner is that other people will use their trademark to identify their product. And sometimes that means they'll use their trademark to identify the product by saying, I don't want this, or I don't want to be associated with something, rather, or even to just say, I would like to find. But if we're talking about someone who chooses to wear a Burberry coat or chooses to purchase something, they've made that choice. What about for the rest of the audience that doesn't want to make that choice? They don't want to be affiliated with a Washington football team or with some other monopolistic entity that has a trademark that they find offensive, and yet the only way to refer to that product is to use the trademark. And I call that captive speakers, captive audience. And so if you kind of think about Mattel from that position, we have a more complicated First Amendment analysis. First, in that we are giving them a right that would exclude others and therefore suppress speech. And second, that it actually is going to force the audience who wants to say, I do or don't want to engage with this band, to utilize the name. And that is the functionality of trademark. And that, I think, is where we're getting some of this conflict. Okay, so one of the other things that I think is really interesting about the Mattel case is what we see. Oh, one more thing about Tam. I just have to say, if you go to their Wikipedia page now, they're all about free speech. This is what they wanted to do. They're all about reclaiming this slur, and I get it, but that's not what their Wikipedia page said before all of this happened. I just want to point out that they said at first there was a whole bunch of other stuff. Then they narrowed it down to three things: that it was about their slant on life, that it's about a musical reference to kind of the slant guitar chords, and then the third is to reclaim. I just want to put that out there, that to me, that might suggest that there's some fortuitousness in the structure of the argument that they ultimately made about reclaiming, but I am not saying that for sure. I do not know. I just point that out. Okay. So the other thing that a lot of people have referenced is this language from the Mattel case from Justice Alito. We now hold that this provision violates the free speech clause of the First Amendment. It offends a bedrock First Amendment principle. Speech may not be banned on the ground it expresses ideas that offend. Not true, Justice Alito. That's a very broad statement. And we know that this statement is not true. I, being the contrarian that I am, as soon as I read this, I start listing them off. Obscenity, not even included in the First Amendment. Disparaging, something we've always said can get scrutiny, but it's still, it's a concept, it's a restriction that we allow. There's all these other areas where ideas that offend are in fact regulated. I mean, obscenity is such a clear one because it is completely excluded from First Amendment protection. So then we start thinking about what the court has said with disparaging trademarks. And one of the other reasons why the Mattel case, Mattel versus Tam, the Tam case, is so difficult for me is that the factual posture in which it was raised, number one, it wasn't the right case to have a full and wholesome conversation about racial slurs. I think the Washington football team case had a much more developed record, just going to put that out there. But even putting that aside, there is a whole component, a whole side to disparaging trademarks that nobody dealt with. And that is that there were a whole strain, a whole line of cases that talked about defamatory marks. In other words, marks that were disparaging because somebody else is taking your corporate trademark, your corporate name, and creating a new trademark to make fun of you, the pooping greyhound being the classic example. But it's not just the pooping greyhound as compared to, for example, the start of where we start to see identity issues, which is the Doughboy case in 1951. Doughboys were World War I soldiers' nickname. I'm going to admit, as a history major, I did not know that until I read the case. But now that I know, associating them with venereal diseases, the judge said was not good. So when it comes to the defamatory branch of disparaging trademarks, they use the restatement second of torts. They use the conversations that are long rooted in defamation and in thinking about what constitutes defamation, to think about an essential violation of one's right of privacy, the right to be left alone, and used that test in Greyhound. And that continued to be used for assessing this line of disparaging trademarks. Now, what that tells me is a couple things. Number one, the sex rod versus Red Sox conversation is apparently big enough that multiple speakers on this panel or on this day in the symposium are going to reference it. Maybe it's because it involves the Boston Red Sox, which is apparently not too far away. I also chose to not include another one that I could have included, which is the New York Yankees partnership versus Evil Empire, baseball's Evil Empire. They objected, the Yankees did. Of course, the problem is they called themselves that. So, is that really defamatory if you call yourself that? But I don't know how well Yankee dumb is received here, so I didn't include that. But those are examples that are more modern that demonstrate that long after we started talking about Tarjo and the Washington football team and racial slurs, we had another line that talked about defamatory focused issues and a different test that applied. What this also tells me is that we can do that without express language in the Lanham Act to consider it, right? So there's nothing in the disparaging prohibition in Section 2 that says disparaging, including things that are defamatory. There's nothing that directs us to defamation, but they created the test and they applied it by incorporating pre-existing law to protect right of privacy and to protect those interests. So I take that knowledge that that line existed and that the Supreme Court never saw it, never dealt with it, never considered it when they struck the disparaging prohibition. And I think about Section 2A falsely suggests a connection. you can see that, yes, there's a stronger argument that falsely suggested connection fits into our unfair competition concerns, fits into our deception concerns. But historically, under legislative history, under the Notre Dame case all the way back in 1983, it was considered as embracing concepts of the right to privacy, an area of law which, when this was drafted, was in an embryonic state. I think it's not embryonic anymore, even to the extent it ever was. But certainly we have a well-developed series of rules and laws and ways of thinking about privacy that not only take into account the dignitary interests, but also take into account First Amendment concerns. Thus, when we have defamation, we bring in, if it's a public figure, questions about whether there's actual malice. There is a way to balance the First Amendment and also take into account dignity concerns. And this would equally apply to Section 2.3 with respect to a living person without permission. The concern, as I'm sure Alex is going to talk more about, in a lot of the right of publicity cases from its very inception, is that some of these sports figures did not want to be associated with that particular good or service, and they should have the right to decide what their name would be associated with. And I think about, what if somebody decided to have Jasmine Abdel-Kalik boats as their trademark? And number one, why? Why? It's a really long trademark, dude. No one would be able to pronounce it. You'll have to tell them how. I mean, it's got issues. But if somebody decided to do that, what if I don't want to be associated with your boats, dude? What if your boats are, in my mind, as a raised Floridian, born North Carolinian, I don't like your boats. I like different boats. Don't I have the right to decide if I want to be associated with that? And or don't I have the right to decide if I don't want to be put into the commercial world, right? So we have these dignitary interests that we have considered in the past. The court didn't consider, it wasn't in front of them, but it shows how we can bring those interests into play and balance some First Amendment concerns. All right, so defamation, we know it exists, can balance those concerns. We even have some recognition of that in the Federal Circuit and in the ADCO Industries decision. Merchandising, is merchandising an issue? I think it actually is part of the issue. So merchandising started off, if you recall, from the National Hockey League saying, hey, retailer, you can't just come up with these patches that have the National Hockey League team's emblem on them that people could buy and then just put on their leather jackets and iron them on. That's a thing that we did in the 70s and 80s. Don't judge us. So they said, you can't just take those trademarks and make the trademark your product that you're selling. That's where we start to get merchandising. But note what's happening here is that they're not selling a separate good or service with that particular product. It's still implied, though, that the good or service is that the patch that you're selling. It is something. And it has led to a lot of conversations about T-shirts and other clothing. Notice that both the Elster case with Trump Too Small and the Brunetti case with Fakta. Fakakta? Can I just say Fakakta? Which is a different slur in a different language. So notice that both of those cases started with putting the slogan on the front of the T-shirt, which is what a lot of different panelists have talked about. And I suggest, of course, that that's part of the problem, is that our merchandising rules have gotten too expansive. I'm not the first, I won't be the last. Lots of trademark professors don't like the merchandising concept. I think when you're starting to talk about a good or service that has pre-existing goods or services, they already have something in the world, and this is a promotional item, it makes sense to say that this would be perceived as coming from Nike or coming from Lacoste or coming from Ralph Lauren with his little polos. But what happens when it's built by God or a-holes live forever? When we've got these messages, we see the TTAB and sometimes courts are starting to use failure to function. But again, as panelists have discussed, failure to function is problematic. I'm not sure exactly where it comes from. We have arguments about where it comes from. I'm not sure exactly what the scope of it is. It feels to me like part of it is trying to find a justification to avoid this, to avoid the expansion of merchandising so that you are controlling expressive conversations on the front of your shirt. Think about live, laugh, love. How many things are sold now in the store that say live, laugh, love? I can't stand it. I do want to live. I do laugh. I enjoy it's fine. You can love people. I don't need to say it, but people do want to say it on a variety of household goods. Should one company be able to monopolize that and say that that is their trademark and it's associated with that one company? I think that's where we're getting in this conflict between First Amendment expression and trademark law. It's the overexpansion of merchandising. And what I would suggest is it makes sense in situations where there's a pre-existing business that has already established their trademark otherwise, and it's clear that these are promotional items. Doesn't make so much sense when you're just trying to convey a message. And so that's what I leave you with. I hope I haven't taken too much time. Thanks.
Okay, and up next, we'll turn it over to Professor Alexandra Roberts.
Hi, I am so happy to be back here today. My love for this school runs very deep, so it brings me great joy and to talk about such a fun topic. So this is something a lot of folks have touched on today. I want to dig a little bit deeper when it comes to these right of publicity questions. Can we get this to click through? Can't even, this is not working. Okay. Slideshow? Because it's what?
I think you've got to pull it.
So can you go to slideshow? Usually it works when I do it.
I think we have to enable editing. Here you go.
Cool. All right. So we've been talking today about 2C. I think you know what 2C does. You know, no trademark by which the goods of the applicant may be distinguished from the goods of the other shall be refused registration on account of its nature unless, and then we get these different carve outs in section 2, right? So if it consists of or comprises a name, portrait, or signature identifying a particular living individual except by his written consent, right? That is, as we've discussed, the focus of this case. But we've also got 2A, and 2A overlaps so much of the time, right? When we teach this stuff, I teach this Bo ball case, Bo knows football, Bo knows baseball. Why don't I make a combo football, baseball and call it a Bo ball? Well, you can't do that. That violates both section 2A and section 2C, right? So this is matter that falsely suggests a connection with someone, right? So we could see how that Venn diagram goes. Usually we get both of those bases for refusal at the same time, but not always. And then we've got our section 2D, which we expect to see all the time. It creates a likelihood of confusion with somebody else's mark, right? So the court at oral arguments, this question came up, this question that has come up earlier today as well, which is 2C just superfluous? Do we really need 2C? Is it already covered by everything else elsewhere? And the government said, no, not exactly. There are some scenarios that 2A and 2D don't reach and 2C does reach, like if you want to call yourself the Derek Jeter of car salesmen, or as Professor Tushnet discussed, Obama's favorite team, Senator X8 here, truthful comments that are nonetheless violating 2C, right? Or the government said, and I'm kind of still furrowing my brow at this one, a use where consumers don't see endorsement. Consumers are not confused. They don't think there's a false association, but the individual doesn't like it. They don't like it. And 2C, and another interesting thing today is I think people have kind of framed this in terms of like a veto power, but it's not the individual vetoing the mark. It's the USPTO doing it on the individual's behalf, right? So we, the trademark examining attorney, are going to intuit that even though 2A and 2D don't apply here, this person still wouldn't like this mark. And they have the ability then, or we have the ability on their behalf to say no to it. So forgive my very sloppy Venn diagrams that I made at midnight. I'm doing the best I can. I'm just trying to illustrate that like these things will overlap a lot of the time. You might get 3, you might get 2, but there are going to be scenarios arguably in which only one of them applies. So we're serving some kind of purpose here, right? Okay, now I'm going to make a big jump and you'll see why in a minute. And I'm going to talk about false endorsement and right of publicity, right? So the trademark statute, the Lanham Act, which has also a false advertising cause of action, it includes a cause of action for false endorsement. So the use of someone's identity in connection with a product or service in a way that creates a false impression or a likelihood of confusion among consumers that the person endorses or approves of the product or service, right? So it's kind of a form of false advertising. And the confusion element is required. You do need to show that it's the consumer's point of view. They're getting the wrong idea about this celebrity endorsement, right? So we get cases like Michael Jordan, you know, these full page ads in the tribute to Michael Jordan where consumers would expect that. And often the bottom line is like, would consumers expect that this person got paid? Right? Not necessarily would they expect that he shops at Jewel Osco and he loves Jewel Osco, but would we expect that he got something out of this deal, this use of his name or of his likeness or his persona by reference to his shoes or his number or whatever, right? This is a Kendall Jenner, a photo of Kendall Jenner that was used to advertise this laser treatment that pretty clearly you would expect that she got paid, right? That she's endorsing this brand. Actually, in fact, she had nothing to do with this ad. She had no knowledge of this ad. It just popped up, right? So those are the kinds of cases where we see false endorsement. Then we've got rights of publicity. We know about rights of publicity. This is this patchwork, right? We've got a lot of state statutes. We've got state common law. They vary tremendously. So we've got some states with no posthumous rights. We've got states that protect up to 100 years after death. We've got some subset of things protected in one state and much broader set of things protected in another state. So we've got a big range. And again, a lot of overlap. So rights of publicity protect against the unauthorized commercial use of someone's name, image, or likeness. So we will often see those claims brought together, right? Federal false endorsement and state right of publicity violation. But sometimes right of publicity applies where false endorsement doesn't. I used to use this when I first started teaching. Madonna may have 10 platinum albums, but she's never had a Mitchell banana. All right, it's weird. There's no statement there that Madonna loves Mitchell bananas, that she endorses Mitchell bananas. It's just we put her face and her name on a billboard for some other thing, right? And then this fell into my lap, this much better example that I love. This is a tweet from Ryanair. So the look of a man who might not have access to Air Force One in the future and will have to fly commercial. Don't worry, Eric. We'll have low fares the next time that you're flying. This is Eric Trump, right? This is obviously like a news picture of him. This is not a traditional looking advertisement. There is no expectation that anybody would think that this is an endorsement, but it's still assuming that we believe that a tweet from a brand is an advertisement, which is a different conversation. It's a commercial use of his name and likeness without his permission, right? And then you get cases like Ariana Grande suing Forever 21, saying you cast a model who looks like me, you dressed her up using the looks from my video. So then again, if you know Ariana Grande and you know what her face looks like, you're not going to be confused. But there's a kind of creative argument here that it's still a violation of her right of publicity, a use of her persona under kind of the Vanna White line of cases without her permission, right? So, oh, and Bernie, of course, I think that people don't really expect that this is Bernie shilling for IKEA for money. So this photo went viral and IKEA stuck it in an ad for a folding chair and an oven glove. Lots of fun. So here again, sloppy Venn diagram. Hello. These two things overlap, but they aren't fully consumed by each other. You can have the one without the other. More often, we're going to see right of publicity without false endorsement because it is broader. So what? Okay. If the court applies strict or intermediate scrutiny, if Section 2C impinges on speech, then we need to have some kind of government interest, right? Substantial, compelling, important, whatever it is. The goals of trademark, as discussed repeatedly at oral arguments, we usually think about those as preventing consumer confusion or deception, and then also protecting distinctive devices that indicate source to the public, right? Section 2A and Section 2D serve those goals. The bars on disparaging and immoral marks didn't really serve them. Those got struck down. Section 2C doesn't serve them at all, right? It doesn't do those things. It does a third thing. And the third thing is it protects individuals' rights of publicity. So is that a substantial or compelling or important government interest, as opposed to maybe an important individual interest, an important individual dignitary privacy kind of interest for individuals to think about enforcing? Even if we say that there is that kind of government interest, is trademark law the right context? And is the USPTO the right entity to protect that interest? As you probably can tell, I'm not a good constitutional law scholar, so we could think more about how those questions map onto what's going on in this case, right? The Federal Circuit said the government has no valid publicity interest that could overcome First Amendment concerns about restricting political speech here. So the Federal Circuit paid attention to this question and said, if we're going to do a First Amendment analysis, we struck down these different provisions in Tam and Brunetti, and here we're trying to figure out what purpose Section 2C serves. And it's not a main identified goal of trademark law. It's something really different, right? Elster at oral arguments said, if the former President Trump were to bring a right of publicity action against my client, then that would fail on First Amendment grounds. And that's probably true for ornamental use on a shirt. Is it true when you have use as a mark and you have registration? I'm not so sure. Elster also said the government doesn't have a legitimate interest in facilitating the unconstitutional application of state law. So kind of making this point, so does the government have a whatever interest in protecting the right of publicity? If so, is Section 2C appropriately tailored in service of that interest? And as Professor Ernst raised, I think today, and also in his amicus brief, and some others have mentioned as well, Section 2C, which is about registrations, the registration part of the statute, it doesn't have these built-in mechanisms, these kind of safeties that state law incorporates, right? So right of publicity statutes and right of publicity case law usually have a really robust First Amendment carve out, or, give a lot of leeway when use is criticism or parody or other kinds of expressive uses, right? Political speech, artistic speech. So we make a lot of space for those. The USPTO doesn't have a mechanism to do that. It straight up says, if you're using somebody's name and you don't have their permission, then this bar must apply, right? On the other hand, applying to register a mark is an affirmative statement of commercial use, right? So this case that you can see an image from, this user applied to register 2 marks. One of them was a parody of the Yankees logo, and one of them was the phrase, the house that Juice built, which is a play, of course, on the house that Ruth built. So this case came up to the TTAB on a question about dilution, and the TTAB said, well, this is a really easy one. You don't get to pretend that this is a non-commercial parody use because you applied to register these marks. When you apply to register marks, you are announcing that you're making commercial use. Otherwise, you wouldn't have applied to register marks, right? This is what you're affirmatively representing to us. So you don't get the benefit of the defense. Listening to John Welch today and Professor Farley, it sounds like on the infringement question, there's a little bit of a mixed bag on what the TTAB does with that kind of parody defense, but I think, you know, most of the time it makes the same argument that it made in the Yankees case, which was when you have commercial use, you've kind of missed your chance to put on that defense that you would have put on and you would have won on if you were just making this use in the wild, right? So in other words, if the Yankees had sued the company that was selling shirts that said the house that Juice built with this really disparaging kind of parody use, they would have had a great First Amendment defense. But because they applied for registration, they threw it away, right? So, so that kind of complicates things a little bit here. I don't know which way it directs us. The TTAB has held that applying for registration undermines the parity defense. And I also think that the court in Bad Spaniels embraced that same logic, right? So we saw that emphasis on whether or not the use is use as a mark. Like others, I don't know that the Supreme Court made the right call on that specific question. It didn't really look so much like use as a mark, right? But that was their kind of like simple equation, was when you're using something as a trademark instead of an expressive, non-commercial way, then you don't get that First Amendment defense. You don't get access to it, right? So Professor Ernst in his amicus brief said 2C burdens speech that the right of publicity would not burden by denying registration without inquiring as to whether it constitutes political speech or social commentary. So what next? This is the what next panel. If the court upholds 2C, which I think all of us today have expressed our opinion that they seem very inclined to do, right? Are there implications for a federal right of publicity in holding that there's a government interest, not just a private interest in protecting individuals' right of publicity, right? Once you embrace that logic, if the court is to say, okay, it's not about preventing confusion, it's not about aiding the flow of commerce, it's about this other thing, which in fact is a compelling or a substantial or an important interest of the government, then maybe that takes us further down the path toward a federal right of publicity, which is something that many people have advocated for a long time, right? On the one hand, some say we don't need a right of publicity. It's covered elsewhere. We have Lanham Act false endorsement. We have arguments based on confusion. This is kind of too broad. On the other hand, these state laws exist. Litigating across them is really messy, especially in the age of online speech and advertising and representation that takes place or reaches every jurisdiction at the same time. So at least we know that a federal right of publicity would simplify things dramatically if we could kind of reach some middle point. I don't know how preemption would work, so it could stay messy. Okay, that's if the court upholds 2C. If the court strikes down 2C as unconstitutional, violating the First Amendment, then what happens? Well, the USPTO then is no longer in the business of prohibiting these registrations. So users who have trademarks and want to register them, and those trademarks incorporate the names of other people, then instead of the USPTO enforcing your rights in the sanctity of your name and your dignitary interest, you got to do it yourself. So I guess we might get more right of publicity litigation on that front at the intersection of kind of right of publicity and trademark use. And it might be that that takes us in the same direction, that might actually increase the likelihood of congressional response in the form of a federal right of publicity. So that's kind of where I wound up, but I'm interested in hearing everybody's thoughts.
Thank you, Professor Roberts. And as that helpful reminder is, please put your questions into the Q&A so we can get to them after our final talk, which is going to be by Mike Keys. So I'm going to stop this share and bring the next one up. And you're on to our final presentation of the day. Thank you, Michael.
Good afternoon, everybody. Let me, I'm going to start this at the, how do we get to the beginning of it, Peter? Where do I just go? There we go. Super. Okay, good afternoon. Great to be here with all of you, and thank you to Peter for the honor of the invitation. so this is the cleanup crew of the What's Next panel. My presentation is Will Bad Spaniel's new disclaimer get him out of the doghouse? So what are we talking about here? We're not talking about 2C. I'll skip my background here as Peter already mentioned it. So the question presented by my presentation is in the wake of the Jack Daniels decision by the US Supreme Court. Would a point of sale disclaimer potentially alleviate confusion in the marketplace between a senior user and an alleged parodist? And the backdrop for this is perfect because in the Jack Daniels case, as many of you may know, there was survey evidence that was produced at trial. It was a survey that was conducted by an old friend of mine, Dr. Jerry Ford, who was a great friend and mentor, a very accomplished survey researcher. And so he conducted an ever-ready study. Now, we do have the benefit of the bottle here. I'm going to point out a couple of aspects to it. Thank you, Peter. Point out a couple of aspects to it. So this is the original bottle and hang tag that Dr. Ford tested. Now note at the very bottom of the hang tag, it does have this disclaimer. This product is not affiliated with Jack Daniel Distillery. All right. So during the course of conducting the survey, Dr. Ford arrived at the criteria that would be necessary for respondents to qualify for the survey. So you had to be 21 years of age. You had to be likely to purchase a dog toy, I believe, in the next 6 months. And if you met those two criteria, you were shown this stimulus during the course of the survey. And you had to acknowledge that you could see and read the hang tag. So after they decided on who the appropriate population, the survey population was, a representative sample was chosen. 211 respondents participated in the survey, and the gender breakdown, 44% male, 56% female participated. Well, that helps. Thank you. Okay, now the questions that Dr. Ford asked are consistent with what's called the ever-ready survey format. So in an ever-ready survey, what we do is we go out and we essentially ask survey respondents 4 questions, and they're listed here on the screen. Who or what company makes or puts out this product? What other product or products are made or put out by this company? Do you believe this product is being made or put out with the approval of another company? And then do you believe that whoever makes or puts out this has a business affiliation or connection with another company? So if a survey respondent answered Jack Daniels in response to any one of those 4 questions, they were counted as confused. All right, let's look at Dr. Ford's results. So 62 out of 211 survey respondents answered Jack Daniels in response to one or more of those 4 ever-ready questions. So this nets a net confusion rate of approximately 29%. So 29% of the survey respondents were confused or deceived into believing that there was an affiliation or connection between Jack Daniels and Bad Spaniels. Now, the trial court, as you may recall, and I think it was mentioned on one of the earlier panels today, gave considerable weight to Dr. Ford's decision in rendering this decision on behalf of Jack Daniels. And we all know what happened. That was ultimately up to the Ninth Circuit a couple of times, ultimately up to the US Supreme Court, and is now back at the trial court. And I believe there's a status conference that's going to be held in a couple of weeks. Okay, so during the course or after that survey was completed, it appears as though Bad Spaniels ramped up its efforts to disclaim an affiliation or association or sponsorship with Jack Daniels. Now, how do we know that? Well, because the new hang tag that was issued now says Silly Squeakers parody dog toys, right? But let's look a little closer. What they did is they actually printed Dr. Ford's survey questions on the hang tag itself. So you can see here, it says, if you're doing a legal survey right now and you're reading this, don't worry. Here are the correct answers to the poorly worded questions designed to trick you into answering incorrectly. And so they go through, you can see I've highlighted some of them. What company makes or puts out this product? Correct answer, VIP products. and so on and so forth, right? So they go through, they list the 4 ever-ready questions that Dr. Ford posed to survey respondents, and then helpfully provide the correct answer on the hang tag. Now note at the very bottom, they note most important in all caps, bold. After each question, you will be asked, why do you say that? And the correct answer should be, because I'm smart. All right, so that's the new hang tag. Now, when we saw this, we thought, wow, what a great opportunity to test. Would it make a difference if consumers saw this hang tag compared to what the survey respondents saw initially? And would it dispel any sort of confusion or association in the minds of consumers? So recall that the original hang tag and bottle showed a 29% net confusion rate. So we were curious at Dorsey, at our survey research department, what would a survey yield if we showed survey respondents this modified hang tag? So what we did is we replicated Dr. Ford's survey in all material respects. In order to qualify for our survey, respondents had to be 21 years of age or older, and you had to likely purchase a dog toy within the foreseeable future. Now, Dr. Ford had 211 respondents. We had 216 respondents that qualified. Same gender breakdown, 44% male, 56 female. And just like Dr. Ford did, we acknowledged, or respondents, in order to qualify for the survey, had to acknowledge that they could read the hang tag. All right, so we set it up just as Dr. Ford did. It was just a number of years later. And the only modification that we made in any material respect was showing the hang tag along with the bottle, the modified hang tag, I should say. Okay. Now, we asked the identical questions. We asked those 4 ever-ready survey format questions. Who do you think makes or puts this out? So on and so forth. The same questions that Dr. Ford posed to survey respondents in his initial survey back in 2015. And our results. 71 out of 216 respondents still answered Jack Daniels in response to 1 or more of those 4 ever-ready questions. So this netted 33% confusion, slightly higher, not statistically significant, but directionally higher than Dr. Ford's. And the because I'm smart directive, anybody want to guess how many people responded I am smart as they should have? Well, out of the 216 respondents, 5 respondents responded because I'm smart as they were directed to do so. All right. Okay, so what does this tell us? Well, let me tell you a little bit more about, I'll break down the data a little bit more, because I think there's some pretty interesting things in here. So about half of the confused respondents from both surveys answered Jack Daniels in response to 2 or more of the questions that were posed, okay? In Dr. Ford's initial survey, 48% of the survey respondents answered Jack Daniels to 2 or more questions. In ours that we conducted, 38 out of 71, or approximately whatever that is hiding behind the screen there, it's 52 or 53%, I believe. Even better. Okay. Now let's look at, so in this regard, the results are fairly similar in terms of how survey respondents responded, at least to 2 or more questions. Help me out here, Peter. Oh, there we go. Okay. Now let's look at this. This is interesting. Now, on just the authorization or approval question, okay, this is with survey respondents that answered only with in response to the authorization or approval question. On the original survey, 23 out of 62 respondents, or 37%, believed Bad Spaniels needed Jack Daniels' approval or authorization. But then look at what we did in the follow-up survey. Our results are substantially different. Only 5 out of 71 respondents believed that Bad Spaniels needed Jack Daniels' approval or authorization. Now remember, the only thing that we did differently between the 2 studies is show the different hang tag. So we see about a 30% difference on that particular question. But on just the business affiliation question, on those survey respondents that answered Jack Daniels only in response to the business affiliation question, we saw big discrepancies, but the other way. The original survey, only 4 out of the 62 confused respondents, or 6%, believed there was a business affiliation or connection between the two. But then look at our results in the follow-up survey. 21 out of 71 respondents, or 30%, believed there was a business affiliation or connection between the two. So we have some rather disparate results between the two. So what explains the discrepancies? Hard to know for certain, but you could tell by looking at the verbatim responses in our follow-up survey that consumers were really keyed in on and articulated the visual similarities between the two. You see these, this is indicative of a lot of our survey respondents and how they responded. So on that question about the business affiliation, why do you say that? A lot of them just said, because they look alike. Okay, so what are the takeaways? All right, so the disclaimer appears to have significantly decreased the number of consumers that believe Bad Spaniels needed approval or authorization. Remember, 37 versus 7%, 30% differential, very significant. But the disclaimer also appears to have significantly increased the number of consumers that nevertheless believe there was a business affiliation or connection between the two companies. And then the net result was essentially the same. So even though consumers in the respective surveys answered the questions differently as to and provided a different basis for why they were confused, the net result at the end of the day is pretty much the same. Okay, so will this keep this modified hang tag that presumably Bad Spaniels came out with to disassociate itself with Jack Daniels? Will it keep it out of the doghouse? I mean, that's certainly above my pay grade. That's going to be for the court in Arizona or potentially the jury to ultimately make that determination. But I think there is a potential takeaway here for would-be parodists that, you think on one level that disclaimers may actually help disassociate me with the senior user. This shows us otherwise. Perhaps consumers didn't pay as much attention as you would like them to with respect to the disclaimer. Maybe this particular disclaimer is just too much. It's pretty significant. But on the other hand, we did see some fairly significant differences on that authorization question, 30% difference. So that certainly suggests that people were paying attention and that looked at it in such a significant amount to such a significant degree that it really did reduce that by 30%. So I don't know if this keeps Bad Spaniels out of the doghouse, but I think it tells an important lesson that disclaimers at the point of sale may not be all that they're cracked up to be. So thank you very much.
Hey, that was terrific. Thank you so much, Mike, and to all of our panelists. So now we have plenty of time for Q&A. Let me stop this share here. Okay, so why don't we start it off with an opening question that I would like to ask to all of our panelists, which I think brings in a lot of what was discussed earlier in the day as well, which this is a genuine question I don't know the answer to myself, and maybe put you on the spot a little bit. But so a lot of us have given this general consensus that 2C looks like it will probably be maintained and be found constitutional. Given that, or if that is the case, what do we want this opinion to look like? Would we be happy that this opinion goes broad and covers a lot of the doctrines that we've been talking about in this last panel of what's next? Are we a little trepidatious about how the court might go, especially the current constituency of the court, whoever we might feel about that? How do we want this court to rule? Would we look for something broad or narrow? And does any panelists have a thought on that?
I mean, I'm willing to say something. If basically just if you read JDI next to Abitron, next to booking.com. And frankly, even for the switches in tone between Tam and Brunetti, I don't think they really have much of an idea what they're doing. Like they have no idea about the interactions, the implications for the next case. And they're so I would want the narrowest possible opinion, but I don't know that they know how to write a narrow opinion. Because to know how to write a narrow opinion, you have to know what the next cases are likely to look like. Since they don't, I would just hope for some interpretive modesty. That's all.
Okay, so what? Yeah.
I don't have super strong feelings about it. One of the most fun things about doing trademark law is that these are not life or death cases. And so the stakes are like, we can enjoy this opinion no matter which way it goes. If you ask me what I personally would like to see, I am getting bored of the limited public forum, government speech kind of stuff. It feels like we covered it and we covered it and we covered it in Tam and Brunetti. So, so the reason that I focused on the right of publicity is because what was so interesting to me in this case, we saw a couple of cases in a row where a provision, a bar on registration was struck down related to the speech that it expresses. And then here, what's going on is something that that I have looked at for a long time as the little piece of the trademark law that is doing right of publicity. It's the government, it's the USPTO enforcing individuals' rights of publicity. So I think it's possible to get an opinion that basically doesn't address that at all. And I would love to see an opinion that spends some time on that issue and kind of explores what is trademark law supposed to be doing.
Thank you.
I guess I just hope there's more clarity in this case than there is the mathematical extraterritoriality case.
Okay, just looking back on some of our queue, just to get us go through questions. Jasmine, you have a question for you early on. Can you explain the difference between defamatory and disparaging analyses?
Yeah. Disparaging is the overarching objection that was in the Lanham Act until it was struck down constitutional, of course, in the Tam case. And to be disparaging, the TTAB and courts actually developed out two lines. One line really started with the Harjo case in terms of it being explicit, but had its roots all the way back to 1951. And it is when there's something that was considered negative towards a group, right? So whether it's, and most of the time, identity traits or something like that. But the other line was based in defamation law, used the restatement of torts and kind of that articulation of defamation law. And it was when a trademark that belonged to a particular entity was commercially defamed or defamed in a commercial way by essentially having a second trademark applicant that was making fun of or negatively commenting on the first entity by adopting and altering their trademark. Thus, the most famous one that we all referred to, one of the earliest ones, is the Greyhound case, where Greyhound said, "You are taking our symbol, the Greyhound dog, and you are having him on a shirt." And that is defamatory to our business. Now, you can have corporate defamation, but it also triggers commercial disparagement or trade libel, or there's like 17 names for that particular tort. And it really is all to this notion of kind of harming that individual business. That whole line existed, kept going on, but it wasn't ever addressed by the court. It wasn't brought up by any of the parties. So when they struck the disparaging provision, they struck that protection against defamatory trademarks without knowing. But I think that it does at least explain that when we're developing what the meaning is for each of these objections, we haven't in the past, and we probably won't in the future, limit ourselves to only the language of the statute. They develop out tests and they add in other concepts in order to strike the right balance. And I think they can do so again in the future. It is much easier for me to talk sitting down. I appreciate this.
Very good. How about our live audience? audience here. We have questions.
Thank you. A couple of questions for Michael. I found that really interesting. So it seems that premised in your conclusion is something fundamental, which is if you had shown those respondents that you surveyed the same hang tag, you would have yielded the same results. And I wonder if that's true. So we always see survey results coming in two different directions by both parties, but they're asking different questions with different stimuli. But I wonder if parties reproduce their survey evidence at all. You know, in scientific studies, you need reproducibility, but we don't demand this of surveys. So that's one question. And the second is, well, two more. The second is, you know, it's a really weird survey. Yeah, write it down, Michael. It's a really weird survey that asks the same questions that the survey respondents can read, you know, so that is hard to figure out how your survey respondents would process that. And then I would just love it, since you seem to have the resources to do these experimental surveys, I would love it if a follow-up question would be, and now can you tell me what that means to have authorized or to be an affiliated business or whatever the question that they answered, to see if they even understand what they're responding to or what they're saying yes to.
Thank you, Professor Farley. So your first question, if I understood it correctly, is why wouldn't we show the survey response both? Show them one and then the other?
Done the same survey that Ford did. Do we know we come out with the same response?
Why not help people? Oh, I see. So you're saying, why not just replicate Dr. Ford's survey and run it again?
Yeah.
Well, it's already done. So yeah, but I mean, from a survey standpoint, the only difference would be a logic was done in 2015. So you're right. I mean, I would concede that I don't know if it would be different right now. I was just doing compare what the results were prior. So there could be
a change over time. I just wonder how reproducible they are, whether we should draw as much meaning from the survey result that somebody got once.
Well, I think if a survey is done according to generally accepted principles, they are reliable. I think maybe your criticism is more in line with, well, if a survey wasn't done or if it was ginned up or if it was slanted or leaning or you know, in bias the respondents. But I think if a survey is done fairly and accurately, it's reliable. Your next question. Oh, it's a weird survey. You asked the same question 4 different times. You know, Correct. Well, but those questions, though, come from the Eveready survey format. They were only reproduced on the hang tag because Bad Spaniels saw Dr. Ford's survey and then put them on the hang tag. So those questions are tried and true. And if you look at the structure of it, it actually is fairly close to the wording in 43A. Sponsorship, approval, authorization. I mean, the language really comes from that portion of the statute. It actually comes from the Eveready case from the 1970s. And then you were saying, well, ask the follow-up question. Why didn't you ask the follow-up question? Well, we actually did say, why do you say that? We had a number of probes, but you're asking, well, could you define what you mean by authorization? And you could. I suspect you're going to get a variety of responses as to what people understand by authorization. But again, that language is in 43A. So that's where it comes from. I mean, so it's not my doing, it's not the Eveready format's doing, it's Congress's doing. Yes.
So here's my follow-up question. Coming from contracts, we know that there are lots of studies about how people don't read their contracts. The fine print is too small. They don't understand the legalese. Even if it's not legalese, they don't read it. It's too much work. Could that have been influencing this? In other words, the disclaimer doesn't work because it's too little and it's too much.
I think the data supports that to an extent, for sure. But the other interesting thing, which leads me to believe that people did read it, or at least a substantial number of respondents did read it and it did affect them, was on this authorization issue. Because there's such, again, back to the data, 37% of those that said there was an authorization or sponsorship, or excuse me, on the authorization question, 37% in Dr. Ford's survey thought that, but only 7%, if I've got my numbers correct. So, I mean, there was a pretty big disparity, pretty big difference there, which leads me to believe that, at least some of these respondents did read. But I would say there is a disconnect, though. I mentioned the 5 respondents that only said because I'm smart at the end. That would require a respondent to read, comprehend, and then follow a directive. So I think it's on that final piece, following the directive, which is where we saw a lot of fall off.
I have some follow-ups. More questions for you, Mike. This is such an interesting experiment but I'm not sure how much we can extrapolate from it. So first of all, the second survey kind of seemed to imply to me that people read the disclaimer but didn't believe it. Like they thought that it was Jack Daniels being cute, right? Like we're putting a note on this that explicitly says there's no authorization or business relationship. And then somebody asks you if there's a business relationship and you say yes. So I wonder how much of that stems from Jack Daniels's reputation, like what, whether it's the speaker and associations with the speaker, with the plaintiff, with the main brand, the brand that's being used in the parody, how much that's affecting perceptions. And then you asked the question at the end, like, what can we take away from this when it comes to point of sale disclaimers? And I'm skeptical that this is really a point of sale disclaimer. I bought my squeaky toy online. I bet a lot of other people bought it online. So, this is a broader question, but maybe you have thoughts about like whether disclaimers belong on online listings. Maybe there they can be more prominent. Maybe placement is as much of an important question as size and content. And then related to that, like when you have something that comes in a package that you keep the thing in, then you're stuck with the disclaimer forever, versus when you have a dog toy, the first thing you do is cut off all the tags because you don't want your dog to choke on the cardboard, right? So, so there must be a lot of different concerns in play about how to craft the disclaimer in order for it to be read and believed and accepted.
Yeah, really, really good points there. So I guess addressing the last one first, you're right. I mean, this isn't a point of sale. I mean, you see, this is how it's kind of attached here to the toy itself. I mean, I think of a point of sale being right there at the point of sale, right? Now, what we did do though, is we kind of replicated a point of sale scenario because we showed it to consumers or respondents rather, along with the dog toy, so they could see both. So it replicated the concept of point of sale. Your other point, though, I think is a good one, or your other question is a good one, which is the kind of the I guess the tension or maybe the inconsistencies between what the data shows on the question about authorization versus the question on is there a business affiliation. And that's what led me to believe that, look, the disclaimer at least carried some water here and did make it clear that people thought that there's not authorization, but nonetheless, because everything is so visually similar here, they still thought there had to be some sort of business affiliation.
So can I follow up on that? You said that you're taking the language from the Lanham Act. Of course, the Lanham Act neither says business affiliation nor defines that. Presumably, it actually has a meaning in the Lanham Act. That is, we don't usually say, oh, it's got whatever meaning people give to it about statutes. So I do wonder if you're not testing, are people saying business affiliation includes, well, this is obviously a reference to Jack Daniels, like it's about Jack Daniels. If that's how they're communicating, especially if you've managed to get a swing in like, approval, it sure seems like they're communicating, well, it's clearly about Jack Daniels. Why? Because it looks like Jack Daniels, right? So I think that's probably the source of the pushback that you're getting, is that we don't really know what they thought business affiliation means, especially if you've got this big swing in answers about actual control.
Can I stand up and answer it?
Your mic should be working out.
Oh, is it working? Well, I mean, I would certainly concede that this survey format is not designed to plumb the depths of what people's understanding or knowledge is with respect to authorization or approval. But at the same time, this is what we call an experimental design, test and control, with there only being one variation between the two. There's the test stimulus and the control stimulus. And clearly there is a difference as to how respondents answered that authorization question with respect to Dr. Ford's survey as opposed to how they answered it with respect to mine. Now, we know that the only difference between the two surveys was the different stimuli that they were shown. So we're seeing a large difference between those two, a 30% difference. Now, I can't tell you what individual respondents understood by authorization or approval, but what we can show is the data shows a very wide discrepancy between the two studies.
Right. So I agree. That's why I'm asking about where the affiliation because you say you get the same results, you get the same like net 43A language, but you don't. If business, at least if business affiliation could just mean it's a reference.
Yeah, I would concede that that's true, that we don't go through and ask people specifically to define it, but I'm not sure that that's the point of why consumer surveys are done in the first instance. Authorization to me is going to mean something that it means to Professor Linford, so I'm not sure that exercise is going to be fruitful in terms of trying to show, is there a collective definition that consumers understand that term to mean? I don't think that's the point or the purpose here.
It just strikes me that we're all agreeing with Bad Spaniel that these are poorly written questions. But these are the poorly written questions that are common and that are commonly used. And so take it for what it's worth in terms of also its impact on the court, because this is what the courts are going to see and this is what the courts are going to use, and it doesn't even work. It is I think how I might take it.
Well, I can't say that I agree with that. I mean, again, these questions have been, now you can certainly take pot shots at the questions and disagree with them and say that they're vague and ambiguous and we don't know what people mean when they provided an answer, yes, this was authorized. But again, this is a survey methodology that has been recognized across the country in terms of the appropriateness of the questions. Consumer surveys, I should say, are not a panacea. And I get the sense that everybody agrees with me on that. These are an imperfect measurement tool to try to get a glimpse into what's happening in the marketplace. Are they perfect? No, there's measurement errors. There's all sorts of problems associated with surveys. But when you replicate marketplace conditions to a reasonable degree and ask the questions that courts have approved of, these are what the results show.
Can I press you on this though? But you keep saying we aren't asking about authorization, but that's right, because your redo produced a massive decrease in the answer authorization, but an equally massive increase in business affiliation. And that's right. So I think we are actually much more willing to accept that an authorization answer indicates true confusion. But if you keep pivoting to authorization, you're ignoring the fact that you got a big shift in authorization. And so I think that's what we're reacting to.
Yeah, I'm here to just discuss what the data shows. I'm not here to advocate one way or the other. What I'm here to do is just reflect and discuss what the survey shows. To me, we did see that big disparity between those two answers. And why is that? I can't tell you. I don't think any of us sitting here have an answer to that. But at the end of the day, when you look at the follow-up questions that were asked, why do you say that? Why do you think there's a business affiliation? I can't say to a person, but just about everybody said because they look alike. And that's really I think the insight that we can glean as to consumer state of mind. Visual similarity.
I want to let Lisa Ramsey, she's got a question online, ask her question.
Hey, thank you. So my question is this for Mike Keys. Did you consider asking whether consumers thought Jack Daniel's was the source of the product or whether it was responsible for the quality of the product? Because I think it would be really helpful if people separated out those questions, because I think people would understand those questions a lot more than these questions that you asked.
Thank you for that. No, we don't ask that question in a survey of this sort. So, and let me explain that. So this is an Eveready survey, as I indicated. And when you're doing an Eveready survey, you don't show the consumer or the respondents the senior user's mark, because that would bias them. If you ask them, oh, is this, do you think this is made by Jack Daniel's or whatever?
If you could clarify, if you could say, who do you think is the source of this product might be another way to do that.
Well, I think that's what we try to do with that very first question. Who do you think makes or puts this out? So no, we typically don't, when it comes to doing an Eveready study, you don't show the senior user's mark because you're relying on the fact that that senior user's mark is typically top of mind and people will come to that association on their own without you suggesting that to them.
Yeah, just a quick question though. I didn't see that question here for the Jack Daniel's case about who do you think puts this out? Was that something that you asked them? Because I don't think it. Oh, what was the percentage for that one?
On both, it was fairly low. Just on that one, I want to say in mine that I did, it was like 7 or 8%, maybe 3 or 4% with in Dr. Ford's study. So,
I see. Yes. Again, I guess that would be my position. I think Christine, Farley, and I, we think that's what we should be focusing on is source confusion. And again, it thinks like with the Jack Daniel's focus on source confusion, maybe that's what surveys should be focused on in the future. I know the Lanham Act has this other language, but at least in cases that implicate First Amendment interests, perhaps we shouldn't be focusing on that other language.
I know we have about 10 minutes left. I want to get Professor Linford. Okay, do you want to? Okay. Well, I think you're good. Go ahead, Jerry. Well, I'll take a look at the queue while you.
So there's a meta question, and I don't want to spend all the time on surveys, but it is kind of a meta question that has to do with surveys, and it has to do with what we think the proper or the responsible scope of the inquiry is here, right? Where there is, I think, a broad-based presumption that I don't share, but I understand that surveys are kind of inherently suspect, that the questions are bad, or we can't get a sense for what the consumers or really mean when they answer the questions, or perhaps the statute's too broad. And so there's a general distrust of surveys. So we might replace that with some level of judicial inquiry that tries to duplicate what we think the reasonable consumer is. And I do have some suspicions about the ability of judges to imagine much beyond, my reasonable class in law school or my reasonable social club. And one of the reasons I say this is because one of the pushbacks I've got on the research that I have done is academic research in the United States tends to be weird. And the weird is an acronym, and I can't remember all 5 pieces of the acronym. But most US survey respondents, especially if you're doing an online study, they tend to be white and they tend to be highly educated. And especially the highly educated. And I remember having a conversation with Mike about this earlier. We tend not to control for education in these surveys, and presumptions we make about what the batch of us in this room might presume. I don't think that gets tested in academic studies or in these surveys for litigation. And I do worry, and I don't know which way this cuts, but I do worry that we tend to, and I think this problem would be replicated or exacerbated if we move to some kind of reasonable, objectively reasonable consumer, that we're going to kind of replicate this relatively highly educated we leave behind the relatively uneducated consumer. Now they're difficult and expensive to track because they don't respond to online surveys. You got to mail them stuff and you got to offer them money. So they're really expensive to study in these sorts of contexts, but I do worry about that. And to the extent we're trying to kind of get to a meta level where we are replacing consumer surveys with something else, I worry that we won't be making a replacement that captures the whole market. Maybe we don't want to capture the whole market, but I kind of think we do. So I'd love thoughts on that. Maybe there are
No, I mean, typically in my experience, when it comes to selecting who should be part of your population, unless you're looking for a highly specialized audience, you know, a group of lawyers or doctors or highly educated individuals, you know, we don't abstract at that level. You're really looking to identify who the potential consumers are of this product. If you're doing a nationwide survey, you typically do it based on the individual gender breakdowns at the 4 census regions across the country. So it's more general than that. But I think your point's a valid one. I mean, you're going to have different strata of society that may very well look at this differently.
And just to repeat the question for our audience, that was the difference between offline and online disclaimers.
I'm going to say something that is barely related to our topic today, but I am writing a false advertising paper and I'm looking at FDA in part. And one thing I've noticed is that where FDA has jurisdiction to regulate labels on a particular subset of products, they have started to say the things you put online in the place where you can buy the product is part of the labeling loosely defined. And so the reason that my brain jumped to that is, I think really broadly, we're seeing more acceptance from agencies, FDA, FTC, and also from courts that so much of where marketing happens and where labeling happens and where purchasing happens. And I'm even thinking of like the Molly Sims case, right? Like you wrote a blog post about a product and people could then click on the link and buy the product. So you made a trademark use. Like all of that action is happening online. So it would be really obtuse to say, no, the focus is on the physical product and what you attach to the physical product. So without making any predictions, I guess I'll say I see things moving in that direction, that kind of broad acknowledgement that that's where so much of the action is.
All right, thanks. So I want to talk about something different. I want to ask about surveys. And no, I'm just, no, I don't want to ask about surveys. So I want to talk about something Rebecca mentioned with respect to 2C, but think about it in terms of what both Alex and Jasmine were mentioning in terms of kind of the framework of thinking about the different rationales for trademark law. So we have sort of consumer confusion, we've got affiliation or false association, impairing the rights of the owner, and then depending on how this case turns out, maybe kind of the yes, yeah, right of publicity, right of publicity type harms if this is upheld. But what I'm wondering about is 2C with the flags. And because what I'm trying, there's really kind of two parts to the question is, one, what's the rationale for the ban on flags and insignia? And depending on what that rationale is, it doesn't seem to, and my guess is it has nothing to do with any of those of consumer confusion or false association or sort of dignitary type harms. And if that's the case, if that doesn't fit into any of those buckets, then is 2C next on the chopping block?
So I'm willing to take that. I've done a little work on this. And so the answer is actually, no, it's actually pretty much the same mix. Flags, to be flags is pretty much the same mix as 2C. That is, you see in the legislative history, a concern about the dignity of the state and how the state shouldn't be intermixed with commerce. In fact, even with its consent, which is something quite interesting. And then in subsequent cases, you've also seen courts say, you know what, not only is there a reason to preserve the dignity of the state, there's something worrisome if a state has trademark rights, which are really quite big. Right. So if the state is worried about impersonation, which, is a reason to keep non-state actors from getting insignia registrations. So that's definitely one defense of it, is that it avoids deception. But we also don't want the state to get access to trademark rights for insignia, because trademark rights are so broad they can be used to suppress criticism that we would otherwise say is clearly allowed. So the state needs to have an anti-impersonation rule that says, don't pretend to be a state actor, and that has a bunch of constraints on it, including like fraud, right, and a likelihood of material deception. Which means that, the person who puts on a police officer's costume in the school play is clearly not violating the law. And so, trademark's just the wrong thing for that. But it is a blanket prohibition, which means that the actual state or institution can't get a registration, which the city of Houston found out. And it also means that even if nobody knows that it's a flag, you can refuse it. My favorite version of this is Remax had one of its registrations, which was just the red, white, blue stripes, canceled because it turns out it's the flag of the Netherlands, despite putting in a survey in which not a single American surveyed said it was the flag of the Netherlands. Because, of course, we're Americans. How the hell would we know? So it is an absolute prohibition, and it's a little hard to justify that in the pure trademark purposes sense, but it actually is, adjacent in the same way, maybe more strongly so than personhood interests.
Ryan, you really were asking a survey question. You just didn't.
I think Rebecca covered everything. I just wanted to add one more piece, which is kind of like between deception and impersonation and state dignitary rights, there's this kind of like imprimatur idea. And Mike Mattioli has this new paper that I reviewed in Jotwell, where he looked at marks that include the word patented or the use of referencing the FDA or referencing the USPTO or the FTC, even where it's literally meaningless. And still somehow consumers are like, oh, well, that must be legitimate. So there's this add-on marketing effect that might also roll into that explanation, I think.
Can I just add one thing to that? Sorry. I just want to add one thing to that. And what makes all of this interesting is that many of these marks would have been precluded as scandalous when you're associating the government with marketing, when you're associating there are older cases that talk specifically about that. And again, none of it addressed with respect to whether or not that's appropriate or inappropriate by the Supreme Court decision. Same thing with religion too.
Okay, and I have one, I think, time for last question here. I want to ask from Lisa Ramsey for the entire panel. Which really broadens this out as a good last question. Since the court in Jack Daniels said that the primary goal of trademark law is preventing source confusion and focused on the source identifying function of marks, and some mentioned these goals during oral arguments, could this suggest that dilution laws or other laws regulating non-misleading speech are less likely to survive constitutional scrutiny? Does anybody want to take that?
God, I hope so.
That'd be my answer too.
Sure. The problem with dilution has always been, what are we protecting? Is this just an add-on for corporations to be able to have even more property rights than anyone else if they're super famous? I mean, when it comes to blurring, there's a different argument maybe than when it comes to tarnishment. I've always been confused because I'm not sure how you can tarnish without having some blurring as well, because you still have to have that association. You're still going to have the potential blurring, but regardless, Tarnishment is definitely, I think, up on the chopping block, as we've seen from other panelists, because we're talking specifically other panelists, Jake, because we're seeing them talking specifically in language that sounds very reminiscent to what the court was addressing in Tam and Brunetti. Blurring, I just don't know what it does. I don't, it's not about unfair competition. It's not about protecting against consumer confusion. It's about creating unfair competition. I don't know. I mean, I just don't know what benefit it has. I've had someone tell me that blurring is a dead doctrine, that no one really uses it. I don't think that's true. I think it's used a lot in cease and desist letters and in trademark bullying. And so I'm not really sure if the benefit is worth the behind the scenes, backroom harms that it's causing, to the extent there's a benefit.
I think we have one final thought on that from Professor Roberts.
Cool. I'm just going to tie it back into Elster. And of course, I also would love to see that kind of attention applied to dilution. But even though at oral arguments in Elster, we kept hearing explicitly that focus on confusion and deception, we also kept getting these kind of threads of propertization, right? If it doesn't confuse and it's not false endorsement, but the individual just doesn't like it. We have recognized historically from time immemorial, the right of the individual to control the use of their own name, right? And so my fear would be that if that makes it into the opinion, that kind of propertization treatment of a trademark as property has always felt like what bolsters the dilution right, the anti-dilution right.
Okay, and with that, I think we are going to call a close to this symposium. Thanks again to all of our panelists today, both in person and online. Thanks to the Franklin Pierce Center for Intellectual Property and the University of New Hampshire Franklin Pierce School of Law for all their support of this. It has been a terrific afternoon, and thank you all for coming and attending. We will be posting this recording and sending it out to everybody on the Zoom, so fear not, you will receive a copy of the recording. Okay, thank you all so much.
Thank you. Great job, Peter. Great job.
All right.